Senate will now come to order. Before we do the recall, I am going to take a moment to introduce someone who, the roll call, something's on our minds, to acknowledge someone who is joining us today whose name used to be on the roll call, but is no longer, and that is former Representative and Senator Matt Jones, now Commissioner Matt Jones. Thank you for joining us. Mr. Carpenter, please call the roll.
Senators Bridges, Cook, Coram, Crowder, Danielson, Donovan, Finberg, Fields, Foote, Gardner, Janal, Gonzalez, Hill, Heisey, Holbert, Lee, Lundeen, Marble, Moreno, Pedersen, Priola, Rankin, Rodriguez, Scott,
Excused. Here he is.
Scott, Smallwood, Sonnenberg, Story, Tate, Todd,
Excused.
Williams, Winter, Woodward, Zenzinger, President Garcia. Madam President.
Here. With 34 present, 0 absent, 1 excused, we have a quorum adopted. Senator Gonzalez, please lead us in the Pledge of Allegiance.
Thank you, Madam President. Colleagues, guests, I invite you to join me in the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Motion to adopt the journal, Senator Danielson.
Thank you, Madam President Pro Tem. I move that the reading of the Journal of Friday, March 8th, 2019 be dispensed with and that the journal be approved as corrected by the Secretary.
You've heard the motion. Are there objections? Seeing none, the motion is approved. Senate Services, introduction of bills. Mr. Carpenter. Senate Services.
Correctly printed, Senate Bill 189, 191, 191, correctly engrossed, Senate Bill 141, 151, 152, Supreme Resolution 4, correctly engrossed, Senate Bill 77, correctly revised, House Bill 1083 and 1148, correctly enrolled, Senate Bill 35, 46, 49, 68, 105, and 128.
Introduction of bills.
Senate Bill 192 by Senators Winter and Priola and Representative Jackson concerning the creation of an enterprise that is exempt from the requirements of Section 20 of Article 10 of the State Constitution to administer a fee-based waste diversion grant program.
Local government. Third readings consent calendar. Mr. Carpenter, please read the titles to the bills on the consent calendar.
Senate Bill 141 by Senator Donovan, Representative Roberts, concerning the authority to create an entertainment district in connection therewith, authorizing an entertainment district within the county or city and county, and permitting an optional premises be included in an entertainment district. Senate Bill 152 by Senator Williams, Representatives Duran and Arndt, concerning the continuation of the Public Safety Communications Subcommittee in connection therewith, implementing the recommendations contained in the 2018 Sunset Report by the Department of Regulatory Agencies. Senate Bill 151 by Senator Bridges and Representative Exum, concerning the continuation of the Emergency Planning Subcommittee in connection therewith, implementing the recommendations contained in the 2018 Sunset Report by the Department of Regulatory Agencies.
Mr. Majority Leader.
Thank you, Madam President. I move the passage of the bills on the third reading of bills consent calendar, which includes Senate Bill 141, Senate Bill 152, and Senate Bill 151.
Are there any discussions on any of the bills on the consent calendar? Seeing none, are there any no votes of any of the bills on the consent calendar? Seeing none, the consent calendar, third reading bills, no. Oh, excuse me. With a vote of 34 ayes, 1 excused, 0 noes, 1 excused, the consent calendar third reading is adopted. now we, okay. Those adopted are Senate Bill 141, Senate Bill with 34 ayes, 0 no, and 1 excused. Senate Bill 141 is adopted. Senate Bill 1, co-sponsors. I'll get it. Co-sponsors on Senate Bill 141. Senator Tate. Oh, Senator Priola, Senator Woodward. I'm giving you lots of time, folks. Senator Lundin. All right. Now, Cindy. Senate Bill 152. With a vote of 34 ayes, 0 noes, 0 absent, and 1 excuse, is adopted. Co-sponsors. Senator Tate. I feel like an auctioneer. Are there others? All right. Senate Bill 151 is adopted with a vote of 34 ayes, 0 noes, 0 absent, and 1 excused. Senate Bill 151 is adopted. Co-sponsors. Senator Tate. Senator Crowder. Okay, now we go to second reading of bills consent calendar. Senator Rodriguez.
Thank you, Mr. President. I move the Senate resolve itself in the Committee of the Whole for consideration of general orders, second reading of bills consent calendar.
Excuse me, did you say Mr. President?
Sorry. Blame the script.
Thank you, Senator Rodriguez. Please continue.
Gladly pay. Thank you, Madam President. I move the Senate resolve itself into the Committee of the Whole for consideration of general orders, second reading of bills consent calendar.
You have heard the motion. All those in favor, please say aye. Aye. All those no. The motion is adopted. The Senate will resolve itself into the Committee of the Whole for consideration of general orders, second reading of bills consent calendar. Senator Rodriguez will chair.
The committee will come to order and the court rule is relaxed. Will the clerk please read the title of all bills on the general orders, second reading of bills consent calendar?
House Bill 1137 by Representatives Wilson and Valdez D. and Senator Priola concerning supporting high school students' interest in early childhood education through the Teacher Cadet Program. Senate Bill 168 by Senators Lee and Gardner and Representatives Weissman and Herod concerning implementation of recommendations of the Committee on Legal Services in connection with legislative review of rules of state agencies. Senate Bill 148 by Senators Heisey and Sonnenberg and Representatives Valdez D. and Cadlin concerning the continuation of the Seed Potato Advisory Committee in connection therewith, implementing the recommendations contained in the 2018 Census Report by the Department of Regulatory Agencies. Senate Bill 147 by Senators Heisey and Sonnenberg and Representatives Valdez D. and Cadlin concerning the continuation of the Seed Potato Act in connection therewith, implementing the recommendations contained in the 2018 Census Report by the Department of Regulatory Agencies.
Majority Leader Fenberg.
Thank you, Mr. Chair. I move for the adoption of all the bills on the consent calendar and their associated committee reports, which includes House Bill 1137, Senate Bill 168, along with the Legal Services Committee report, Senate Bill 148, and Senate Bill 147.
Is there any discussion on any of the committee reports on the consent calendar? The motion before the body is the adoption of all the committee reports on the general orders, second reading of bills consent calendar. All those in favor say aye. Aye. Opposed, no. The ayes have it and the committee reports are adopted. Is there any discussion on any of the bills on consent calendar? The motion before the body is the adoption of all bills on the general orders, second reading of bills consent calendar. All those in favor say aye. Aye. Opposed, no. The ayes have it and the bills are adopted. Majority Leader Fenberg.
Thank you, Mr. Chair. I move the committee rise and report.
The motion is for the committee to rise and report. All those in favor say aye. Aye. Opposed, no. The ayes have it, and the motion is adopted. The committee will rise and report.
The Senate will come to order. Senator Rodriguez.
Thank you, Mr. President. The committee has a number of bills under consideration. Will the clerk please read the report?
Mr. President, your committee will place the reports out in consideration of the following tax bills being second thereof. Makes the following recommendation on Senate Bill 168 as amended, Senate Bill 148, Senate Bill 147. Pass second read order, gross place on counter for the reading and final passage. House Bill 1137. Pass second read order, revised place counter for the reading and final passage.
Senator Rodriguez.
Thank you, Mr. President. I move the report.
The motion is for the adoption of the committee of the whole report. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, the committee of the whole report is adopted. Senate Bill 168 as amended, Senate Bill 148, Senate Bill 147 passed on second reading in order engrossed and placed on the calendar for third reading and final passage. House Bill 1137 passed on second reading in order revised and placed on the calendar for third reading and final passage. General orders, second reading of bills. Senator Rodriguez.
Thank you, Mr. President. I move the Senate resolve itself into the committee of the whole for consideration of general orders, second reading of bills.
You have heard the motion. All those in favor say aye. All those opposed, no. The motion is adopted, and the Senate will resolve itself into the committee of the whole for consideration as general orders, second reading of bills, and Senator Rodriguez will take the chair.
Hold on, where am I? The committee will come to order and the court rule is relaxed. Will the clerk please read bill titles to Senate Bill 191137? Oh wait, 191172. Sorry.
House Bill 1172 by Representative Weissman and Senators Gardner and Cook, concerning an organizational recodification of Title 12 of the Colorado Revised Statutes in connection with limiting substantive changes to those that conform similar provisions to achieve uniformity, eliminate redundancy, or allow for the consolidation of common provisions, and eliminate provisions that are archaic or obsolete.
Senator Gardner.
Thank you, Mr. Chairman. I move House Bill 1172, which is the Title 12 recodification and reorganization. Recodifies Title 12 of the CRS and makes a variety of technical changes. I'm sure you've all read the 2,000 pages of this bill and are ready to vote on it.
Senator Cook.
Thank you, Mr. Chair. I also move House Bill 1172 and ask that it be read at length.
Is there any further discussion? Seeing none, the motion is... Oh, sorry. So can I go take a nap?
House Bill 1172 by Representative Weissman and Senators Gardner and Cook, concerning the organizational recodification of Title 12 of the Colorado Revised Statutes and in connection therewith, limiting substantive changes to those that conform to similar provisions to achieve uniformity, eliminate redundancy, or allow for the consolidation of common provisions, or that eliminate provisions that are archaic or obsolete. Community Legal Services Title 12 of the Colorado Revised Statutes relates primarily to the regulation of professions and occupation. 2016 General Assembly enacted the Senate Bill 16163, which authorized a multi-year project to recodify Title 12. In 2017-2018, the General Assembly enacted numerous bills to relocate two other titles. All laws that do not relate to the regulation of professions and occupations. Title 12 now generally contains laws administered by the Department of Regulatory Agencies or the regulated profession or occupation. Section 1 starting on page 4. The bill recodifies Title 12 is contemplated by the Senate Bill 16163 by reorganization and renumbering articles and parts within the Title 12 of all which are administered by the Division of Real Estate, the Division of Conservation, and the Division of Professions and Occupation, DPO, with DORA, relocating into Title 12 current statutes and Article 34, the Title 24 relating into the creation, powers, and duties of DPO and administering the laws, regulations, professions, occupations, practice acts, creating common provisions that are generally applicable to all practices, acts administered by DPO, expected as otherwise specified, and modifying the various practices acts to eliminate redundancies with the common provisions and eliminating provisions in Title 12 that are archaic or obsolete. Article 1 of the recodified Titles 12, page 4, contains provisions that apply to the entire title. Article 10, page 5, includes the laws governing real estates, including the divisions of real estate with the DORA, while Article 15, page 181, includes laws governing conservation easements, including the division of conservation within DORA. The remainder of the title relates to professions and occupations regulated by the DPO within DORA. Article 20, page 202, includes laws relocated from Title 24 relating to the creation of DPO and DPO's powers and duties and consolidated common provisions derived from the practice acts that relate to procedures, immunity, disciplinary and enforcement authority, and judicial reviews of final orders of DPO and regulatory boards within DPO. Articles 30, page 251, includes common provisions governing healthcare professionals and occupations related by DPO, including the Michael Skonlik Medical Transparency Act of 2010, healthcare workforce data collection requirements, and opioid prescribing limitations. The bill organizes the practice acts as follows: business, professions, and occupations. Article 100, accounts, page 311. Articles 105, barbers and cosmetologists, page 358. Articles 110, combative ports, page 379. Article 115, electricians, page 398. Article 120, engineers, surveyors, and architects, page 445. Article 125, fantasy contests, page 528. Article 130, landscape architects, page 537. Article 135, mortuaries and crematories, page 560. Article 140, non-transplant tissue banks, page 597. Article 145, outfitters and guides, page 603. Article 150, passenger tramways, page 621. This law was relocated from Title 25. Article 155, plumbers, page 638. And Article 160, private investigators, page 679. Healthcare professions and occupations, Article 200. Acupuncturists, page 699. Article 205, athletic trainers, page 722. Article 210, audiologists, page 743. Article 215, chiropractors, page 763. Article 220, dentists and dental hygienists, page 808. Article 225, direct entry midwives, page 887. Article 230, hearing aid providers, page 914. Article 235, massage therapists, page 928. Article 240, medical practice, page 953. Article 245, mental health, page 1041. Article 250, naturopathic doctors, page 1170. Article 255, nurses, page 1206. Article 260, nurses' aides, page 1281. Article 265, nursing home administrators, page 1307. Article 270, occupational therapists and occupational therapy assistants, page 1334. Article 275, optometrists, page 1364. Article 280, pharmacists for pharmacy businesses and pharmaceuticals, page 1407. Article 285, physical therapists and physical therapist assistants, page 1524. Article 290, podiatrists, page 1592. Article 295, psychiatric technicians, page 1639. Article 300, respiratory therapists, page 1653. Article 305, speech language pathologists, page 1675. Article 310, surgical assistants and surgical technologists, page 1703. And Article 315, veterinarians, page 1720. Section 2, page 1763, relocates the law that prohibits the mandatory donation of services from Title 12 to the Administrative Organization Act of 1968. In Title 24, Section 3, page 1764, repeals relocated provisions from Titles 24 and 25 to give agencies time to make necessary adjustments to their rules and forms. Section 265, page 1925, delays the effective date of the bill until October 1st, 2019. Section 4 through 264, page 1764, contains conforming amendments that are necessitated by recodification of Title 12 to the sections of the Colorado Revised Statutes that are codified in other titles. Comparative tables show how all sections of the Colorado Revised Statutes of the bill have been relocated or repealed or attached to the bill. Page 1926, being enacted by the General Assembly of the State of Colorado, Section 1 of Colorado Revised Statutes repeal and reenact with amendment relocated provisions. Title 12 as allows. Title 12, Article 1, General Provisions 12.1.101, short title. The short title of 12 is the Professions and Occupations Act 12.1.102. Scope of article. This Article 1 applies to every article in this Title 12 except to the extent otherwise specified by in another article of this Title 12. 12.1.103, definitions as used in this Title 12 unless The context otherwise requires. 1. Department means the Department of Regulatory Agencies created in Section 24(1)(1)22. Executive Director means the Executive Director of the Department or the Executive Director designee. Profession or occupation, profession or qualified appraiser in accordance with the uniform standards of professional appraisal practice. And 3. Complies with the requirements of the Section B. Landowner has the burden of proof regarding compliance with all applicable laws, rules, and regulations. 3. For the purpose of reviewing applications and making determinations regarding the issuance of tax credit certificates, including the dollar amount of tax credit certificates to be issued. A. Division staff shall review each application and advise and make recommendations to the Director of the Commission regarding the application. B. The Director has authority and responsibility to determine the credibility of the appraisal. And determining credibility, the Director shall consider, at a minimum, compliance with the following requirements. 1. The appraisal for the conservation easement donation for which a tax credit is claimed pursuant to Section 3922(5)(22 is a qualified appraisal from a qualified appraiser as defined in Section 170F of the Federal Internal Revenue Code of 1986 as amended, and any federal regulations promulgated in connection with such that Section 2, the appraisal conforms with the uniform standards of professional appraisal practice promulgated by the Appraisal Standards Board, the Appraisal Foundation, and any other provisions of the law. 3. The appraiser holds a valid license as a certified general appraiser in accordance with Part Strike 7 Unstrike 6 of this Strike this Article 61 Unstrike Article 10 of this Title 12, and 4. The appraiser meets any education and experience requirements established by the Board of Real Estate Appraisers in accordance with Section Strike 12617041K Unstrike 12106041K. C. The Director has the authority and responsibility to determine the compliance with the requirements of Section Strike 12611104 and Strike 1215-104. D. The Commission has the authority and responsibility to determine whether a conservation easement donation for which a tax credit is claimed pursuant to Section 3922(5)(22 is a qualified conservation contribution as defined in Section 170H of the Federal Internal Revenue Code of 1986 as amended, and any federal regulation promulgated in connection with strike such, unstrike that section. 4. The Department of Revenue is not authorized to disallow a conservation easement tax credit based on any requirements that are under the jurisdiction of the Division of the Director or the Commission pursuant to this Section 5. A complete tax credit certificate application must be made by the landowner to the Division and must include a copy of the final conservation easement appraisal, b. a copy of the recorded deed granting the conservation easement, c. documentation supporting the conservation purpose of the easement, d. any information or documentation the Director of the Commission deems necessary to make final determination regarding the application, and E. the fee required pursuant to subsection 6 of this section. 6. Landowner submitting an application for a tax credit certificate pursuant to this section or an application for an optional preliminary advisory opinion pursuant to subsection 14 of this section shall pay the Division a fee as prescribed by the Division. The application fee for an optional preliminary advisory opinion may be a different dollar amount than the application fee for a tax credit certificate. The fees must be adequate to pay for the administrative costs of the Division of the Commission in administering the requirements of this section, but not so high as to act as disincentive to the creation of the conservation easements in the state. State Treasurer shall credit the fees collected pursuant to this subsection 6 Conservation Cash Fund created in section unstrike 12611107 1215-107 on or before January 1st, 2014, and on or before each January 1 thereafter. The Division shall certify to the General Assembly the amount of any fees prescribed by the Division pursuant to this subsection 6(7)(a). If during the review of an application for tax credit certificate, the Director of the Commission identifies any potential deficiencies, the Director or Commission shall document the potential deficiencies in a letter sent to the landowner by the first-class mail. The Division shall send letters documenting potential deficiencies to the landowner in a timely manner so that the number of days between the date of completed application is received by the Division and the mailing date of the Division's letter, and the landowner does not exceed 120 days. The landowner has 60 days after mailing date of the Division's letter to address potential deficiencies, notify the Director and the Commission, and provide additional information or documentation that the Director of the Commission deems necessary to make a final determination regarding the application. The Director and the Commissions have 90 days after the date of receipt of any additional information or documentation provided by the landowner to review the information and documentation made a final determination regarding the application. The deadlines prescribed by this subsection 7 may be extended upon mutual agreement between the Director and the Commission and the landowner. 8. The Director of the Commission may deny an application if the landowner A has not demonstrated the satisfaction of the Director of the Commission that the application complies with requirements of this strike Part 11 unstrike Article 15. B. Does not provide information and documentation required pursuant to this strike Part 11 unstrike Article 15. or C, fails timely to respond within a request notice from the division of the director of the commission. 9, if the director reasonably believes that any appraisal submitted in accordance with this section is not credible, the director, after consultation with the commission, may request that the landowner, at the landowner's expense, obtain either a second appraisal or a review of the appraisal submitted with the application from the appraiser who meets the requirements of Part Strike 7, Unstrike 6 of this strike, Article 61, Unstrike Article 10 of this Title 12, and is in good standing with the Board of Real Estate Appraisers before making a final determination regarding the application. 10, if this director of the commission does not identify any potential deficiencies with an application, the director and the commission shall approve the application, and the division shall issue a page-wise on this thing. You get a little lost in the page-wise. Alright. So 201 and 202. It's 237, 238, 234. Okay, so I see. So it's like this. Okay.
Reading the amended pages.
Right.
You don't need to be reading amended pages. You really should. How many pages have you read? We're going to pretend that it's 10. So start on 11.
Residential commercial industrial purposes. 16, any person for a partnership limited liability company, association, or corporation, or employee authorized again thereof engaged in the act of negotiating, purchasing, signing, exchanging, selling, leasing, requiring rights, way permits, licenses, any other interest in real property on behalf of a third party for the purpose of facilities related to A, telecommunications lines, B, wireless communications facilities, C, CATVs, D, electric generation, transmission, distribution lines, E, water diversion, collection, distribution, treatment, and storage or use, and F, transportation, so long as such the person, firm's partnership, limited liability company, associated corporation, including any employees, authorization thereof, does not represent, displace in person, and is the agent thereof, the purchase, sales, or exchange of real estate, or an interest therein resulting from residential, commercial relocations required on a transportation project, regardless of the source of public funding. 12-10202, formerly 12-61-102, license required. It is unlawful for a person, firm, partnership, limited liability company, association, or corporation to engage in the business capacity of real estate broker in the state without first having obtained a license from the Strike Real Estate Unstrike Commission. No person shall be granted a license until such the person establishes compliances with business part 2 concerning education, experience, testing, truthfulness, and honesty, and otherwise good moral character. And in addition, any other requirements of this section complete competency to transact business of a real estate broker in such matters as to safeguard the interests of the public only after satisfactory proof of such the qualifications, together with the application for strike such unstrike the license is filed, and the office of commission is determining strike such unstrike the person's character. The Strike Real Estate Unstrike Commission shall be governed by section 24.5.101. 12-10-203, formerly 12-61-103, application for license. Rules definition 1A. All persons desiring to become real estate brokers shall apply to the Strike Real Estate Unstrike Commission for a license under the provisions of this part. Strike 1, Unstrike 2. Application for a license as a real estate broker shall be made to the commission upon forms or in a manner prescribed by Strike It Unstrike the Commission. B1. Prior to submitting the application for a license pursuant to Strike Paragraph A of this subsection 1, Unstrike subsection 1A of this section, each applicant shall submit a set of fingerprints to the Colorado Bureau of Investigation for the purposes of conducting a state and national fingerprint-based criminal history record check. Utilizing the records of the Colorado Bureau of Investigation and the Federal Bureau of Investigation, the applicant shall pay the fee established by the Colorado Bureau of Investigation for conducting the fingerprint-based criminal history record check to the Bureau. Upon completion of the criminal history record check, the Bureau shall forward the results to the Strike Real Estate Unstrike Commission. The Strike Real Estate Unstrike Commission may require a name-based criminal history record check for an applicant who has twice submitted to a fingerprint-based criminal history record check and whose fingerprints are unclassifiable. So for purposes of this strike, paragraph B, unstrike subsection 1B, applicant means an individual or any person designated to act as broker for any partnership, limited liability company, or corporation pursuant to subsection strike 7, unstrike 6 of this section. 2. Every real estate broker license under this part, strike 1, unstrike 2, shall maintain in place of business within the state except as provided in section strike 1261-107 unstrike 1210-208. In case a real estate broker maintains more than one place of business within the state, the broker shall be responsible for supervising all licensed activities originating in strike such unstrike the offices. 3. The commission is authorized by the section to require and procure any such proof as is necessary in reference to the truthfulness, honesty, and good moral character of any applicant for a real estate broker's license, or if the applicant is a partnership, limited liability company, or corporation of any partner, manager, director, officer, member, or stockholder. If strike such unstrike, the person has either directly or indirectly a substantial interest in strike unstrike such the applicant prior to the issuance of strike such unstrike the license. 4A, an applicant for a broker's license shall be at least 18 years of age. The applicant must furnish proof satisfactory to the commission the applicant has either received a degree from an accredited degree granting college or university with a major course of study in real estate, or has successfully completed courses of study approved by the commission at any accredited college or university, or in a private occupational school that has certified approval for the private occupational school division in accordance with the provisions of Article Strike 59, Unstrike 64 of Strike This Unstrike Title 23, or that has been approved by the commission or licensed by any official state agency of any other state as follows. 1. 48 hours of classroom instruction or equivalent corresponding hours in real estate law and real estate practice, and 2. 48 hours of classroom instruction or equivalent corresponding hours in understanding and preparation of Colorado real estate contracts, and 3. A total of 72 hours of instruction or equivalent correspondence hours from the following areas of study: A. Trust accounts and record keeping. B. Real estate closing. C. Current legal issues. And D. Practical applications. B. An applicant for a broker's license who has been licensed as a real estate broker in another jurisdiction shall be required to complete only the course of study comprising the subject matter areas described in strike subparagraphs 2 and 3B of paragraph A of this subsection 4, strike subsections 4A2 and 4A3B of this section. C. An applicant for a broker's license who has been licensed as a real estate salesperson in another jurisdiction shall be required to complete only the course of study required in strike subparagraphs 2 and 3 of paragraph A of this subsection 4, unstrike subsections 4A2 and 4A3 of this section. Strike D, deleted by Amendment L 96P 1414, Section 2, effective January 1, 1997. 5, deleted by Amendment L 96P 414, Section 2, effective January 1st, 1997. 6, unstrike. 5A, the applicant for a broker's license shall submit to and pass an examination designated to determine the competency of the applicant and prepared by or under the supervision of the Strike Real Estate Unstrike Commission or its designated contractor. The commission may contract with an independent testing service to develop, administer, or grade examinations or to administer license records. The contract may allow the testing service to recover the costs of the examination and the cost of administering exam and license records from the applicant. The commission may contract separately for these functions and allow recovered costs to be collected and retained by a single contract for a distributor or other contractors. The commission shall have the authority to set the minimum passing score that the applicant must receive in the examination, and strike said unstrike these scores shall reflect the minimum level of competency required to be a broker. Strike said unstrike the examination shall be given at such times and places as the commission prescribes. The examination shall include, but not be limited to, ethics, reading, spelling, basic mathematics, principles of land economics, appraisal, financing, a knowledge of the statutes and laws of the state relating to deeds, trust deeds, mortgages, listing contracts, contracts with sale, bills of sales, leases, agency brokers, trust accounts, closing securities, the provisions of this part, strike 1, unstrike 2, and the rules of the commission. The examination for a broker's license shall also include preparation of a real estate closing statement. B, an applicant for a broker's license who has held a real estate license in another jurisdiction that administers a real estate broker's examination, who has license for 2 or more years prior to applying for a Colorado license, may be issued a broker's license if the applicant establishes that he or she possesses credentials and qualifications that are substantially equivalent to the requirements in Colorado for licensure by examination. C, in addition to all other applicable requirements, the following provisions apply to brokers that did not hold a current and valid broker's license on December 31st, 1996. 1, no such broker shall engage in independent broker's practice without first having served actively as a real estate broker for at least 2 years. The commission shall adopt rules requiring employing brokers to ensure that a high-level supervision is exercised over such a broker during the strike such unstrike the 2-year period. 2, no such broker shall employ another broker without first having completed 24 clock hours of instruction or the equivalent in correspondence hours as approved by the commission in brokerage administration. 3, effective January 1st, 2019, a broker shall not act as an employing broker without first demonstrating, in accordance with rules of the commission, experience and knowledge sufficient to enable the broker to employ and adequately supervise other brokers as appropriate to the broker's area of supervision. The commission rules must set forth the method or methods by which the broker may demonstrate strike such unstrike the experience and knowledge, either by documenting a specified number of transactions that the broker has completed or by other methods. Strike 7, unstrike. 6A, real estate broker's license may be granted to individuals, partnerships, limited liability companies, or corporations. A partnership, limited liability company, or corporation in its application for a license shall designate a qualified active broker to be responsible for management and supervision of the license actions of the partnership, limited liability company, or corporation and all licensees. shown in the Commission's records as being in the employ of strike such, unstrike the entity, the application of the partnership, limited liability company or corporation, and the application of the broker designated by it shall be filed with the Strike Real Estate Unstrike Commission. B, no license shall be issued to any partnership, limited liability company or corporation unless and until the broker so designated by the partnership, limited liability company or corporation submits to and passes the examination required by this part, strike 1, unstrike 2 on behalf of the partnership, limited liability company, corporation. Upon strike such brokers, unstrike the broker, successfully passing the examination upon compliance with all the requirements of law by the partnership, limited liability company, or corporation, as well as by the designated broker. The Commission shall issue a broker's license to the partnership, limited liability company, or corporation, which shall bear the name of strike such, unstrike the designated broker, and thereupon the broker so designated shall conduct business as a real estate broker only through the strike said, unstrike partnership, limited liability company, or corporation, and not for the broker's own account. C, if the person so designated is refused a license by the Strike Real Estate Unstrike Commission, or ceases to be the designated broker of strike such, unstrike the partnership, limited liability company, or corporation, strike such, unstrike the entity may designate another person to make application for a license. If strike such, unstrike the person ceases to be designated broker of strike such, unstrike the partnership, limited liability company, or corporation, then the director may issue a temporary license to prevent hardship for a period not to exceed 90 days to the licensed person so designated. The director may extend a temporary license for one additional period not to exceed 90 days upon proper application and showing of good cause. If the director refuses, no further extension of a temporary license shall be granted except by the Commission. If any broker or employee of any such partnership, limited liability company, or corporation other than the one designated as provided in this section desires to act as a real estate broker, strike such, unstrike the broker or employee shall first obtain a license as a real estate broker as provided in this section and shall pay the regular fee thereafter. Therefore, strike 8, unstrike 7. The broker designated to act as broker for any partnership, limited liability company, or corporation is personally responsible for the handling of any and all earnest money, deposits, or escrow or trust funds received or distributed by strike said, unstrike the partnership, limited liability company, or corporation in the event of any breach of duty by the strike said, unstrike partnership, limited liability company, or corporation as a fiduciary. Any person aggrieved or damaged by the strike said, unstrike breach of fiduciary duty shall have a claim for relief against strike such, unstrike the partnership, limited liability company, or corporation, as well as against the designated broker, and may pursue strike said, unstrike the claim against the partnership, limited liability company, or corporation, and the designated broker personally. The strike said, unstrike broker may be held responsible and liable for damages based upon strike such, unstrike the breach of fiduciary duties may be recoverable against said partnership, limited liability company, or corporation, and any judgment so obtained may be enforced jointly or severally against strike said, unstrike the broker personally, and the strike said, unstrike partnership, limited liability company, or corporation. Strike 9, unstrike 8. No license for a broker registered as being in the employ of another broker shall be issued to a partnership, limited liability company, or corporation, or under a fictitious name or trade name, except that the married woman may elect to use her birth name. Strike 10, unstrike 9. No person shall be licensed as a real estate broker under more than one name, and no person shall conduct or promote a real estate broker's business except under the name under which strike such, unstrike the person is licensed. Strike 11, repealed. Unstrike. Strike 12, unstrike 10. A licensed attorney shall take and pass the examination referred to in this section after having completed 12 hours of classroom instruction, equivalent corresponding hours in trust accounts, record keeping, and real estate closings. 1210-204, formerly 1261-103.6, errors and omissions insurance required. Rules. 1. Every licensee under this part, strike 1, unstrike 2, except an inactive broker or an attorney licensee who maintains a policy of professional malpractice insurance that provides coverage for errors and omissions for their activities as a licensee under this part, strike 1, unstrike 1, 2, shall maintain errors and omissions insurance to cover all activities contemplated under part, strike 1, unstrike 2, 2, strike 8, unstrike 6 of this Article 10 in the division strike of real estate, unstrike, shall make the errors and omissions insurance available to all licensees by contacting with an insurer for group policy after a competitive bid process in accordance with Article 103 of Title 24. Strike CRS, unstrike a group policy obtained by the division strike of real estate. Unstrike must be available to all licensees with no right of the part of insurer to cancel a licensee. A licensee may obtain errors and omissions insurance independently if the coverage complies with the minimum requirements established by the division strike of real estate. Unstrike. 2A. If the division strike of real estate unstrike is unable to obtain errors and omissions insurance coverage to ensure all licensees who choose to participate in the group program at a reasonable annual premium As determined by the Division Strike of Real Estate on Strike, a licensee shall independently obtain the errors and omissions insurance required by this section. B, the Division Strike of Real Estate on Strike shall solicit and consider information and comments from interested persons when determining the reasonableness of annual premiums. 3, Division Strike of Real Estate on Strike shall determine the terms and conditions of coverage required under the section based on rules promulgated by the Commission. The Commission shall notify each licensee of the required terms and conditions at least 30 days before the annual premium renewal date is determined by the Commissions. Each licensee shall file a certificate of coverage showing compliance with the required terms and conditions with the Commission by the annual premium renewal date as determined by the Division Strike of Real Estate on Strike. 4, in addition to all other powers and duties conferred upon the Commission by this Article 10, the Commission shall adopt such rules as it deems necessary or proper to carry out the provisions of this section. Strike 5, deleted by Amendment L2008, page 497, Section 4, effective April 17th, 2008, unstrike. 12-10-205, formerly 12-61-104, licenses, issuance, contents, display. Strike 1, unstrike. The Commission shall make available for each licensee a license in such form and size as strike said unstrike. The Commission shall prescribe and adopt the real estate license shall show the name of the licensee and shall have imprinted thereon the seal or a facsimile of the Department Strike of Regulatory Agencies unstrike, and in addition to the foregoing shall contain such other matters as strike said unstrike. The Commission shall prescribe. Strike 2 and 3, deleted by Amendment L 2001, page 24, Section 2, effective March 9th, 2001, unstrike. 12-10-206, formerly 12-61-105, Real Estate Commission created compensation immunities subject to termination. 1. There is hereby created a commission of 5 members appointed by the Governor, which shall administer parts strike 1, unstrike 2, and strike 4, unstrike 5 of this article, strike 61, unstrike 10. This commission is known as the Real Estate Commission Strike, also referred to in this Part 1 as the Commission on Strike, and consists of 3 real estate brokers who have had not less than 5 years' experience in the real estate business in Colorado, one of whom has substantial experience in property management, and 2 representatives of the public at large. Members of the Commission hold office for a period of 3 years. Upon the death, resignation, removal, or otherwise of any member of the Commission, the Governor shall appoint a member to fill out the unexpired term. The Governor may remove any member for misconduct, neglect of duty, or incompetence. To each member of the Commission shall receive the same compensation and reimbursement of expenses as those provided for members of the Boards of Commission in the Division of Professions and Occupations pursuant to Section Strike 2434-102-13 CRS unstrike 1220-103. 6. Payment for all such per diem compensation expenses shall be made out of annual appropriations for the Division of Real Estate Cash Fund provided for in Section Strike 1261-111.5 unstrike 1210-215. Strike 2.5 unstrike 3. Members of the Commission, consultants, expert witnesses, and complainants shall be immune from suit in any civil action based upon any disciplinary proceedings or other official acts they performed in good faith. Strike 3, unstrike 4. No real estate broker's license shall be denied, suspended, or revoked except as determined by a majority vote of the members of the Commission. Strike 4. The provisions of Section 2434-104 CRS concerning the termination schedule for regulatory bodies of the state, unless extended as provided in that section, are applicable to the Real Estate Commission created by this section. Unstrike 12-10-207, formerly 1261-106, Division of Real Estate Creation, Director, Clerks, and Assistants. 1. There is hereby created within the Department of Division of Real Estate the Executive Director Strike of the Department of Regulatory Agencies. Unstrike is authorized by the section to employ, subject to the Division of State Personnel System laws of the state, a director of the Division Strike of Real Estate unstrike, who in turn shall employ such attorneys, deputies, investigators, clerks, and assistants are as necessary to discharge the duties imposed by parts strike 1, unstrike 2, and strike 4, unstrike 5 of this article. Strike 61-10, the Division Strike of Real Estate, which is a division of the Department of Regulatory Agencies, unstrike, and the director of strike. The Division on Strike shall exercise their power and perform their duties and functions under the Department of Strike of Regulatory Agencies on Strike as they were transferred to the Department by a Type 2 transfer. 2. It is the duty of the Director, personally, or strike his unstrike the Director's designee, to aid in the administration and enforcement of Part Strike 1, unstrike 2, and Strike 4, unstrike 5 of this article, Strike 61, unstrike 10. and in the prosecution of all persons charged with violating any of their provisions, the conduct, audits of business accounts of licensees, to perform such duties of the Commission as the Commission prescribes, and to act on behalf of the Commission on such occasions and in such circumstances as the Commission directs. 12-10-208, formerly 12-61-107, resident licensee, non-resident licensee, consent to service. 1. A non-resident of the state may become a real estate broker in this state by conforming to all the conditions of this part. Strike 1, unstrike 2, except that a non-resident broker shall not be required to maintain a place of business within the state if the broker maintains a definite place of business in another state. 2. If a broker has not registered, has no registered agent registered in the state, strike such, unstrike. The registered agent is not located under its registered agent name and its registered agent address, or the registered agent cannot, with reasonable diligence, be served. The broker may be served by registered mail or by certified mail. Return receipt requested. Address to the entity and its principal address. Service is perfected under this subsection 2 at the earliest of A, the date the broker receives the process, notice, or demand. B, the date shown on the return receipt if signed by or on behalf of the broker. Or C, 5 days after mailing. 3, all such applications shall contain a certification that the broker is authorized to act for the corporation. 12-10-209, formerly 12-61-108, record of licensees' publications. The Commission shall maintain a record of the names and addresses of all licensees licensed under the provisions of Part Strike 1, unstrike 2, and Strike 4 and Strike 5 of this Article 10, together with such other information relative to the enforcement of strike said, unstrike the provisions as deemed by the Commission the necessary publication of the record and of any other information circulated by quantity outside the executive branch shall, in accordance with the provisions of Section 24-136, strike CRS, unstrike. 12-10-210, formerly 12-61-108.5, compilation and publication of passing rates per educational institution for real estate licensure examination definition rules. 1. The Commission shall have the authority to obtain information from each educational institution authorized to offer courses in real estate for the purposes of compelling the number of applicants who pass the real estate licensure examination from each educational institution. The information shall include the name of each student who attended the institution and a statement of whether the student completed the necessary real estate courses required for licensure. The Commission shall have access to such other information as necessary to accomplish the purpose of his section. For the purpose of this section, an applicant is a student who completed the required education requirements and who applied for and sat for the licensure examination. 2. The Commission shall compile the information obtained, subsection 1 of this section, with an applicant information retained by the Commission specifically. The Commission shall compile whether the student applied for licensure examination and whether the applicant passed the licensure examination. The Commission shall create statistical data setting forth A, the name of the educational institution, B, the number of students who completed the necessary real estate course required for licensure, C, whether the student registered and sat for the licensure examination, and D, the number of those applicants who passed the licensure examination. 3. The Commission shall publish statistical data and make it available to the public quarterly. 4. The Commission shall retain these statistical data for 3 years. 5. Specific examination scores for an applicant will be kept confidential by the Commission unless the applicant authorizes release of strike such, unstrike the information. 6. The Commission may promulgate rules for the administration of this section.
12-10-211, bracket, formerly 12-61-109, change of license status, dash inactive, dash cancellation. 1. Immediate notice shall be given in a manner acceptable to the Commission by each license of any changes of business, location, or employment. A change of business address or employment without notification to the Commission shall automatically inactivate the licensee's license. 2. A broker who transfers to the address of another broker or a broker applicant who desires to be employed by another broker shall inform the Commission of the strike said the broker is to be in the employ of the other broker. The employing broker shall have the control custody of the employed broker's license. The employed broker may not act on behalf of strike said the broker or as broker for a partnership, limited liability company, or corporation during the time of strike such the employment, but this shall not affect the employed broker's rights to transfer to another employing broker or a location where the employed broker may conduct business as an independent broker or as broker acting for partnership, limited liability company, or corporation. 3. In the event that any license is discharged by or terminates employment with a broker, it shall be the joint duty of both such parties to immediately notify the Commission. Either party may furnish strike such the notice in a manner acceptable to the Commission. The party giving notice shall notify the other party in person in writing of the termination of employment. 4, it is unlawful for any such licensee to perform any of the acts authorized under the license pursuant of this part, strike 1, 2, either directly or indirectly on or after that date that employment has been terminated. When any real estate broker whose employment has been terminated is employed by another real estate broker, the Commission shall, upon proper notification, enter strike such the change of employment in the records of the Commission. No more than the employer or place of employment shall be shown for any real estate broker for the same period of time. 12-10-212, formerly 12-61-110, license fees, partnership, limited liability, incorporation license S rules. 1. Fees established pursuant to section strike 12-61-11.5 in strike 12-10-215 shall be charged by and paid to the Commission or the agent for the commission of the following. Strike A and B deleted by Amendment L.96, page 419, Section 5, effective January 1, 1997. C, in strike A, each broker's examination. D, strike, in strike B, each broker's original applications and license. Strike C, deleted Amendment L.96, page 419, Section 5, effective January 1, 1997. F, in strike C, each renewal of broker's license. Strike G, deleted by Amendment L96, page 419, Section 5, effective January 1, 1997. In strike H, strike D, any change of name, address, or employing other broker or changes in commission records. Strike I. In strike E, a new application, strike which. That shall be submitted when licensed real estate broker wishes to become the broker acting for a partnership, a limited liability company, or a corporation. 2, the proper fee shall accompany each applicant for licensure. The fee shall not be refundable. Failure by the person taking an examination to file the appropriate broker's application within 1 year of the date, strike such the person passed the examination will automatically cancel the examination. All rights to a passing score will be terminated. 3, each real estate broker's license granted to an individual shall entitle, strike such the individual to perform acts contemplated by this part, strike 1, 2, with any further application on his or her part without the payment of any fee other than fees specified in this section. 4AI, the Commission shall require any person licensed under this part, strike 1, 2, whether on an active or inactive basis, renew the license on or before December 31st of every third year after issuance, except that an initial license issued under this part, strike 1, 2, or on after April 23rd, 2018, expires at 12 midnight on December 31st of the year in which it was issued. Roman numeral 2, renewal is conditioned upon fulfillment of containing education requirements set forth in this strike 1261-110.5 and strike 1210-213 for persons renewing or reinstating an active license, written certification verifying completion of the previous licensing period of the continuing education requirements set forth in section strike 1261-110.5 and strike 1210-213 must accompany to be submitted to the Commission with the application for renewal or reinstatement. For persons who do not submit certification verifying compliance with section strike 1261-110.5 and strike 1210-213 at the time the license was renewed or reinstated on an inactive status, written certification verifying completion of the previous licensing period of continuing education requirements set forth that section must accompany and be submitted with any future application to reactivate the license. The Commission may, by rule, establish procedures to facilitate such renewal. In the absence of any reason or condition that might warrant the refusal of granting license to the revocation thereof, the Commission shall issue a new license upon receipt of the Commission of the written request of the applicant and the appropriate fees required by this section. Applications for renewal will be accepted 30 days prior to January 1. Roman numeral 3, a person who fails to renew a license before January 1 of the year succeeding of the year expiration of the license may reinstate the license as follows. A, if proper application is made within 31 days after the date of expiration by payment of the regular renewal fee. B, if proper application is made more than 31 days but within 1 year of the date of expiration by payment of the regular renewal fee and payment of reinstatement fee equal to 1/2 the regular renewal fee. C, if proper application is made more than 1 year but within 3 years after the date of expiration, the payment of regular renewal fee and payment of a reinstatement fee equal to the regular renewal fee. 4, Roman numeral 4, the Commission may, by rule, establish such procedures to facilitate the transition of the reinstatement license periods described in subsections 4A3A to 4A3C of this section from anniversary expiration date to a 31st expiration date. Strike 8.5 repealed and strike. B, any reinstated license shall be effective only as the date of the reinstatement. Any person who fails to apply for reinstatement within 3 years after the expiration of a license shall, without exception, be treated as a new applicant for licensure. C, all reinstatement fees shall be transmitted to the State Treasurer, who shall credit, strike same, the fees to Division of Real Estate Cash Fund as established by section strike 261-111.5 and strike 1210-215. 5, the suspension, expiration, or revocation of a real estate broker's license shall automatically inactivate every real estate broker's license where the holder of strike such the license is shown in the commission records to be in the employ of the broker whose license has expired or has been suspended or revoked pending notification to the commission by the employed license of a change of employment. Strike 6 deleted by Amendment L.91, page 1628, Section 8, effective July 1, 1991. And strike 1210-213, formerly 1261-110.5, renewal of license continuing education requirement rules. 1. A broker applying for renewal of a license pursuant to section strike 1261-110.4 in strike 1210-212.4 shall include with the strike such the application a certified statement verifying successful completion of real estate courses in accordance with the following schedule. Strike A and B repealed. C. In strike A for licensees applying for renewal of a 3-year license, passage with the previous 3 years of the Colorado portion of real estate exam or completion of a minimum of 24 hours of credit, 12 of which must be the credits developed by the commission pursuant to subsection 2 of this section. Strike D and strike B for licensees applying for renewal of a license that expires less than 3 years after it was issued, passage with the license period of the Colorado portion of the real estate exam or completion of a minimum of 24 hours of credit, at least 8 of which may be the credits developed by the commission pursuant to subsection 2 of this section. 2, the strike real estate commission shall develop 12 hours of credit designed to assure reasonable currency of real estate knowledge by licensees, which credit shall include an update of the current statutes and the rules promulgated by the commission that affect the practice of real estate. If licensee takes a course pursuant to Rule Strike 260-250 of the Colorado Rules of Civil Procedure, and the course concerns real property law, the licensee shall receive credit for the course toward fulfillment of the licensee's continuing education requirements pursuant to this section. The credit shall be taken from an accredited Colorado college or university, a Colorado community college, a Colorado private occupational school holding a certificate of approval from the State Board for Community Colleges and Occupational Education, or an educational institution for an educational service described in Section 2364-104. Successful completion of strike such the credit shall require satisfactory passage of a written examination of examinations of the material covered. The examination shall be audited by the Commission to verify their accuracy and the validity of the grades given. The Commission shall set standards required for this satisfactory passage of examinations. 3. All credits other than the credits specified in subsection 2 of this section shall be acquired from the educational courses provided by the Commission that contribute directly to the professional competence of a licensee. Strike such, the credits may be acquired through successful completion of one or more of the following subject areas. Print A, real estate law. Print B, property exchanges. C, real estate contracts. D, real estate finance. E, real estate appraisal. F, real estate closing. G, real estate ethics. H, condominiums and cooperatives. I, real estate time sharing. J, real estate marketing principles. K, real estate construction. L, land development. M, real estate energy concerns. N, real estate geology. O, water and waste management. P, commercial real estate. Q, real estate securities syndications. R, property management. S, real estate computer principles. T, brokerage administration and management. U, agency. And V, any other subject matter as approved by the Strike Real Estate Commission. 4, a licensee applying for renewal of a license strike which that expires on December 31st of the year it was issued, is not subject to the education requirements set forth, in subsection paren 1 of this section. Paren 5, the Strike Real Estate Commission shall promulgate rules, strike, and regulations to implement this section. 1210-214, formerly 1261-111, disposition of fees. All fees collected by the Strike Real Estate Commission under parts strike 1, 2, and strike 4, 5 of this Article 10, not including administrative fees that are in the nature of administrative fine and fees retained by contractors pursuant to contracts entered into in accordance with Section Strike 1261-103, 1210-203, or 2434-101 Strike CRS shall be transmitted to the State Treasurer, who shall credit to the same division of Real Estate Cash Fund. Pursuant to Strike 1261-111.5, 1210-215, the General Assembly shall make an annual appropriations from Strike said the fund for expenditures of commission incurred by the performance of its duties under Part Strike 1, 2, and Part Strike 4, 5 of this Article 10. The Commission may request an appropriation specifically designed for the educational and enforcement purposes. The expenditures incurred by the Commission under Part Strike 1, 2, and Strike 4, 5 of this Article 10 should be made out of Strike such the appropriations upon vouchers and warrants drawn pursuant to law. 1210-215, formerly 1261-111.5, fee adjustments, cash fund created. Paren 1. This section applies to all activities, the division under parts strike 1, 4, 7, 9, and 10. Two, 5, 6, and 7 of this article, strike 6110. 2A, Roman numeral 1. The division shall purpose as part of this annual budget request an adjustment of the amount of each fee that is authorized by the law to collect under Part Strike 1, 4, 7, 9, and 10 in Strike 2, 5, 6, and 7 of this article, Strike 6110. The budget request and adjusted fees for the division must reflect direct and indirect costs. Roman numeral 2. The cost of HOA Information Resource Center created in this section, Strike 1261 406.5 and Strike 1210 801 shall be paid from the Division of Real Estate Cash Fund created in this section. The Division of Real Estate in Strike shall estimate the direct and indirect costs operating the HOA Information Resource Center and shall establish the amount of annual registration fee to be collected under the section 33.3401. The amount of the registration fee shall be sufficient to recover these costs subject to a maximum limit of $50. B, strike Roman numeral 1. Based on the appropriation made subject to the approval of the Executive Director, strike of the Department of Regulatory Agencies, the Division Strike of Real Estate shall adjust its fees so the revenue generated from fees approximated its direct and indirect costs incurred in administration the programs and activities from which the fees are derived. The fee shall remain in effect for a fiscal year for which the budget request applies. All fees collected by the division, not including fees retained by contractors pursuant to contracts entered into in accordance with Strike 1261-103 and Strike 1210-1003, 203, or 2434-101, shall be transmitted to the State Treasurer, who shall credit the same division of the Real Estate Cash Fund, which fund is hereby created. All money credited to the division of the Real Estate Cash Fund shall use provided in this section or in section Strike 1261-111 and Strike 1210-214 and shall not be deposited or transferred to general fund of the state of any other fund. Strike Roman numeral 2 repealed. In Strike C, beginning July 1, 1979, each July 1 thereafter, whenever Strike money appropriated to the division for its activities for the prior fiscal year, Strike R is unexpended. In Strike said monies. In Strike, the money shall be made part of the appropriation of the division for the next fiscal year, and Strike such, the amount shall not be raised from fees collected by the division. If supplemental appropriation is made to the division for its activities, its fees, when adjusted for the fiscal year the next following, in that in which the supplemental appropriation was made, shall be adjusted by an additional amount Strike which that is sufficient to compensate for Strike such the supplemental appropriation. Funds appropriated by the division in an annual long appropriations bill shall be designated as a cash fund not exceed the amount anticipated to be raised from fees collected by the division. 12-10-216, formerly 1261-112, Records Evidence Inspection 1. The Executive Director, Strike, the Department of Regulatory Agencies, and Strike shall adopt a seal by which all proceedings authorized under Part Strike 1, 2, and Strike 4, 5. This article, Strike 6110, shall be authenticated. Copies of the records and paper in the office of the Commissioner, Department of Strike Regulatory Agencies, and Strike relating to the administrations of Strike 1, 2, and Strike 4, 5 of this article, Strike 6110, when duly certified and authenticated by the seal, shall be received as evidence in all courts equally with the like effect to the originals. All records kept in the office of the Commissioner of the Department Strike of Regulatory Agencies under authority of Parts Strike 1, 2, and Strike 4, 5 of this article, Strike 6110, must be open to the public inspection at the time and in such a manner as may be prescribed by rules formulated by the Commission. Strike 2, repealed. 3, in Strike 2, the Commission shall not require or maintain preserve licensing history of any person licensed under provisions of the Strike 1, 2, or for any time longer than 7 years. 12-10-217, formerly 1261-113, investigation, revocation, actions against licensee or application definition. Commission upon so motion may, and upon the complaint of writing against a person, shall investigate the activities of any licensee or any person who assumes in the active capacity of a licensee within the state and the Commission after holding a hearing pursuant to section Strike 1261-114 and Strike 12-10-219, has the power to impose administrative fine not to exceed $2,500 for each separate offense and to censure a licensee, to place the licensee on probation and to set the terms of the probation or to temporarily suspend a license or permanently revoke a license when the licensee has performed, is performing, or attempting to perform any of the following acts and is guilty of: A, knowingly making any misinterpretation or knowingly making any use of any false advertising. B, making any promise of character strike which that influences, persuades, or induces another person when he or she could not or did not intend to keep strike such the promise. C, knowingly misinterpreting or making false promises through agents, advertising, or otherwise. Strike C.5 and Strike D, violating a provision of the, quote, Colorado Consumer Protection Act, in quote, Article 1 of Title 6, Strike CRS. D, in Strike E, acting for more than one party in transaction without the knowledge of all parties thereto. Strike C. Strike E, F, representing or attempting any represent a real estate broker other than licensee's employees without express knowledge and consent of that employer. Strike F and Strike G, in the case of the broker registered by the employer, another broker failing to place or soon after receipt as is practically possible in the custody of that licensed broker employer, and any deposit money or other money or fund transferred to the employee by any person dealing with the employee as a representative of that licensed broker employer. Strike G, H, failing to account for or remit within reasonable time any strike money's money coming to the licensee's possession that strike belongs to others, whether acting as real estate broker or otherwise, and failing to keep records relative to strike said monies the money, which records shall contain such information as may be prescribed by the rules of the commission relative thereto, shall be subject to the audit by the commission. Strike G.5, little I. Converting funds of others, diverting funds of others without proper authorization, commingling funds of others with the broker's own funds, or failing to keep strike such the funds of others in an escrow or a trustee account with some bank, reorganized depository in the state, which account may be a type of checking demand, passbook, or statement account insured by an agency of the United States government, and to strike so keep records alive. To the deposit, strike which that contains such information may be prescribed by the rules, strike, and regulations of the commission relative hereto, which records shall be subject to the commission.
Strike. H, unstrike. J, failing to provide the purchase and sale of real estate with a closing statement of the transaction containing such information as may be prescribed by the rules, strike, and regulations on strike of the commission, or failing to provide a signed duplicate copy of the listing contract and the contract of sales of the preliminary agreement to sell the parties thereto. Strike I, unstrike. K, failing to maintain possession for future use or inspection by an authorized representative of the commission for a period of 4 years or the documents or records prescribed by the rules, strike, and regulations on strike of the commission, or to produce, strike such, unstrike the documents or records upon reasonable request by the commission or authorized representative of the commission. Strike J, unstrike. Paying a commission or valuable consideration for performing any of the functions of a real estate broker as described in this part. Strike 1, unstrike 2. To any person not licensed under this part, strike 1, unstrike 2, except that a licensed broker may pay a finder's fee or a share of any commission to a cooperative sale when strike such, unstrike. The payment is made to the real estate broker licensed in another state or country. If a country does not license real estate brokers, then the payee must be a citizen or resident of strike said, unstrike the country, and represent that the payee is the business of selling real estate in strike said, unstrike the country. Strike K, unstrike M, disregard or violating any provisions of this part. Strike 1, unstrike 2, or part strike 8, unstrike 4 of this Article 10, violating any reasonable rule or strike or regulation on strike promulgated by the commission in the interest of the public and in conformance with the provisions of this part. Strike 1, unstrike 2, or part strike 8, unstrike 4 of this Article 10, violating any lawful commission orders or aiding and abetting violation of any rule, strike, regulation, unstrike, commission order or provision of this part. Strike 1, unstrike 2, or part strike 8, unstrike 4 of this Article 10. Strike I repealed. Strike, unstrike, strike M, unstrike N. 1. Conviction of entering a plea guilty to or entering a plea of no contender to any crime in Article 3 of Title 18, Parts 1, 2, 3, and 4 of Article 4 of Title 18, Part 1, 2, 3, 4, 5, 6, 5, 7, 8, or 9 of Article 5 of Title 18, Article 5.5 of Title 18, Parts 3, 4, 6, 7, and 8 of Article 6 of Title 18, Parts 1, 3, 4, 5, 6, 7, and 8 of Article 7 of Title 18, Part 3 of Article 8 of Title 18, Article 15 of Title 18, Article 17 of Title 18, Section 18, 18.404, 18, 18.405, 18, 18.406, 18, 18.411, 18, 18.412.5, 18, 18.412.7, 18, 18.412.8, 18, 18.415, 18, 18.416, 18, 18.422, or 18, 18.423, or any other like crime under Colorado law, federal law, or the laws of other states. A certified copy of the judgment of a court of competent jurisdiction of strike such, unstrike the conviction, or other official record indicating that strike such, unstrike the plea was entered, shall be conclusive evidence of strike such, unstrike the conviction or plea in any hearing under this part. Strike 1, unstrike 2. 2. As used in this subsection, strike 1M, unstrike 1N. Conviction includes the imposition of a deferred judgment or deferred sentence. Strike M.5, unstrike O, violating or aiding and abetting a violation of Colorado federal fair housing laws. Strike M.6, unstrike P, failing to immediately notify the commission in writing of conviction, plea, or violation pursuant to strike paragraph M or M.5 of this subsection 1, unstrike subsection 1N or 1O of this section. Strike in, unstrike Q, having demonstrated unworthiness or incompetency to act as a real estate broker by conducting business in such a manner as to endanger the interest of the public. Strike O, unstrike R. In this case, the broker licensee failing to exercise reasonable supervision over the activities of the licensed employees. Strike P, unstrike S, procuring or attempting to procure a real estate broker's license, or renewing, reinstating, reactivating, or attempting to renew, reinstate, or reactivate a real estate broker's license by fraud, misrepresentation, or deceit, by making material misstatement of fact in an application for strike such, unstrike the license, strike Q, unstrike T, claiming, arranging for, or taking any secret or undisclosed amount of compensation, commission, or profit, or failing to reveal the licensee's principal or employer the full amount of strike such, unstrike the licensee's compensation, commission, or profit in connection with any acts for which the license is required under this part. Strike 1, unstrike 2. Strike R, unstrike U, using any provision allowing the licensee an option to purchase any agreement authorizing or employing strike such, unstrike the licensee to sell, buy, or exchange real estate for compensation or commission, except when strike such, unstrike the licensee prior to or coincident with election to exercise strike such, unstrike the option to purchase, reveals in writing the licensee's principal or employer the full amount of the licensee's profit, and obtains the written consent of strike such, unstrike the principal or employers approving the amount of strike such, unstrike the profit. Strike S1 repealed. 2, unstrike V, effective on and after August 26, 2013, fraud, misrepresentation, deceit, or conversion of trust funds that results in the entry of a civil judgment for damages. Strike T, unstrike W, any other conduct, whether of the same or different character than specified in the subsection 1, strike which, unstrike that constitutes dishonest dealing. Strike U, repealed. Unstrike V, strike V, unstrike X, having a real estate broker or subdivisions developer's license suspended or revoked in any jurisdiction, or having any disciplinary action taken against the broker of subdivision developer in any other jurisdiction of the brokers of subdivisions developers' actions would constitute a violation of this subsection 1. A certified copy of the order of disciplinary action shall be prima facie evidence of strike, unstrike such the disciplinary action. Strike W, unstrike Y, failing to keep records documenting proof of completion of the continuing education requirements in accordance with section strike 1261 110.5, unstrike 1210-213 for a period of 4 years from the date of compliance with strike said, unstrike the section. Strike X, unstrike Z. 1, violating the provision of section strike 1261 113.2, unstrike 1210-218. 2, in addition to any other remedies available to the commission pursuant to this strike title, unstrike article 10 after notice of hearing pursuant to section 244105, strike CRS, unstrike the commission may assess a penalty for a violation of section strike 1261 113.2, unstrike 1210-218, or of any rule promulgated pursuant to section strike 1261 113.2, unstrike 1210-218. The penalty shall be the amount of remuneration improperly paid and shall be transmitted to the state treasurer and credited to the general fund. Strike Y, unstrike AA, within the last 5 years, having a license, registration, or certification issued by Colorado or another state revoked or suspended for fraud, deceit, material misrepresentation, theft, or the breach of a fiduciary duty of such discipline, denied the person authorization of practice as 1, a mortgage broker or mortgage loan originator. 2, a real estate broker or person. 3, a real estate appraiser as defined by section strike 1261-702. 2, unstrike 1210-602-9. 4, an insurance producer as defined by section 10-2-103. 6, strike CRS, unstrike 5, an attorney. 6, a securities broker dealer as defined by section 11-51-201, strike CRS, unstrike. 7, a security sales representative defined by section 1151-201-14, strike CRS, unstrike. 8, an investment advisor as defined by section 1151-201, 9.5, strike CRS, unstrike. Or 9, an investment advisor representative as defined by section 1151-201, 9.6, strike CRS, unstrike. Strike 1.5, unstrike. 2, every person licensed pursuant to section strike 1261-101, 2A10. Unstrike 1210-201, 6A10 shall give a prospective tenant a contract or receipt and strike such unstrike. The contract or receipt shall include the address and telephone number of the strike real estate unstrike commission in prominent letters and shall state that the regulation of rental location agents is under the purview of the strike real estate unstrike commission. Strike 2, unstrike. 3, in the event a firm, partnership, limited liability company, association, or corporation operating under the license of a broker, designated license as a representative of strike said, unstrike, the firm, partnership, limited liability company, association, or corporation is guilty of any other foregoing acts, the commission may suspend or revoke the right of strike said, unstrike, firm, partnership, limited liability company, association, or corporation to conduct its business under the license of strike said, unstrike, the broker.
Bring you over a full-size version.
A broker designated licensed representative of strike said, unstrike the firm, partnership, limited liability company, association, or corporation guilty of any of the foregoing acts. The commission may suspend or revoke the right of the strike said, unstrike firm, partnership, limited liability company, association, or corporation to conduct its business under the license of strike said, unstrike the broker, whether or not the designated broker has personal knowledge thereof, and whether or not the commission suspends or revokes the individual license of strike said, unstrike the broker. Strike 3, unstrike 4 upon request of the commission. When any real estate broker is a party to any suit or proceeding, either civil or criminal, arising out of any transaction involving the sale, exchange of any interest in real estate property, or out of any transaction involving a leasehold interest in the real property, and when strike such, unstrike the broker is involved in strike such, unstrike the transaction in such capacity as a licensed broker, it shall be the duty of strike said, unstrike the broker to supply the commission a copy of the complaint, indictment, information, or other initiating pleading and the answer filed, if any, and to advise the commission on the disposition of the case and of the nature and amount of any judgment, verdict, finding, or sentence that may be made, entered, or imposed therein. Strike 4, unstrike 5. This part, strike 1, unstrike 2 shall not be construed to relieve any person for civil liability or criminal prosecution on the laws of the state. Strike 5, unstrike 6. Complaints of record in the Office of the Commission and Commission investigations, including Commission investigative files, are closed to public inspection. Stipulations and final agency orders are public records subject to Section 2472-203 and 2472-204. Strike CRS, unstrike. Strike 6, unstrike 7. When a complaint or an investigation discloses an instance of misconduct, strike which, unstrike that. In the opinion of the Commission, does not warrant formal action by the Commission, but strike which, unstrike that should not be dismissed as being without merit. The Commission may send a letter of admonition by certified mail. Return receipt requested to the licensee against whom a complaint was made, and a copy of the report of the person making a complaint. But the letter shall advise the licensee that the licensee has the right to request in writing within 20 days after the proven receipt that the formal disciplinary proceedings be initiated to adjudicate the proprietary of the conduct upon which the letter of admonition is based. If strike such, unstrike the request is timely made, the letter of admonition shall be deemed vacated, and the matter shall be processed by means of formal disciplinary proceedings. Strike 7, unstrike 8. All administrative fines collected pursuant to this section shall be transmitted to the State Treasurer, who shall credit the same to the Division of Real Estate Cash Fund. Strike 8, unstrike 9. Any application for licensure for a person whose license has been revoked shall not be considered until the passage of 1 year from the date of revocation. Strike 9, unstrike 10. When the Division of Strike of Real Estate unstrike becomes aware of facts, circumstances that fall within the jurisdiction of the criminal justice or other law enforcement authority upon investigation of the activities of the license, the Division shall, in addition to the exercise of its authority under this part, strike 1, unstrike 2, refer and transmit strike such, unstrike the information, which may include originals or copies of documents and materials, to one or more criminal justice or other law enforcement authorities for investigation and prosecution as authorized by law. 1210-218. Formerly 1261-113.2, affiliated business arrangements, definitions, disclosures, enforcement, and penalties, reporting rules, investigation information shared with the Division of Insurance. 1. As used in this section, unless the context otherwise requires, a affiliated business arrangement means an arrangement in which a provider of settlement services or an associate of provider of settlement services, either an affiliated relationship with or a direct benefit ownership interest of more than 1% in another provider of settlement services, and 2, a provider of settlement services or the associate of a provider directly or indirectly refers settlement services business to another provider of settlement services or affirmatively influences the selection of another provider of settlement services. B. Associate means a person who has one or more of the following relationships with a person in a position to refer settlement service business. 1. A spouse, parent, or child of strike such, unstrike the person. 2. A corporation or business entity that controls, is controlled by, or is under common control with strike such, unstrike the person. 3. An employer, officer, director, partner, franchisor, or franchisee of strike such, unstrike the person, including a broker acting as an independent contractor. Or 4. Anyone who has an agreement, arrangement, or understanding with strike such, unstrike the person, the purpose of substantial effect of which is to enable the person in a position to refer settlement services business is to benefit financially from referrals of strike such, unstrike the business. C. Settlement services means any service provided in connection with real estate settlement, including but not limited to the following: 1. Title searches. 2. Title examinations. 3. The provision of title certificates. 4. Title insurance. 5. Services rendered by an attorney. 6. The preparation of title documents. 7. Property surveys. 8. The rendering of credit reports or appraisals. 9. Real estate appraisal services. 10. Home inspection services. 11. Services rendered by real estate broker. 12, pest and fungus inspections. 13, the origination of a loan. 14, the taking of a loan application. 15, process of a loan. 16, underwriting and funding of a loan. 17, escrow handling services. 18, the handling of processing. And 19, closing of settlement. 2A, an affiliated business arrangement is permitted where the person referring business to the affiliated business arrangement receives payment only in the form of a return on an investment and where it does not violate provisions of section strike 1261, 113 on strike 1210 to 17. B, if the licensee or the employing broker of a licensee is part of an affiliated business arrangement with an offer to purchase real property is fully executed, the licensee shall disclose to all parties to the real estate transaction the existence of the arrangement. The disclosure shall be written, shall be signed by all parties to the real estate transaction, and shall comply with the Federal Real Estate Settlement Procedures Act of 1974 as amended, 12 U.S.C. Section 2601 et sequitur. C, a licensee shall not require the use of an affiliated business arrangement of a particular provider of settlement services as a condition of obtaining services from that licensee for any settlement service for the purpose of this strike paragraph. C, unstrike subsection 2C. Required the use shall have the same meaning as required use in 24 CFR 3500.2b. D, no licensee shall give or accept any fee, kickback, or other thing of value pursuant to any agreement or understanding or otherwise that business instance to or part of a settlement service involving an affiliated business arrangement shall be referred to any provider of settlement services. E, nothing in this section shall be construed to prohibit payment of a fee to 1, an attorney for services actually rendered. 2, a title insurance company. 2, its duly appointed agent for services actually performed in the issuance of a policy of title insurance. 3, a lender. 2, its duly appointed agent for services actually performed in the making of a loan. F, nothing in this section shall be construed to prohibit payment to any person of 1, a bona fide salary or compensation or other payment for goods or facilities actually furnished or for services actually performed. 2, a fee pursuant to cooperative brokerage and referral arrangements or agreements between the real estate brokers. G, it shall not be a violation of this section for an affiliated business arrangement. 1, to require a buyer, borrower, or seller to pay for services of an attorney, credit reporting agency, or real estate appraiser chosen by the lender to represent the lender's interest in a real estate transaction. Or 2, if an attorney or law firm represents a client in a real estate transaction, issues arrangement or arranges for the issuance of a policy of title insurance in the transaction directly as agent or through a separate corporate title insurance agency that may be established by the attorney or law firm and operated as an adjunct to his or her law practice. H, no person shall be liable for a violation of this section if strike such unstrike the person proves by preponderance of the evidence that strike such unstrike the violation was not intentional and resulted from a bona fide error with notwithstanding maintenance or procedures that are reasonably adopted to avoid strike such unstrike the error. 3, on and after July 1st, 2006, a licensee shall disclose at the time of the licensee enters into or changes an affiliated business arrangement in a form and manner acceptable to the commission to the names of all affiliated business arrangements which licensee is a party. The disclosure shall include the physical locations of the affiliated businesses. 4, on and after July 1st, 2006, an employing broker in a form and manner acceptable to the commission shall, at least annually, disclose the names of all affiliated business arrangements to which the employing broker is a party. Disclosure shall include the physical locations of the affiliated business. 5, the commission may promulgate rules concerning the creation and conduct of an affiliated business arrangement, including but not limited to rules defining what constitutes a sham affiliated business arrangement. The commission shall adopt the rules, policies, or guidelines issued by the United States Department of Housing and Urban Development concerning the Federal Real Estate Settlement Procedures Act of 1974, as amended at 12 U.S.C. Section 2601, et cetera. Rules adopted by the commission shall be at least as stringent as the federal rules and shall ensure that consumers are adequately informed about affiliated business arrangements. The commission shall consult with the Insurance Commissioner pursuant to Section 1011-124-2 strike CRS unstrike concerning rules, policies, or guidelines the Insurance Commissioner adopts concerning affiliated business arrangements. Neither the rules promulgated by the Insurance Commissioner nor the strike real estate unstrike commission may create a conflicting regulatory burden of an affiliated business arrangement. 6, the Division of Real Estate may share information gathered during an investigation on an affiliated business arrangement with the Division of Insurance. 1210-219, formerly 1261-114. Hearing administrative law judge review rules. 1. Except as otherwise provided in this section, all proceedings before the commission with respect to disciplinary actions and denial of licensure under this part strike 1, unstrike 2, and part strike 8, unstrike 4 of this Article 10 and certifications issued under part strike 4 and strike 5 of this Article 10 shall be conducted by an administrative law judge pursuant to the provisions of sections 24.4104 and 24.4105, strike CRS unstrike 2, strike such unstrike. The proceedings shall be held in the county where the commission has its office or in such other place as the commission may designate. If the licensee is an employed broker, the commission shall also notify the broker employing the licensee by mailing by first-class mail a copy of the written notice required under section 24.4104.3, strike CRS on strike to the employing broker's last known business address. 3. An administrative law judge shall conduct all hearings for denying, suspending, or revoking a license or certificate on behalf of the commission, subject to appropriations made to the Department of Personnel. Each administrative law judge shall be appointed pursuant to Part 10 of Article 30 of Title 24, strike CRS on strike. The administrative law judge shall conduct the hearing pursuant to the provisions of Section 24.4104 and 24.4105, strike CRS on strike. No license shall be denied, suspended, or revoked until the commission has made its decision by a majority vote for the decision. The commission in any disciplinary action or denial of licensure under the section is subject to review by the Court of Appeals by appropriate proceedings under Section 24.4106.11 in order to effectuate the purpose of parts strike 1, 4, and 8 on strike 2, 4, and 5 of this Article strike 61, unstrike 10 to the commission has the power to promulgate rules pursuant to Article 4, Title 24. The commission may appear in court by its own attorney. By pursuant strike said, unstrike the proceeding. The court has the right in decision to stay the execution of effective and final order of the commission, but a hearing shall be held affording the parties an opportunity to be heard of the purpose of determining whether the public health, safety, and welfare would be endangered by staying the commission's order. If the court determines that the order should be stayed, it shall also determine at strike said, unstrike the hearing the amount bond adequacy of the surety, which bond shall be conditioned upon the favorable performance by strike such unstrike the petitioner of all obligations, real estate broker, and upon the prompt payment of all damages arising from or caused by delay in taking effect of or enforcement of the order complained of, and for all costs that may be assessed or required paid in connection with strike such unstrike the proceedings. 6. In the hearing conducted in the commission which there is a possibility of a denial, suspension, or revocation of a license because of the conviction of a felony or crime involved in moral turpitude, the commission shall be governed by the provision of section 24.5101, strike CRS on strike 12.10.220, formerly 1261.114.5. Rules. All rules adopted or amended by the commission are subject to sections 24.4103.8C and 8D and 24.34.104.6B. Strike CRS on strike 12.10.221, formerly 1261.117, broker remuneration. It is unlawful for a real estate broker registered in the commission office as in the employ of another broker to accept a commission or valuable consideration of performance. Any of the acts specified in this part, strike 1 on strike 2, from any person except the broker's employer, who shall be a licensed real estate broker. 12.10.222. Formerly 1261.118. Acts of third parties, broker liability. Any unlawful act or violation of any of the provisions of this part, strike 1, unstrike 2, upon the part of an employee, officer, or a member of a licensed real estate broker shall not be cause for disciplinary action against the real estate broker unless it appears to the satisfaction of the commission that the real estate broker has had actual knowledge of the unlawful act or violation and have been in negligent supervision of employees. 12.10.223, formerly 1261.119, violations. Any natural person, firm, partnership, limited liability company, association, or corporation violating the provisions of this part, strike 1, unstrike 2, by acting as real estate broker in this state without having obtained a license or by acting as a real estate broker after the broker's license has been revoked or during any period for which strike said unstrike the license may have been suspended is guilty of a misdemeanor and upon conviction thereof, if a natural person shall be punished by a fine of not more than $500 or by imprisonment in the county jail for not more than 6 months or by both such fine and imprisonment, and if an entity shall be punished by a fine of not more than $5,000, the second violation, if by a natural person, shall be punishable by a fine of not more than $1,000 or by imprisonment in the county jail for not more than 6 months or by both such fine and imprisonment. 12.10.224, formerly 1261.120, subpoena compelling attendance of witnesses and production of records and documents. The commission, the director, strike for the commission on strike, or the administrative law judge appointed for a hearing may issue a subpoena compelling the attendance and testimony of witnesses and the production of books. papers, or records pursuant to an investigation or hearing of strike such, unstrike, the commission strike such, unstrike. The subpoena shall be served in the same manner as subpoenas issued by district courts and shall be issued without discrimination between public or private parties, requiring the attendance of witnesses and the production of documents at hearings. If a person fails or refuses to obey a subpoena issued by the commission, the director, or the appointed administrative law judge, the commission may petition the district court having jurisdiction for issuance of a subpoena in the premises, and the court shall, in a proper case, issue a subpoena. Any person who refuses to obey strike such, unstrike, a subpoena shall be punished as provided in section strike 1261-121, unstrike 1210-225, 1210-225, formerly 1261-121, failure to obey subpoena penalty. Any person who willfully fails or neglects to appear and testify or to produce books, papers, or records required by subpoena duly served upon him or her in any matter conducted under part strike 1 unstrike 2 and strike 4 unstrike 5 of this article, strike 61 unstrike 10, is guilty of a misdemeanor and upon conviction thereof shall be punished by a fine of $25 or imprisoned in the county jail for not more than 30 days for each such offense, or by both such fine and imprisonment each day strike such, unstrike a person so refuses or neglects constitutes a separate offense. 1210-226, formerly 1261-122. Powers of commission, injunctions. The commission may apply to a court of competent jurisdiction for an order enjoining any act or practice that constitutes a violation of parts strike 1 and 4 and strike 2 and 5 of this article, strike 61 on strike 10, and upon a showing that a person is engaged or intends to engage in any such act or practice. Injunction, restraining order, or other appropriate order shall be granted by strike such, unstrike the court, regardless of the existence of another remedy. Therefore, any notice, hearing, or duration of any injunction or restraining order shall be made in accordance with the provision of the Colorado Rules of Civil Procedure 1210-227, formerly 1261-123, repeal of part. This part, strike 1 on strike 2, is repealed effective September 1st, 2026. Before strike, it's unstrike the repeal, the strike real estate unstrike division, including the strike real estate unstrike commission. Strike shall be reviewed. Unstrike is scheduled for review in accordance with section 2434-104, part 3, brokers' commissions. 1210-301, formerly 1261-201, when entitled to commission, no real estate agent or broker is entitled to commission for finding a purchaser who is ready, willing, and able to complete the purchase of real estate as proposed by the owner until the same is consummated or is defeated by the refusal or neglect of the owner to consummate the same as agreed upon. 1210-302, formerly 1261-202. Objections on account of title. No real estate agent or broker is entitled to commission when a proposed purchaser fails or refuses to complete his or her contract of purchase because of defects in the title of the owner, unless strike such, unstrike the owner within a reasonable time has strike said, unstrike the defects corrected by legal proceedings, or otherwise. 1210-303, formerly 1261-203, when owner must perfect title. The owner shall not be required to begin legal or other proceedings for the correction of strike such, unstrike a title until strike such, unstrike the agent or broker secures from the proposed purchaser an enforceable contract in writing binding him or her to complete the purchase whenever the defects in the title are corrected. 1210-304, formerly 1261-203.5, referral fees, conformity with federal law required. Remedies for violation. Definitions. 1A, person licensed under strike parts 1 to 4, unstrike parts 2, 3, or 5 of this Article 10 shall not pay or receive a referral fee except in accordance with the Federal Real Estate Settlement Procedures Act of 1974 as amended 12 U.S.C. Section 2601 and secondary, and unless reasonable cause for payment of the referral fee exists. A reasonable cause for payment means A, an actual introduction of business has been made, B, a contractual referral fee relationship exists, or C, a contractual cooperative brokerage relationship exists. 2A, no person shall interfere with a brokerage relationship of a licensee, B, as used in the subsection 2. 1. Brokerage relationship means a relationship entered into between a broker and a buyer, seller, landlord, and tenant under which the broker engages in any of the acts set forth in section strike 1261-101-2, unstrike 1210-201-6. A brokerage relationship is not established until a written brokerage agreement is entered into between the parties or is otherwise established by law. 2. Strike interference, unstrike. Interfere with a brokerage relationship means demanding a referral fee from a license without reasonable cause. 3. Referral fee means any fee paid by the licensee to a person or entity other than a cooperative commission offered by a listing broker to a selling broker or vice versa. 3. Any person aggrieved by violation of any provision of this section may bring a civil action in a court of competent jurisdiction. The prevailing party in any such action shall be entitled to actual damages. In addition, the court may award an amount up to 3 times the amount of actual damages sustained as a result of any such violation, plus reasonable attorney fees. 1210-305, formerly 1261-204, repeal of part. This part, strike 2, unstrike 3 is repealed effective September 1st, 2026. Before strike it's unstrike the repeal. The part strike 2 unstrike 3 is scheduled for review in accordance with section 2434-104 part 4 brokers relationships. 1210-401, formerly 1261-801, the legislative declaration. 1. The General Assembly finds, determines, and declares that the public will best be served through a better understanding of the public's legal and working relationships with real estate brokers, and by being able to engage any such real estate broker on terms and under conditions that the public and the real estate broker find acceptable. This includes engaging a broker as a single agent or transaction broker. Individual members of the public should not be exposed to liability for acts or omissions of real estate brokers that have not been approved, directed, or ratified by strike such unstrike the individuals. Further, the public should be advised of the general duties, obligations, and responsibilities of the real estate broker they engage to. This part strike 8 unstrike 4 is enacted to govern the relationships between the real estate brokers and sellers, landlords, buyers, and tenants in real estate transactions. 1210-402, formerly 1261-802 definitions. As used in this part, strike 8 unstrike 4 unless the context otherwise requires. 1. Brokers shall have the same meaning as set forth in section strike 1261-101. 2 unstrike 1210-2016 except as otherwise specified in this part. Strike 8 unstrike 4. Strike 1.3 unstrike 2. Customer means any part of a real estate transaction with whom the broker has no broker's relation. Because strike such the unstrike party has not engaged or employed a broker. Strike 1.5 unstrike 3a. Designated broker means an employing broker or employed broker who is designated in writing by an employing broker to serve as a single agent or transaction broker for a seller, landlord, buyer, or tenant in a real estate transaction. B. Designated broker does not include a real estate brokerage firm that consists of only one licensed natural person. Strike 2 unstrike 4. Dual agent means a broker who, with the written informed consent of all parties that have contemplated real estate transaction, is engaged as a limited agent for both the seller and buyer or both the landlord and tenant. Strike 3 unstrike 5. Limited agent means an agent whose duties and obligations to principal are only those set forth in section strike 1261-804 unstrike 1210-404 or strike 1261-805 unstrike 1210-405 with any additional duties and obligations agreed to pursuant to section strike 1261-8035 unstrike 1210-4035. Strike 4 unstrike 6. Single agent means a broker who is engaged by and represents only one party in a real estate transaction. A single agent includes the following: A. Buyer's agent, which means a broker who is engaged by and represents the buyer in a real estate transaction. B. Landlord's agent, which means a broker who is engaged by and represents the landlord in a leasing transaction. C. Seller agent, which means a broker who is engaged by and represents the seller in a real estate transaction. And D. Tenant's agent, which means a broker who is engaged by and represents the tenant in a leasing transaction. Strike 5 unstrike 7. Sub-agent means a broker engaged to act for another broker and perform broker's tasks for a principal. The sub-agent owes the same obligations and responsibilities to the principal as does the principal's broker. Strike 6 unstrike 8. The transaction broker means a broker who assisted one or more parties throughout a contemplated real estate transaction with communication, interposition, advisement, negotiation, and contract terms, and the closing of strike such unstrike the real estate transaction without being an agent or advocate for the interests of any party. To strike such unstrike the transaction upon agreement in writing pursuant to section strike 1261-803-2 unstrike 1210-4032 or a written disclosure pursuant to section strike 1261-808-2D unstrike 1210-408. 2C, a transaction broker may become a single agent. 1210-403, formerly 1261-803, relationships between brokers and the public. Definition rules: 1. When engaged in any of the activities enumerated in section strike 1261-101-2 unstrike 1210-2016, a broker may act in any transaction as a single agent or transaction broker. The broker's general duties and obligations arising from that relationship shall be disclosed to the seller and the buyer and the landlord in pursuant to section strike 1261-808 unstrike 1210-408. 2. A broker shall be considered a transaction broker unless a single agency relationship is established through a written agreement between the broker and the party, and the parties represented by strike such unstrike the broker. 3. A broker may work with a single party in separate transactions pursuant to a different relationship, including but not limited to selling one property as a seller's agent, working with the seller, and buying another property as a transaction broker or buyer's agent, but only if the broker complies with this part strike 8 unstrike 4 and establishing the relation for each transaction for a broker license pursuant to part strike 1 unstrike 2 with this article 10, whether acting as a single agent or transaction broker may complete standard forms for use in real estate transactions, including standard forms intended to convey personal property as part of the real estate transaction when a broker is performing the activities enumerated or referred to in section strike 1261-101-2 unstrike 1210-2016 in the transaction. B, as used in the subsection 4, standard form means 1. A form promulgated by the Real Estate Commission for current use by brokers, also referred by the section as a commission-approved form. 2. A form drafted by a licensed Colorado attorney representing the broker, employing broker, or broker's firm, so long as the name of the attorney, the law firm, the name of the broker, employing broker, or broker's firm for whom is prepared or included by the form itself. 3, a form provided by the party of the transaction. The broker is acting in the transaction as either a transaction broker or as a single agent for a party providing the form to the broker, so long as the broker retains written confirmation that the form is provided by a party to the transaction. 4, a form prescribed by a governmental agency, a quasi-governmental agency, or a lender regulated by the state or federal law. If use of the form is mandated by strike such, unstrike the agency or lender. 5, a form issued with written approval of the Colorado Bar Association of the successor organization and specifically designated for use by brokers of Colorado, so long as the form is used within any guidelines or conditions specified by the Colorado Bar Association or successor organization in connection with the use of the form. 6, a form used for disclosure purposes only if the disclosure does not purport to waive or create any legal rights or obligations affecting a part of the transaction. If the form provides only information concerning either A, the real estate involved in the transaction specifically, or B, the geographic area in which the real estate is located generally. 7, a form prescribed by a title company that is providing closing services to access for its brokers acting either as a transaction broker or a single agent for a party to the transaction. Or 8, a letter of intent created or prepared by a broker employing broker or brokerage firm, so long as letter of intent states on its face that it is non-binding and creates no legal rights or obligations. C, broker shall use a commission-approved form when such a form exists and is appropriate for the transaction. Of broker's use of any standard form described in subsection 4B3 or 4B4 of this section must be limited to inserting transaction-specific information within the form and using standard forms described in subsection 4B2, 4B5, 4B6, 4B7, or 4B8 of this section. The broker may also advise the parties as to effects thereof, and the broker's use of those standard forms must be appropriate for the transaction and the circumstances in which they are used. In any transaction described in the subsection 4, the broker shall be advised the parties that forms have important legal consequences, and the parties should consult legal counsel before signing, strike such, unstrike the forms. 5, nothing contained in this section shall prohibit the public from entering into written contracts with any broker, strike which, unstrike that contain duties, obligations, responsibilities, strike which, unstrike that are in addition to those specified in this part, strike 8, unstrike 4. 6A, if a real estate brokerage firm has more than one licensed natural person, the employing broker of an individual broker employed or engaged by the employing broker shall be designated to work with the seller, landlord, buyer, or tenant as a designated broker. The employing broker may designate more than one of its original brokers of individual brokers to work with the seller, landlord, buyer, or tenant. Be the brokerage relationship established between the seller, landlord, buyer, or tenant and a designated broker, including the duties, obligations, responsibilities of that relationship, shall not extend to the employing broker, nor to any broker employed or engaged by that employing broker who has not been so designated, and shall not extend to the firm, partnership, limited liability company, association, corporation, or other entity that employs, strike such, unstrike the broker. C, a real estate broker may have designated brokers working as single agents for a seller or landlord and a buyer or tenant in the same real estate transaction without creating dual agency for its employing real estate broker or any broker employed or engaged by that employing real estate broker. D, an individual broker may be designated to work for both a seller or landlord and a buyer or tenant in the same transaction as a transaction broker for both, as a single agent for the seller and landlord, treating the buyer or tenant as a customer, as a single agent for buyer or tenant, treating the seller or landlord as a customer, but not as a single agent for both. The applicable designated broker relationship shall be disclosed in writing to the seller, landlord, and buyer or tenant in a timely manner pursuant to rules promulgated by the Real Estate Commission. E, a designated broker may work with a seller or landlord in one transaction and work with a buyer or tenant in another transaction. F, when a designated broker serves as a single agent pursuant to section strike 1261.804 on strike 1210.404 or strike 1261.805 on strike 1210.405, there shall be no imputation of knowledge to the employing or employed broker who has not been so designated. G, the extent and limitations of the broker's relationship with a designated broker shall be disclosed to the seller, landlord, buyer, or tenant working with a designated broker pursuant to section strike 1261.808 on strike 1210.4087. No seller, buyer, landlord, or tenant shall be vicariously liable for brokers' acts or omissions that have not been approved, directed, or ratified by strike such on strike the seller, buyer, landlord, or tenant. Nothing in this section shall be construed to limit the employing brokers or firms' responsibility to supervise licensees employed by the strike, unstrike by the strike, such unstrike the broker or firm, nor the shield strike, such unstrike the broker or firm from vicarious liability.
12-10-404, formerly 1261.804, single agent engaged by seller or landlord. 1. A broker engaged by a seller or landlord to act as a seller's agent or landlord's agent is a limited agent with the following duties and obligations. A, to perform terms of the written agreement made with the seller or landlord. B, to exercise reasonable skills and care for the seller or landlord. C, to promote the interests of the seller or landlord with the utmost good faith, loyalty, and fidelity, including but not limited to Roman numeral 1, seeking your price and terms, strike which that are acceptable to the seller or landlord, except when the broker shall not be obligated to seek additional offers to purchase the property while the property is subject to contract for sale, or to seek additional offers to lease the property while the property is subject to a lease or a letter of intent of lease. Roman numeral 2, presenting all offers to and from the seller or landlord in a timely manner, regardless of whether the property is subject to a contract for sale or a lease or letter of intent to lease. Roman numeral 3, disclosing to the seller or landlord adverse material facts actually known by the broker. Roman numeral 4, counseling the seller or landlord as to any material benefits or risk of a transaction, strike which that are known to an actual broker. Roman numeral 5, advising the seller or landlord to obtain expert advice as to material matters about which the broker knows, but the specifics of which are beyond the expertise of strike such the broker. Roman numeral 6, accounting in a timely manner. In a timely manner for all money and property received. Roman numeral 7, informing the seller or landlord that strike such the seller or landlord may not be vicariously liable for the acts of strike such the seller's or landlord's agent that are not approved, directed, or ratified by strike such the seller or landlord. D, to comply with all requirements of this Article 10 and any rules promulgated pursuant to this Article 10, and E, to comply with any applicable federal, state, or local laws, rules, regulations, or ordinances, including fair housing and civil rights statutes or regulations. 2, the following information shall not be disclosed by a broker acting as the seller's or landlord's agent without the informed consent of the seller or landlord. A, that a seller or landlord is willing to accept less than the asking price of lease rate or of the property. B, what the motivating factors are for the party selling or leasing the property. C, that the seller or landlord would agree to financing terms other than those offered. D, any material information about the seller or landlord unless disclosure is required by law or failure to disclose strike such the information that would constitute fraud or dishonest dealing. Or E, any facts or suspicions regarding circumstances strike which that may psychologically impact or stigmatize any real property pursuant to Section 38, 35.5101, strike CRS. 3A, a broker acting as the seller's landlord or landlord's agent owes no duty or obligation to the buyer or tenant except that a broker shall, subject to limitations of Sections 38, 35.5101, strike CRS, concerning psychologically impacted property, disclose to any prospective buyer or tenants all adverse material facts actually known by strike such the broker. Strike such the adverse material facts may include but not be limited to adverse material facts pertaining to the title and the physical condition of the property, any material defects in the property, and any environmental hazards affecting the property, strike which that are required by law to be disclosed. B, a seller's or landlord's agent owes no duty or conduct an independent inspection of the property for the benefit of the buyer or tenant, and owes no duty or independently verify the accuracy or completeness of any statement made by strike such the seller or landlord or any independent inspector. 4, a seller's or landlord's agent may show alternative properties not owned by strike such the seller or landlord to prospective buyers or tenants, and may list competing properties for sale or lease, and may not be deemed to have breached any duty or obligation to strike such the seller or landlord. 5, a designated broker acting as the seller's or landlord's agent may cooperate with other brokers but may not engage or create any sub-agents. 12-10-4.405, formerly 1261-805, single agent engaged by buyer or tenant. 1, a broker engaged by a buyer or tenant to act as a buyer's or tenant's agent may be limited with the following duties and obligations. A, to perform the terms of the written agreement made with buyer or tenant. B, to exercise reasonable skill and care for the buyer or tenant. C, to promote the interests of the buyer or tenant with the utmost good faith, loyalty, and fidelity, including but not limited to Roman numeral 1, seeking a price and terms strike which that are acceptable to the buyer or tenant, except that the broker shall not be obligated to seek any other properties while the buyer is party to a contract to purchase property, or while the tenant is the party to a lease or letter of intent to lease. Roman numeral 2, presenting all offers to and from the buyer or tenant in a timely manner, regardless of whether the buyer is already a party to the contract to purchase property or the tenant is already a party to a contract or a letter of intent to lease. Roman numeral 3, disclosing to the buyer or tenant adverse material facts actually known by the broker. Roman numeral 4, counseling the buyer or tenant as to any material benefits or risks of a transaction, strike which that are actually known by the broker. Roman numeral 5, advising the buyer or tenant to obtain expert advice as to material matters about which the broker knows, but the specifics of which are beyond the expertise of strike such the broker. Roman numeral 6, accounting in a timely manner for all money and property received. And Roman numeral 7, informing the buyer or tenant that strike such the buyer or tenant shall not be vicariously liable for the acts of strike such the buyers or tenant's agents that are not approved, directed, or ratified by strike such the buyer or tenant. D, to comply with all requirements of this Article 10 and any rules promulgated pursuant to this Article 10. And E, to comply with any applicable federal, state, or local laws, rules, regulations, or ordinances, including fair housing and civil rights statutes or regulations. 2, the following information shall not be disclosed by a broker acting as a buyer's or tenant's agent without the informed consent of the buyer or tenant. And A, that a buyer or tenant is willing to pay more than the purchase price or lease rate for the property. B, what the motivating factors are for the party buying the lease of the property. C, that the buyer or the tenant will agree to financing terms other than those offered. D, any material information about the buyer or tenant unless disclosure is required by law or failure to disclose strikes such the information would constitute fraud or dishonest dealing. Or E, any facts or suspicion regarding circumstances strike which that would psychologically impair or stigmatize any real property pursuant to Section 3835.5101 strike CRS. 3A, a broker acting as a buyer's or tenant's agent owes no duty or obligation to the seller or landlord except that strike such the broker shall disclose any prospective seller or landlord all adverse material facts actually known by the broker, including but not limited to adverse material facts concerning the buyer's or tenant's financial ability to perform the terms of the transaction and whether the buyer intends to occupy the property to be purchased as principal residence. B, a buyer's or tenant's agent owes no duty or conduct an independent investigation of the buyer's or tenant's financial condition for the benefit of the seller or landlord, knows no duty to independently verify the accuracy or completeness of statements made by strike such the buyer or tenant or any independent inspector. 4, a buyer's or tenant's agent may show properties in which the buyer or tenant is interested to other prospective buyers or tenants without breaching any duty or obligation to strike such the buyer or tenant. Nothing in this section shall be construed to prohibit a buyer's or tenant's agent from showing competing buyers or tenants the same property and from assisting competing buyers or tenants in attempting to purchase or lease a particular property. 5, a broker acting as buyer's or tenant's agent owes no duty to conduct an independent inspection of the property for benefit of the buyer or tenant and owes no duty to independently verify the accuracy or completeness of statement made by the seller, landlord, or independent inspectors, except that nothing in this subsection 5 may be construed to limit the broker's duties and obligations imposed pursuant to subsection 1 of this section. 6, a broker's acting as a buyer's or tenant's agent may cooperate with other brokers but may not engage or create any subagents. 1210-406, formerly 1261-806, dual agent. Strike 1. A broker shall not establish dual agency with any seller, landlord, buyer, or tenant. Strike 2 to 6. Deleted amendment L2002, page 1060, section 6, effective January 1, 2003. In strike. 1210-407, formerly 1261-807, transaction broker. 1. A broker engaged as a transaction broker is not an agent for either party. 2. A transaction broker shall have the following obligations and responsibilities. A. To perform the terms of any written or oral agreement made with any party to the transaction. B. To exercise reasonable skill and care as a transaction broker, including but not limited to Roman numeral 1, presenting all offers and counteroffers in a timely manner, regardless of whether the property is subject to contract for sale or lease or letter of intent. Roman numeral 2, advising the parties regarding the transaction and suggesting that strike such the parties obtain advice as to material matters about which the transaction broker knows, but the specifics of which are beyond the expertise of strike such the broker. Roman numeral 3, accounting in a timely manner for all money and property received. Roman numeral 4, keeping the parties fully informed regarding the transaction. Roman numeral 5, assisting the parties in complying with the terms and conditions of any contract, including closing the transaction. Roman numeral 6, disclosing all prospective buyers or tenants any adverse material facts known by the broker, including but not limited to adverse material facts pertaining to the title, the physical condition of the property, and any defects in the property and any environmental hazards affecting the property required by law to be disclosed. Roman numeral 7, disclosing any prospective seller or landlord all adverse material facts known by the broker to be, including but not limited to adverse material facts pertaining to the buyer's or tenant's financial ability to perform the terms of the transaction and the buyer's intent to occupy the property as principal residence. And Roman numeral 8, performing the parties that seller and or buyer or landlord as and tenant, as they shall not be vicariously liable for any acts of the transaction broker. C, to comply with all requirements of this Article 10 and any rules promulgated pursuant to this Article 10. And D, to comply with any applicable federal, state, or local laws, rules, regulations, or ordinances, including fair housing and civil rights statutes and regulations. 3, the following information shall not be disclosed by a transaction broker without the informed consent of all parties. A, that a buyer or tenant is willing to pay more than the purchase price or lease rate offered for that property. B, that a seller or landlord is willing to accept less than the asking price or lease rate for that property. C, what the motivating factors are for any party buying, selling, or leasing the property. D, that a seller, buyer, landlord, or tenant will agree to financing other terms than those offered. E, any facts, suspicions regarding circumstances, strike which, that may psychologically impair or stigmatize any real property pursuant to Section 38, 35.5, 101, strike CRS, or F, any material information about the other parties unless disclosure is required by law or failure to disclose, strike such, the information would constitute fraud or dishonest dealing. 4, a transaction broker has no duty to conduct an independent inspection of the property for benefit of the buyer or tenant and has no duty to independently verify the accuracy or completeness of statements made by the seller, landlord, or independent inspectors. 5, a transaction broker has no duty to conduct an independent investigation of the buyer's or tenant's financial condition or to verify the accuracy or completeness of any statements made by the buyer or tenant. 6, a transaction broker may do the following without breaching any obligation or responsibility. A, show alternative properties not owned by the seller or landlord to his prospective buyer or tenant. B, list competing properties for sale or lease. C, show properties in which the buyer or tenant is interested in other prospective buyers or tenants. And D, serve as a single agent or transaction broker for the same or different parties and other real estate transactions. 7, there should be no imputation of knowledge or information between any party and the transaction broker or among persons within an entity engaged as a transaction broker. 8, a transaction broker may cooperate with the other brokers but shall not engage or create any sub-agents. 1210-408, formerly 1261-808, broker disclosures. 1A, any person, firm, partner, limited liability company, association, or corporation acting as a broker shall adopt a written office policy that identifies and describes the relationships offered to the public by strike such the broker. B, a broker should not be required to offer or engage in any one or in all of the brokerage relationships enumerated in section strike 1261-804, 1261-805, in strike 1210-404, 1210-405, or strike 1261-807, in strike 1210-407. C, written disclosures and agreements required by subsection 2 of this section shall contain a statement to the seller, landlord, buyer, or tenant. The different brokerage relationships are available that include buyer agency, seller agency, or status as a transaction broker. Should the seller, landlord, or buyer, or tenant request information or ask questions concerning a brokerage relationship not offered by the broker pursuant to the broker's written office policy enumerated in section 1A of this section, the broker shall provide to the party a written definition of that brokerage relationship that has been promulgated by the Strike Colorado Real Estate Commission. D, disclosures made in accordance with this part, strike 8.4, shall be sufficient to disclose brokerage relationships to the public. 2A, Roman numeral 1, prior to engaging any of the activities enumerated in section strikes 1261-101-2, in strike 1210-2016, a transaction broker shall disclose in writing to the party to be assisted that strike such the broker is not acting an agent for strike such the party and that strike such the broker is acting as a transaction broker. Roman numeral 2, as part of each relationship entered into by a broker pursuant to strike subparagraph Roman numeral 1 of this paragraph A and strike subsection 2A Roman numeral 1 of this section, written disclosure shall be made strike which that strike contain a signature block for the buyer, seller, landlord, or tenant to acknowledge the receipt of strike such the disclosure. Strike such the disclosure and the acknowledgement by itself shall not constitute a contract with the broker. If strike such the buyer, seller, landlord, tenant chooses not to sign the acknowledgement, the broker shall note that the fact on a copy of the disclosure and shall retain strike such the copy. Roman numeral 3, if the transaction broker undertakes any obligations or responsibilities in addition to or different from those set forth in section strike 1261-807, such in strike 1210-407, the obligations or responsibilities shall be disclosed in a writing strike which that shall be signed by involved parties. B, prior to engaging in any of the activities enumerated in this section, strike 1261-101-2 and strike 1210-2016, the broker intending to establish a single agency relationship with the seller, landlord, buyer, or tenant shall, in a written agency agreement with the party, be represented. Strike such and strike the agreement shall disclose the duties and responsibilities specified in section strike 1261-804 and strike 1210-404 or strike 1261-805 and strike 1210-405 as applicable. Notice of the single agency relationship shall be furnished to prospective party to the proposed transaction in a timely manner. Strike. Prin C deleted by amendment L 2002, page 1061, section 8, effective January 1, 2003. D in strike C, Roman numeral 1. Prior to the engaging in any of the activities enumerated in section strike 1261-101-2 and strike 1210-2016, the broker intending to work with a buyer or tenant as an agent of the seller or landlord shall provide written disclosure to strike such the buyer or tenant that shall contain the following. A statement that the broker is an agent for the seller or the landlord is not an agent for a buyer or tenant. B, a list of the tasks that the agent intends to perform for the seller or landlord with the buyer or tenant. And C, a statement that the buyer or tenant shall not vicariously liable for the acts of this agent unless the buyer or tenant approves, directs, or ratifies strike such the acts. Roman numeral 2, the written disclosure pursuant to strike subparagraph Roman numeral 1 of this paragraph D in strike subsection 2C Roman numeral 1 of this section shall contain a signature block for the buyer or tenant to acknowledge receipt of strike such the disclosure in strike or strike such. The disclosure and acknowledgement by itself shall not constitute a contract with the broker. If the buyer or tenant does not sign strike such the disclosure, the broker shall note that fact on a copy of strike such the disclosure and retain strike such the copy. Strike C, deleted by Amendment L 2002, page 1061, Section 8, effective January 1, 2003. F, in strike D. A broker who has already established a relationship with one party to a proposed transaction shall advise at the earliest reasonable opportunity and any other potential parties or their agents of strike such the established relationship. Strike G, in strike. E, Roman numeral 1, prior to the engaging of any activities enumerated in Section strike 1261-1012, in strike 1210-2016, the seller, buyer, landlord, or tenant shall be advised in any written agreement with broker that the brokerage relationship exists only within the designated broker, does not extend to the employing broker, to the other brokers employed or engaged by the employing broker who are not so designated, and does not extend to the brokerage company. Roman numeral 2, nothing in this strike paragraph G and strike subsection 2E shall be construed to limit the employing brokers or firms' responsibility to supervise licensees employed by strike such the broker or firm, nor to shield strike such the broker or firm from vicarious liability. 1210-409, formerly 1261-809, duration of relationship. 1A, the relationship set forth in this strike 8-4 shall commence at the time that the broker is engaged by a party and shall continue until the performance or completion of the agreement by which the broker is engaged. B, if the agreement by which the broker is engaged is not performed or completed for any reason, the relationship shall end at the earlier of the following. Roman numeral 1, any date of expiration agreed upon by the parties. Roman numeral 2, any termination or relinquishment of the relationship by the parties. Or Roman numeral 3, 1 year after the date of engagement. 2A, except as otherwise agreed to in writing and pursuant to strike paragraph B of this subsection 2 and strike subsection 2B of this section, a broker engaged as a seller's agent or buyer's agent owes no further duty or obligation after termination or expiration of the contract or completion of performance. B, notwithstanding strike paragraph A of the subsection 2 and strike subsection 2A of this section, a broker shall be responsible after the termination or expiration of the contract or completion of performance of the following. Roman numeral 1, accounting for all strike monies, money, and property related to and received during the engagement, and Roman numeral 2, keeping confidential all information received during the course of engagement, strike which that was made confidential by request or instructions from the engaging party unless A, the engaging party grants written consent to disclose strike such the information, B, disclosure of strike such the information is required by law, or C, the information is made public or becomes public by the words of conduct or of the engaging party or from a source other than the broker. 3, except as otherwise agreed to in writing, and transaction broker owes no further obligation or responsibility to the engaging party after the termination or expiration of the contract for performance or completion of performance, except that strike such the broker shall account for all monies, strike money, and property related to and received during the engagement. 1210-410, formerly 1261-810, compensation. 1, in any real estate transaction, the broker's compensation may be paid by the seller, the buyer, the landlord, the tenant, a third party, or the sharing or splitting of a commission or compensation between brokers. 2, payment of compensation shall not be construed to establish an agency relationship between the broker and the party who paid strike such the compensation. 3, a seller or landlord may agree that transaction broker or single agent may share the commission or other compensation paid by strike such the seller or landlord with another broker. 4, a buyer or tenant may agree that a single agent or transaction broker may share the commission or other compensation paid by strike such the buyer or tenant with another broker. 5, a buyer's or tenant's agents shall obtain the written approval of strike such the buyer or tenant before strike such the agent may propose the seller's or landlord's agent that strike such the buyer's or tenant's agent may be compensated by sharing compensation paid by strike such the seller or landlord. 6, prior to entering into a brokerage agreement or listing agreement or a contract to buy, sell, or lease, the identity of those parties, persons, or entities paying the compensation or commissions to any broker shall be disclosed to the parties in the transaction. 7, a broker may be compensated by more than one party for services in a transaction if those parties have consented in writing to such multiple payments prior to entering into a contract to buy, sell, or lease. 1210-411, formerly 1261-811, violations. The violation of any provision of this part, strike 8. 4, by a broker constitutes an act pursuant to section strike 1261-113-1K and strike 1210-217-1M, for which the Real Estate Commission may investigate and take administrative action against any broker pursuant to section strike 1261-113 in strike 1210-217 and strike 1261-114 and strike 1210-219. Part 5, subdivisions. 1210-501, formerly 1261-401, definitions. As used in this part, strike 4-5, unless the context otherwise requires. 1, quote, commission, means the real estate commission established under section strike 1261-105 and strike 1210-206. 2, quote, developer, means any person as defined in section 24401-8, strike CRS, which, in strike that, participates as owner, promoter, or sales agent in the promotion, sale, or lease of a subdivision or any part thereof. Strike 2.5 HOA or homeowners association means an association or unit owners association formed on or after July 1, 1992 as part of a common interest community and defined in sections 38, 33.5, 103 CRS in strike. 3A, quote, subdivision means any real property divided into 20 or more interests intended solely for residential use and offered for sale, lease, or transfer. B, Roman numeral 1, the term, quote, subdivision also includes A, the conversion of an existing structure into a common interest community as defined in Article 33.3 of Title 38 of 20 or more residential units, strike as defined in Article 33.3 of Title 38 CRS, and strike. B, a group of 20 or more timeshares intended for residential use, and C, a group of 20 or more proprietary leases in a cooperative housing corporation as strike defined described in Article 33.5 of Title 38, strike CRS. 2, a term, quote, subdivision does not include A, the selling of membership in campgrounds, B, bulk sales and transfers between developers, C, property upon which there has been or there will be erected residential buildings that have not previously occupied and where the consideration paid for strike such the property includes the cost of strike such the buildings. D, lot strike which that at the time of closing of a sale or occupancy under a lease are situated on a street or road and a street or road system improved to standards at least equal to streets and roads maintained by the county, city, or town in which the lots are located, have a feasible plan provided to potable water and sewage disposal, and have telephone and electricity facilities and systems adequate to serve the lots, which the facilities and systems are installed and in place on the lots in a street or road or easement adjacent to the lots in which the facilities and systems comply with applicable state, county, municipal, or other local laws, rules, and regulations, or any subdivision that has been or is required to be approved after September 1, 1972 by a regional, county, or municipal planning authority pursuant to Article 28 of Title 30 or Article 23 of Title 31, strike CRS. E, sales by public officials in the official conduct of their duties. 4, quote, timeshare means a timeshare estate is defined in Section 38, 33, 110.5, strike CRS, or a timeshare use, but the term does not include group reservations made for convention purposes as a single transaction with a hotel, motel, or condominium owner or association for the purposes of this subsection 4. Quote, timeshare use, end quote, means contractual or membership right of occupancy, strike which that cannot be terminated by the will of the owner for life or for a term of years to their current exclusive use or occupancy of a lot, parcel, unit, or specific segment of real property annually or on some other periodic basis for a period of time that has been or will be allotted from the use of the occupancy of the periods into which the property has been divided. 1210-502, formerly 1261-402, registration required. 1, unless exempt under these provisions of section strike 1261-4013 and strike 1210-5013, a developer before selling, leasing, or transferring or agreeing to negotiating to sell, lease, or transfer directly or indirectly any subdivision or any part thereof shall register pursuant to this part, strike 4, section 5. 2, upon approval of the commission, a developer who has applied for registration pursuant to strike section 1261-403 and strike 1210-503 may offer reservations in a subdivision during the pendency of strike such the application and until strike such the application is granted or denied if the fees for strike such the reservations are held in trust by an independent third party and are fully refundable. 1210-503, formerly 1261-403, application for registration. 1. Every person who is required to register as a developer under this part, strike 4-5, shall submit to the Commission an application, strike which, that contains the information described in subsections 2 and 3 of this section. If strike such, the information is not submitted, the Commission may deny the application for registration. If a developer is currently regulated in another state and has registration requirements substantially equivalent to the requirements of this part, strike 4, section 5, or that provides substantially comparable protection to a purchaser, the Commission may accept proof of strike such the registration, along with the developer's disclosure or equivalent statement from other state in full or in partial satisfaction of the information required by the section. In addition, the applicant shall be under continuing obligation to notify the Commission within 10 days of any change in the information so submitted, and if failure to do so shall be cause for disciplinary action. 2A, registration information concerning the developer shall include Roman numeral 1, the principal office of the applicant wherever situate. Roman numeral 2, the location of the principal office and the branch offices of the applicant in this state. Strike Roman numeral 3, repealed. Strike Roman numeral 4, Roman numeral 3, the names and residences and business addresses of all the natural persons who have a 24% or greater financial ultimate beneficial interest in the business of the developer, either directly or indirectly as principal, manager, member, partner, officer, director, or stockholder, specifying each such person's capacity, title, and percentage of ownership. If no natural person has a 24% or greater financial or beneficial interest in the business of the developer, the information required in this strike, subparagraph 4, in strike, subsection 2A, Roman numeral 3, shall be submitted regarding the natural person having the largest single financial or beneficial interest. Strike Roman numeral 5, Roman numeral 4, the length of time and the locations where the applicant has been engaged in the business of real estate sales or development. Strike Roman numeral 4, Roman numeral 5, any felony of which the applicant has been convicted within the preceding 10 years, and determining whether a certificate of registration shall be issued in an applicant who has been convicted of a felony within such a period of time. The Commission shall be governed by the provisions of Section 24.5101, strike CRS. Strike Roman numeral 6, Roman numeral, strike Roman numeral 7, Roman numeral 6. The states in which this applicant has had a license or registration similar to the developer's registration in the state granted, refused, suspended, or revoked, or is currently the subject of an investigation or charges that could result in refusal, suspension, or revocation. Strike Roman numeral 8, Roman numeral 7. Whether the developer or any other person financially interested in the business of the developer as principal, partner, officer, director, or stockholder has engaged in any activity that would constitute a violation of this part, strike 4-5. B. If the applicant is a corporate developer, a copy of the certificate of authority to do business in this state or certificate of incorporation issued by the Secretary of State shall accompany the application. 3. Registration information concerning the subdivision shall include A. The location of each subdivision from which sales are intended to be made. B. The name of each subdivision and the trade, corporate, or partnership name used by the developer. C. Evidence or certification that each subdivision offered for sale or lease is registered or will be registered in accordance with state or local requirements of the state in which each subdivision is located. D. Copies of documents evidencing the title or other interests in the subdivision. E. If there is a blanket encumbrance upon the title of the subdivision or any other ownership, leasehold, or contractual interest that could defeat all possessory or ownership rights of a purchaser, a copy of the instruments creating strike such the liens, encumbrances, or interests with dates as to the recording, along with documentary evidence that any beneficiary, mortgagee, or trustee of a deed of trust or any of the other holders strike such the ownership, leasehold, or contractual interest will release any lot or time share from the blanket encumbrance or has subordinated its interest in the subdivision to the interest of any purchaser, has established any other arrangement acceptable to the Strike Real Estate Commission that protects the rights of the purchaser. F. A statement that standard commission approved forms will be used for contract sale, notes, deeds, and other legal documents to effectuate the sale or lease of the subdivision or any part thereof, unless the forms be used were prepared by an attorney representing the developer. G. A true statement by the developer that in any conveyance by means of installment contract, the purchaser shall be advised to record the contract with the proper authorities in the jurisdiction in which the subdivision is located. In no event shall any developer specifically prohibit the recording of the installment contract. H. A true statement by the developer of the provisions for and ability of legal access, sewage disposal, and public utilities, including water, electricity, gas, and telephone facilities, in the subdivision offered for sale or lease, including whether such are to be developer or purchase expense. I, a true statement as to whether or not a survey of each lot, site, or tract offered for sale or lease from strike such the subdivision has been made and whether survey monuments are in place. Strike I.5J, a true statement by the developer as to whether or not a common interest community is to be or has been created within the subdivision and whether or not such the common interest community is or will be a small cooperative or small and limited expanse planned by a community created pursuant to 3833.3 strike CRS.
Strike J on strike K, a true statement by the developer concerning the existence of any common interest community association, including whether the developer controls funds and strikes such on strike the association. Strike 3.5 on strike 4. The Commission may disapprove the form of the document submitted pursuant to strike paragraph F of subsection 3 on strike subsection 3F of this section and may deny an application for registration until such time as the applicant submits strike such on strike the documents. In a form that is satisfactory to the Commission, strike 4, repeal on strike 5. Each registration shall be accompanied by fees established pursuant to section strike 1261, 111.5 on strike 1210-215. 1210-504, formerly 1261-404, registration of developers. 1. The Commission shall register applicants who meet the requirement of this Part 4, Strike 4, on Strike 5, and provide each applicant so registered with a certificate including the developer name therein is registered in the state of Colorado and subdivision developer. This developer strike which on strike that will sign as seller or lesser in any contract for sale, lease, or deed purporting to convey any site, tract, lot, or divided or undivided interest from subdivision shall secure certificate before offering, negotiating, or agreeing to sell, lease, or transfer before strike such on strike the sale, lease, or transfer is made. If such person or entity is acting only as a trustee, the beneficial owner of the subdivision shall secure a certificate. A certificate issued by the developer shall entitle all sales agents and employees of strike such on strike the developer to act in the capacity of the developer as agent for strike such on strike the developer. The developer shall be responsible for all actions of strike such on strike the sales agents and employees. 2. All certificates issued under this section shall expire on December 31st, following the date of issuance in the absence of any reason or condition under this part, strike 4 and strike 5. That might warrant the denial or revocation of registration. The certificate shall be renewed by payment of a renewal fee established pursuant to section strike 1261 111.5 on strike 1210-215. A registration that has expired may be reinstated within 2 years after strike such on strike the expiration upon payment of the appropriate renewal fee if the applicant meets all of the requirements of this part, strike 4 and strike 5. All fees collected under this part, strike 4 and strike 5, shall be deposited in accordance with section strike 1261 111 on strike 1210-214 for regarding any subdivision which the information required by section strike 1261 4033 on strike 1210-503 has not been previously submitted to the Commission. Each registered developer shall register strike such on strike the subdivision, providing the Commission with strike such on strike the information before sale, lease, or transfer, negotiation, or agreeing to sell, lease, or transfer any subdivision or any part thereof. 1210-505, formerly 1261-405, refusal, revocation, or suspension of registration, letter of admonition, probation. 1. The Commission may impose an administrative fine not to exceed $2,500 for each separate offense, may issue a letter of admonition, may place a registrant on probation under its close supervision on such terms for such time as it deems appropriate, and may refuse, revoke, or suspend the registration of the developer or registrant if after an investigation and after notice and hearing pursuant to the provisions of section 244104 strike CRS on strike the Commission determines that the developer of any director, officer, or stockholder with controlling interest in the corporation A has used false, misleading advertising or has made a false or misleading statement or a concealment in his or her application for registration. B, has misrepresented or concealed any material fact from a purchaser of any interest in a subdivision. C, has employed any device, scheme, or artifice with intent to defraud a purchaser in interest in a subdivision. D, has been convicted of, pled guilty to, no contender on a crime involving fraud, deception, false pretense, theft, misrepresentation, false advertising, or dishonest dealing in any court. E, has disposed of, concealed, diverted, converted, or otherwise failed to account for any funds or assets of a purchaser in any interest in a subdivision, homeowners association under the control of strike such on strike the developer or director, officer, or stockholder. F, have failed to comply with any stipulation agreement made with the Commission. Has failed to comply with or violated provisions of Article 10, including and failed to comply with the registration requirements of Section Strike 1261 403 on Strike 1210 503 or any lawful rule, strike, or regulation on strike promulgated by the Commission under this Article 10, strike H, deleted by Amendment L, 89, page 740, Section 17, effective July 1st, 1989, on strike I on strike H has refused to honor the buyer's request to cancel the contract for the purchase of the timeshare or subdivision or part thereof. If strike such on strike, the request was made within 5 calendar days after execution of the contract and was made either by telegram, mail, or hand delivery. A request is considered made if by electronic mail, when sent, if by mail, when postmarked, strike if by telegram, when filed for telegraphic transmission on strike, or if by hand delivery when delivered to the seller's place of business. No developer shall employ a contract that contains a provision waiving a buyer's right to such a cancellation period. Strike J on strike I has committed any acts constitutes a violation of the Colorado Consumer Protection Act. Article 1 of Title 6, strike CRS on strike. Strike K on strike J is employed any sales agent or employee who violates the provision of this part. Strike 4 on strike 5. Strike L on strike K has used documents for sales of these transactions other than those described in section strike 12-614033F on strike 12-10-5033F. Strike M on strike L has failed to disclose encumbrances to prospective purchaser or has failed to transfer a clear title at the time of sale. If the parties agree that strike such on strike, the transfer will be made at the time. Strike 1.5 on strike 2, a disciplinary action relating to the business of subdivision development taken by any other state or local jurisdiction of the federal government shall be deemed to be prima facie evidence of grounds for disciplinary action, including denial of registration under this part. Strike 4 on strike 5. This subsection, strike 1.5 on strike 2, shall apply only to such disciplinary actions as are substantially similar to those set on the grounds for disciplinary action or denial of registration under this part. Strike 4 on strike 5, strike 2 on strike 3. Any hearing held under this section shall be in accordance with the procedures established in section 244105 and 244106. Strike CRS on strike 2.5 on strike 4. When a complaint or investigation discloses an instance of misconduct that, in the opinion of the Commission, does not initially warrant formal action by the Commission, but strike which on strike that should not be dismissed as being without merit, and the Commission may send a letter of admonition by certified mail, return receipt requested, to the registrant, who is the subject of the complaint or investigation, as a copy thereof. Any person making strike such unstrike the complaint, strike such unstrike the letter shall advise the registrant that he or she has the right to request in writing within 20 days after proven receipt that formal disciplinary proceedings be initiated against him or her to adjudicate the propriety of the conduct upon which the letter of admonition is based. If strike such on strike the request is timely made, the letter of admonition shall be deemed vacated and the matter shall be processed by means of formal disciplinary proceedings. Strike 3 on strike 5. All administrative fines collected pursuant to this section shall be transmitted to the State Treasurer, who shall credit the same to the Division of Real Estate Cash Fund. 12-10-506, formerly 12-61-406, Powers of Commission Injunction Rules. 1. The Commission may apply to a court of competent jurisdiction for an order enjoining any act or practice, strike which unstrike that constitutes a violation of this part. Strike 4 on strike 5, and a report showing that a person is engaging or intends to engage in any such act or practice. An injunction, restraining order, or other appropriate order shall be granted by strike such on strike the corporate glorious of existence of another remedy. Therefore, any notice, hearing, or duration or any injunction, restraining order shall be made in accordance with the provisions of the Colorado Rules of Civil Procedure. Strike 1.2 on strike 2. The Commission shall apply to a court of competent jurisdiction for the appointment of receiver who determines that strike such on strike the appointment is necessary to protect the property or interests of purchasers of a subdivision or part thereof. Strike 1.5 on strike 3. The Commission shall issue or deny a certificate or additional registration within 60 days from the date of receipt of the application by the Commission. The Commission may make necessary investigations, especially to determine whether any developer has violated this part. Strike 4 on strike 5, or any lawful rule, strike, or regulation on strike promulgated by the Commission if, after an application by a developer has been submitted pursuant to section strike 12-61-403 on strike 12-10-503, information has been submitted pursuant to section strike 12-61-404 on strike 12-10-504. The Commission determines that an inspection of a subdivision is necessary. It shall complete the inspection within 60 days from the date of filing of the application or information, or the right of inspection is waived, and the lack thereof shall not be grounds for denial of registration. Strike 1.6 on strike for the Commission, the Director. Strike for the Commission, unstrike, or the administrative law judge appointed for a hearing may issue a subpoena compelling the attendance testimony of witnesses, production of books, papers, and works pursuant to investigations or hearing of strike such, unstrike the Commission. Any such subpoena shall be served in the same manner as subpoenas issued by district courts. Strike 2 on strike 5. The Commission has the power to make any rules necessary for the enforcement or administration of this part strike 4, unstrike 5, strike 2.5, unstrike 6. The Commission shall adopt, promulgate, amend, or repeal such rules, strike, and regulations, unstrike as are necessary. 2A, required written disclosure and procedures as provided in subsection strike 3, unstrike 7 of this section to be prescribed and require that the standardized forms be used by any subdivision developers in connection with the sale or lease of the subdivision or part thereof, except as otherwise provided in section strike 12, 614033F, unstrike 12, 105033F, and require B, that developers maintain certain business records for a period of at least 7 years. Strike 3. On strike 7, the Commission may require any developer to make written disclosure of purchase on the contract sale by separate written documents. The Commission finds that strike such, unstrike the disclosure necessary for the protection of strike such, unstrike the purchaser. Strike 4. On strike 8, the Commission or its designated representatives may audit the accounts of any strike homeowner, unstrike homeowners association, the funds for which are controlled by developer. 12-10-507, formerly 12-61-407, violation penalty. Any person who fails to register as developer in violation of this part, strike 4 and strike 5, commits class 6 felony and shall be punished as provided in section 18, 1.3401, strike CRS. On strike any agreement or contract for the sale or lease of a subdivision or part thereof shall be voidable by the purchaser and unenforceable of the developer unless strike such. Unstrike the developer was duly registered under the provisions of this part, strike 4, unstrike 5, when strike such, unstrike the agreement or contract was made. 12-10-508, formerly 12-61-408, repealed the part. This part, strike 4, unstrike 5 is repealed effective September 1st, 2026. Before strike, it's unstrike the repealed part. Strike 4, unstrike 5 is scheduled for review in accordance with section 24-34-104. Part 6, real estate appraisers. 12-10-601, formerly 12-61-701, legislative declaration. The General Assembly finds, determines, and declares that sections strike 12-61-702, unstrike 12-10-602 to strike 12-61-723, unstrike 12-10-623 are enacted pursuant to the requirements of the Real Estate Appraisers Reform Amendments, Title 11 of the Federal Financial Institutions Reform, Recovery, and Enforcement Act 1999 as amended. 12 U.S.C. sections 3331 to 3351. The General Assembly further finds, determines, and declares that sections strike 12-61-702, 12-10-602 to strike 12-61-723, unstrike 12-10-623 are intended to implement the requirements of federal law in the last burdensome manner to real estate appraisers and appraisal management companies licensed ad valorem appraisers licensed under this Article 10 are not regulated by the Federal Real Estate Appraisal Reform Amendment. Title 11 of the Federal Financial Institution Reform, Recovery, and Enforcement Act of 1989 is amended in 12 U.S.C. sections 333-31 to 33-51.
12-10-602, formerly 12-61-702. Definitions as used in this part, strike 7, unstrike 6, unless the context requires. Section 1A, appraisal report, or real estate appraisal means a written or oral analysis, opinion, or conclusion relating to the nature, quality, value, or utility of specified interests in or aspects of identified real estate that is transmitted to the client upon the completion of an assignment. These terms include evaluation, which is an opinion of the value of the real estate, and an analysis, which is a general study of real estate not specifically performed only to determine value, except that the terms include evaluation completed by an appraiser, employee of a county assessor as defined in section 39-1-102. 2. Strike CRS. Unstrike. B. The terms do not include an analysis, valuation, opinion, conclusion, notation, or compilation of data by an officer, director, or strike regular, unstrike regularly, salaried employee of a financial institution or its affiliate made for internal use only by financial institutions or affiliate concerning an interest in real estate that is owned or held as collateral by the financial institution or affiliate and is not represented or deemed to be an appraisal except to the financial institution. The agencies regulating the financial institution and any secondary markets that purchase real estate secured loans. An appraisal prepared by an officer, director, or strike regular, unstrike regularly salaried employee of a financial institution who is not licensed or certified under this part, strike 7, unstrike 6, shall contain a written notice that the preparer is not licensed or certified as an appraiser under this part, strike 7, unstrike 6. C. Appraisal report, or real estate appraisal does not include a federally authorized waiver valuation as described in 49 CFR 24.2 A33 as amended. 2A. Appraisal management company, or AMC, means in connection with valuing properties, collateralizing mortgage loans, or mortgages incorporated into securitization, any external third party authorized either by the creditor in a consumer credit transaction secured by a consumer's principal dwelling that oversees an appraiser panel, or by an underwriter of or other principal in the secondary mortgage markets that oversees an appraisal panel. 2. 1. Recruit, select, and train appraisers. 2. contract with licensed and certified appraisers to perform appraisal assignments. 3, manage the process of having an appraisal performed, including providing administrative duties such as receiving appraisal orders and appraisal reports, submitting completed appraisal reports to creditors and underwriters, collecting fees from creditors and underwriters for services provided, and reimbursing appraisers for services performed. Or 4, review and verify the work of appraisers. B, appraisal management company, or AMC, does not include 1, a corporation, limited liability company, sole proprietorship, or other entity that directly performs appraisal services. 2, a corporation, limited liability company, sole proprietorship, or other entity that does not contract with appraisers for appraisal services but solely distributes orders to a client's selected panel of appraisers. And 3, a mortgage company or its subsidiary that manages a panel of appraisers who are engaged to provide appraisal services on mortgage loans, either originated by the mortgage company or funded by the mortgage company with its own funds. 3, board means the Board of Real Estate Appraisers, created in section strike 12-61-703, unstrike 12-10-603. 4, client means the party or parties who engage an appraiser or an appraisal management company for a specific assignment. Strike 5, repealed. 6, unstrike 5. Consulting services means services performed by an appraiser that do not fall within the definition of an independent appraisal in subsection strike 10, unstrike 7 of this section. Consulting services include marketing, financing, and feasibility studies, evaluations, and analysis, and opinions of the conclusions given in connection with real estate brokerage, market banking, and counseling and advocacy in regard to property tax assessments and appeals thereof, except that if in rendering unstrike the services, the appraiser acts as a disinterested third party, the work is deemed as an independent appraisal and not a consulting service. Nothing in this subsection strike 6, unstrike 5 precludes a person from acting as an expert witness in valuation appeals. Strike section 7, relocated to 12-10-1011. Strike section 8, unstrike relocated to 12-10-1012. Strike 9, unstrike 6. Financial institutions mean any bank or savings association as strike such, unstrike those terms as defined in 12 U.S.C. section 1813, any state bank incorporated under Title 11, strike CRS, unstrike any state or federally chartered credit union or any company that has direct or indirect control over any of those entities. Strike 10, unstrike 7, independent appraisal means an engagement for which an appraisal is employed or retained to act as a disinterested third party in rendering an unbiased analysis, opinion, or conclusion relating to the nature, quality, value, or utility of specified interest in or aspects of identified real estate. Strike 10-5, unstrike 8. A panel or appraisal panel means a network list of roster of licensed or certified appraisals approved by an AMC to perform appraisals as independent contractors for the AMC. B, appraisers on an AMC's appraiser panel include both 1, appraisers accepted by AMC for consideration for future appraisal assignments in covered transactions or for secondary mortgage market participants in connection with covered transactions, and 2, appraisers engaged by the AMC to perform 1 or more appraisals in covered transactions or for secondary mortgage market participants in connection with covered transactions. C, an appraiser is an independent contractor for purpose of this subsection. Strike 10.5, unstrike 8, if the appraiser is treated as an independent contractor by the AMC for purposes of federal taxation. Strike 11, unstrike 9A, real estate appraisers or appraiser means a person who provides an estimate of the nature, quality, value, or utility of an interest in or aspect of identified real estate and includes 1 who estimates the value and who possesses the necessary qualifications, ability, and experience to execute or direct the appraisal of real property. B, real estate appraiser or appraiser does not include 1, a person who conducts appraisal strictly of personal property, 2, a person licensed as a broker pursuant to Part 2 of this Article 10 who provides an opinion of value that is not represented as an appraisal and is not used for purposes of obtaining finance. 3, a person licensed as a certified public accountant pursuant to Article strike 2, unstrike 100 of this Title 12 and otherwise regulated as long as the person does not represent his or her opinions of value for real estate as an appraisal. 4, a corporation acting through its officers or strike regular, unstrike regularly salaried employees when conducting evaluation of real estate property rights owned to be purchased or sold by the corporation. 5, a person who conducts appraisals strictly of water rights or of mineral rights. 6, a right-of-way acquisition agent and appraisal who is licensed and certified pursuant to this part, strike 7, unstrike 6 of, or any other individual who has sufficient understanding of the local real estate market to be qualified to make a waiver evaluation when the agent, appraiser, or other qualified individual is employed by the contracts with a public entity and provides an opinion of value that is not represented as an appraisal, and when, for any purpose, the property or portion of property being valued is valued at $25,000 or less, as permitted by federal law and 49 CFR 24.102 C2 as amended. 7, an officer, director, regularly, strike regular, unstrike regularly salaried employee of a financial institution or its affiliate who makes for internal use only by financial institution or affiliates an analysis, evaluation opinion, conclusion, notation, or compilation of data with respect to an appraisal, so long as the person does not make a written adjustment of the appraisal's conclusion as to the value of the subject real property. 8, an officer, director, or strike regular, unstrike regularly salaried employee of a financial institution or its affiliate who makes an internal analysis, valuation, opinion, conclusion, notation, or compilation of data concerning an interest in real estate that is owned or held as collateral by the financial institution or its affiliates. Or 9, a person who represents property owners as an advocate in the tax or valuation protests and appeals pursuant to Title 39, strike CRS.
12-10-603, formerly 12-61-703, Board of Real Estate Appraisers, Creation, Compensation, Immunity, Legislative Declaration, Repeal, Part 1A. There is hereby created in the Division of Real Estate, a Board of Real Estate Appraisers consisting of 7 members appointed by the Governor of the consistent of the Senate. Of the members, 3 shall be licensed certified appraisers, 1 of whom shall be expertise in eminent domain matters, 1 shall be a county assessor in office, 1 shall be an officer or employee of a commercial bank experienced in real estate lending, 1 shall be an officer or employee of an appraisal management company, and 1 shall be a member of the public at large not engaged in any of the business represented by other members of the board. B, members of the board shall hold office for terms of 3 years in the event of a vacancy by death, resignation, removal, or otherwise. The governor shall appoint a member to fill the unexpired term. The governor has the authority to remove any member of the misconduct, neglect of duty, or incompetence. The board shall exercise its powers and perform its duties and functions under the Division of Real Estate as if it transferred to the division by Type 1 transfers defined in the Administrative Organization Act of 1968, Article 1, Title 24. Strike CRS on strike B. The General Assembly finds, determines, and declares that the organization of the board under the division of its Type 1 agency will provide the autonomy necessary to avoid potential conflicts of interest between the responsibility of the board of the regulation of real estate appraisers and the responsibility of the division of the regulation of real estate brokers and salespersons. The General Assembly further finds, determines, and declares that the placement of the board as a Type 1 agency under the division consistent with the original organizational structure of state government. 3, each member of the board shall receive the same compensation and reimbursement of expenses as is provided for members of boards and commissions in the divisions of professions and occupations pursuant to Section Strike 2431, 10213 CRS, unstrike 12, 21036, payment for all per diem compensation expenses shall be made out of annual appropriations from the Division of Real Estate Cash Fund provided for in Section Strike 1261, 705, unstrike 1210, 605. 4 members of the board, consultants, expert witnesses are immune from liability in any civil action based upon the disciplinary proceedings or other officials acts as they perform in good faith pursuant to this part, strike 7 on strike 6. 5, a majority of the board constitutes quorum for the transaction of all business and actions of the board required a vote of the majority of the members present in favor of the action taken. 6, this part, strike 7 on strike 6 is repealed effective September 1st, 2022. Strike prior to, unstrike before the repeal strike. The Department of Regulatory Agencies shall review the functions of the Board of Real Estate Appraisers as is provided in unstrike. This part, section 6, is scheduled for review in accordance with section 2434-104, strike CRS, unstrike 12-10604. Formerly 1261-704, powers and duties of the board rules. 1, in addition to all other powers and duties imposed by the law, the board has the following powers and duties. A1, to promulgate and amend necessary rules pursuant to Article 4, Title 24, strike CRS, unstrike for the implementation and administration of this part, strike 7 on strike 6, and required to comply with the Federal Real Estate Appraisal Reform Amendments, Title 11 of the Federal Financial Institution Reform, Recovery and Enforcement Act of 1989 as amended 12 U.S.C. sections 3331 to 3351. And with any requirements imposed by amendments to the federal law. 2, the board shall not establish any requirements that are more stringent than the requirements of any applicable federal law. 3, licensed ad valorem appraisers are not regulated by the Federal Real Estate Appraisals Reform Amendments, Title 11 of the Federal Financial Institution Reform, Recovery and Enforcement Act of 1989 as amended 12 U.S.C. sections 3331 to 3351, where the board shall adopt rules regarding minimum qualifications, standards of practice of licensed ad valorem appraisers. 4, in any lists or registry it maintains, the board shall identify or separately account for any appraisal management company that oversees panel more than 15 certified licensed appraisers in Colorado or more than 25 in all states in which it does business within a given year. B, to charge application, examination, license, certificate renewal fees established pursuant to section strike 1261-111.5 on strike 1210-215 from all applicants for licensure, certification, examination, renewal under this part, strike 7 on strike 6. The board shall not refund any fees received from applicants seeking licensure, certification, examination, or renewal C through the department, strike of regulatory agencies on strike and subject to appropriations made to the department, strike of regulatory agencies on strike to employ administrative law judges appointed pursuant to Part 10 of Article 30 of Title 24, strike CRS on strike on a full-time or part-time basis to conduct any hearings required by this part, strike 7 on strike 6. D, to issue, deny, or refuse to renew a license or certificate pursuant to this part, strike 7 on strike 6. E, to take disciplinary actions to conformity With this part, strike 7 on strike 6. F to delegate the direct administration and enforcement of this part, strike 7 on strike 6. The authority to act on behalf of the board on the occasions and circumstances of the board directs G, 1, to develop, purchase, or contract for any examination required for the administration of this part, strike 7 on strike 6, to offer each examination at least twice a year if demand warrants, at more frequent intervals, and to establish a passing score for each examination that reflects a minimum level of competency. 2, if study materials are developed by a testing company or other entity, the board shall make the materials available to persons desiring to take examinations pursuant to this part, strike 7 on strike 6. The board may charge fees the materials to defray any costs associated with making materials available. H, in compliance with Article 4, Title 24, strike CRS, on strike to make investigations, subpoena persons, documents with subpoenas may be enforced by a court of competent jurisdiction if not obeyed, to hold hearings and take evidence in all matters relating to the exercise of the board's power. Under this part, strike 7 on strike 6 I, pursuant to strike sections on strike section 1119B of Title 11 of the Federal Financial Institutions Reform, Recovery, and Enforcement Act of 1989, publication L10173, is amended to apply, if necessary, for a federal waiver of the requirement related to certification and licensing of a person to perform appraisals, to make necessary written determinations specified in strike 7 on strike said that sections for purposes of making the application. J, if the board has reasonable cause to believe that a person, partnership, limited liability company, corporation is violating this part, strike 7 on strike 6, in order requiring the individual appraisal management company to cease and desist the violation, and K, to establish classroom education and experience requirements for an appraiser who prepares an appraisal for a conservation easement for which tax credit is claimed pursuant to section 3922.522. The requirements must ensure that appraisers have a sufficient amount of training and expertise to accurately prepare appraisals that comply with the uniform standards of professional appraisal practice and any other provision of law related to the appraisal of conservation easements for which tax credit is claimed. Tax credit certification for conservation easement shall not be given in accordance with section strike 1261.1105 on strike 1215.105 and strike 1261.1106 on strike 1215.106, unless the appraiser who prepared the appraisal of the easement met all requirements established in accordance with the subsection 1K in effect at the time the appraisal certification is signed. 2, the board shall maintain and preserve for 7 years licensing history records of a person licensed or certified under this part, strike 7 on strike 6. Complaints or records in the office of the board and board investigations, including board investigative files, are closed to public inspection. Stipulations and final agency orders are public record and are subject to sections 2472.203 and 2472.204, strike CRS on strike 1210.605, formerly 1261.705. Fees, penalties, and fines collected under Part 6. All fees, penalties, and fines collected pursuant to this part, strike 7 on strike 6, not including fees retained by contractors pursuant to contracts entered into in accordance with section strike 1261.103, 1261.706, on strike 1210.203, 1210.606, or 2434.101, strike CRS on strike shall be transmitted to the state treasurer, who shall credit the state of the division of real estate cash fund created in section strike 1261.111.5 on strike 1210.215, 1210.606, formerly 1261.706, qualifications, licensing, certification of appraisers, continuing education, definitions, rules. 1A, the board shall by rule prescribe requirements for the initial licensing or certification of persons under this part, strike 7 on strike 6, to meet the requirements of the Real Estate Appraisal Reform Amendments, Title 11 of the Federal Financial Institution Reform, Recovery, and Enforcement Act of 1989 is amended 12 U.S.C. sections 3331 to 3351. And shall develop purchases or contract for examinations to be passed by applicants. The board shall not establish any requirements for initial licensing or certification that are more stringent than the requirements of any applicable federal law, except that all applicants shall pass an examination offered by the board. If there is no applicable federal law, the board shall consider and may use as guidelines the more recent available criteria published by the appraiser, qualifications board of appraisal, final successful organization, be the 4 levels of appraisal licensure or certification pursuant to strike paragraph A of this subsection 1, unstrike subsection 1A of this section, are defined as follows. 1, certified general appraisers means an appraiser means meeting the requirements set by the board for general certification. 2, certified residential appraisers means an appraiser meeting the requirements set by the board for residential certification. 3, licensed ad valorem appraiser means an appraiser meeting the requirements set by the board of ad valorem appraiser certification. Only a county assessor, employee of a county assessor's office, or employee of the Division of Property Taxation in the Department of Local Affairs may obtain and possess an ad valorem appraiser certification. Strike and unstrike. 4, licensed appraiser means an appraiser meeting the requirements set by the board of licensed seed county assessor or employee of county assessor's office who is licensed ad valorem appraiser may not perform real estate appraisals outside of his or her official duties. D, the board shall transfer persons employed in the county assessor's office or in the Division of Property Taxation in the Department of Local Affairs who are registered appraisers as of July 1st, 2013 in the category of licensed ad valorem appraised. The board shall allow these persons until December 31st, 2015 to meet any additional requirements imposed by the board pursuant to sections strike 12617041A as amended on strike 12106041A2A. The board shall by rule prescribe continuing education requirements for persons licensed or certified as certified general appraisers, certified residential appraisers, or licensed appraisers as needed to meet the requirements of the Real Estate Appraisal Reform Amendments, Title 11 of the Federal Financial Institution Reform, Recovery, and Enforcement Act 1989, as amended 12 U.S.C. Section 3331 and 3351. The board shall not establish any continuing education requirements that are more stringent than the requirements of any applicable federal law, except that all persons licensed certified on this Part 7, Strike 7, on Strike 6 are subject to continuing education requirements that are in no applicable federal law. The board shall consider and may use as guidelines the most recent available criteria published by the Appraiser Qualifications Board of the Appraisal Foundation or its successor organization. No, I'm all right. B, the board shall by rule prescribe continuing education requirements for licensed ad valorem appraisers, 3 notwithstanding provisions in this section. On the contrary, the criteria established by the board for the licensing certification of appraisers pursuant to this part, strike 7 on strike 6, shall not include membership or lack of membership in an appraisal organization. 4A, subject to section strike 12617192 on strike 12106192. All appraisers and employees of county assessors shall be licensed certified as provided in subsection 1 and 2 of this section, obtaining a license certificate under either of strike said subsections, unstrike subsection 1, strike and unstrike, or 2 of this section, entitles an appraiser employee of a county assessor to perform all real estate appraisals required to fulfill person's official duties. B, appraiser employees of county assessors who are employed to appraise real property are subject to this part, strike 7 on strike 6, except the appraiser employees of county assessors who are employed to appraise real property are not subject to disciplinary actions by the board of the ground that they have performed appraisals beyond their level of competency when appraising real estate and fulfillment of their official duties. County assessors, if licensed certified as provided in subsection 1 and 2 of this section, are not subject to disciplinary actions by the board on the ground that they have performed appraisals beyond their level of competency when appraising real estate and fulfillment of their official duties. See, the county in which an appraiser employee of a county assessor is employed shall pay all reasonable costs incurred by the appraiser employee of the county assessor to obtain and maintain license certificate pursuant to this section. 5, the board shall not issue an appraiser's license as referenced in subparagraph 4 of paragraph B of subsection 1, unstrike subsection 1B 4 of this section unless the applicant has at least 12 months appraisal experience. 6A, the board shall not issue a license or certification on the applicant until the applicant demonstrates that he or she meets the fitness standards established by board rule and submits a set of fingerprints in the Colorado Bureau of Investigation for the purpose of conducting a state and national fingerprint-based criminal history record check utilizing records of the Colorado Bureau of Investigation and the Federal Bureau of Investigation. Each person submitting a set of fingerprints shall pay the fee established by the Colorado Bureau of Investigation for conducting the fingerprint-based criminal history record check to the Bureau. Upon completion of the criminal history record check, the Bureau shall forward the results to the board. The board may require a name-based criminal history record check for the applicant who has twice submitted to a fingerprint-based criminal history record check and whose fingerprints are unclassifiable. The board may deny an application for licensure or certification based on the outcome of the criminal history record check and may establish criminal history requirements more stringent than those established by any applicable federal law. At a minimum, the board shall adopt the criminal history requirements established by any applicable federal law. B, an applicant for certification as a licensed ad valorem appraiser is not subject to the fingerprint and criminal background check requirements of strike paragraph A of this subsection 6, unstrike subsection 6A of this section. 12-10-607, formerly 12-61-707, appraisal management company's application for license exemptions. 1, an applicant shall apply for a license as an appraisal management company or as a controlling appraiser to the board of a manner prescribed by the board. 2, the board may grant appraisal management company licenses to individuals, partnerships, and limited liability companies or corporations. A partnership, limited liability company, or corporation in its application for a license shall designate a controlling appraiser who is actively certified and state recognized by the appraisal subcommittee of the federal financing institution, strike examinations, unstrike examination council, or its successor entity. The controlling appraiser is responsible for its license practices of the partnership, limited liability company, or corporation, and all persons employed by the entity. The application of the partnership, limited liability company, or corporation, the application of the appraiser designated by the controlling appraiser shall be filed with the board. The board has jurisdiction over the appraiser so designated over the partnership, limited liability company, or corporation. 3, the board shall not issue a license to any partnership, limited liability company, or corporation And last, an utility appraiser designated by the partnership, limited liability company, or corporation as controlling appraiser, and each individual who owns more than 10% of the entity demonstrates that he or she meets the fitness standards established by the board rule and submit a set of fingerprints to the Colorado Bureau of Investigation for the purposes of conducting a state and national fingerprint-based criminal history record check utilizing records of the Colorado Bureau of Investigation and the Federal Bureau of Investigation. Each person submitting a set of fingerprints shall pay the fee established by the Colorado Bureau of Investigation for conducting the fingerprint-based criminal history record check of the Bureau. Upon completion of the criminal history record check, the Bureau shall forward the result of the board. The board may require a name-based criminal history record check for an applicant who has twice submitted to a fingerprint-based criminal history record check and whose fingerprints are unclassifiable. The board may deny an application for licensure or refuse to renew a license based on the outcome of the criminal history record check. The board may require criminal history requirements more stringent than those established by any applicable federal law. At a minimum, the board shall adopt the criminal history requirements established by any applicable federal law. 4, the board shall not issue a license to any partnership, limited liability company, or corporation if the appraiser designated by the entity as controlling appraiser has previously had in any state an appraiser resignation, license, registration, license, or certification refused, denied, canceled, surrendered in lieu of revocation, or revoked. A disciplinary action resulting in refusal, denial, cancellation, surrender in lieu of revocation or revocation relating to a registration license or certification as an appraiser registered license or certified under this part, strike 7, unstrike 6 of any related occupation in any other state, territory, accounting for disciplinary reasons is prima facie evidence of grounds for denial of the license by the board. The board shall not issue a license to any partnership, limited liability company, or corporation if it is owed in whole or in part, directly or indirectly, by any person who has had in any state an appraiser license, registration, or certificate refused, denied, canceled, surrendered in lieu of revocation, or revoked. A disciplinary action resulting in refusal, denial, cancellation, surrender in lieu of revocation, or revocation relating to a license, registration, or certification as an appraiser license, registered, or certified under this part, strike 7, unstrike 6, or any related occupation in any other state, territory, or county for disciplinary reasons is prima facie evidence grounds for denial of a license by the board. 6, the board may deny an application for a license for any partnership, limited liability company, or corporation. If the partnership, limited liability company, or corporation has previously had a license revoked, surrendered, and license in lieu of revocation, a disciplinary action resulting in the surrender in lieu of revocation or the revocation of a license as an appraisal management company under this part, strike 7, unstrike 6, or any related occupation in any other state, territory, or country for disciplinary reasons may be deemed to be prima facie evidence of grounds for denial of a license by the board. 7, each appraisal management company must maintain a definite place of business. If the appraisal management company is domiciled in another state, the appraiser designated by the appraisal management company as controlling appraiser is responsible for supervising all licensed activities that occur in Colorado. All licensed actions occurring within the state of Colorado must occur under the name under which the appraisal management company is licensed or its trade name adopted in accordance with Colorado law. An application that is submitted by an appraisal management company that is a partnership must be properly registered with the Colorado Department of Revenue or properly filed with the Colorado Secretary of State and in good standing, proof of which must be included in the application. If an assumed or trade name is to be used, it must be properly filed with the Colorado Department of Revenue or filed and accepted by the Colorado Secretary of State, proof of which must be included with the application. B, a limited liability company must be properly registered with the Colorado Secretary of State in good standing, proof of which must be included with the application. If an assumed or trade name is to be used, it must properly file with the Colorado Secretary of State, proof of which must be included with the application. C, a corporation must be registered as a foreign corporation or properly incorporated with the Colorado Secretary of State in good standing, proof of which must be included with the application. If an assumed or trade name is to be used, it must be properly filed with the Colorado Secretary of State, proof of which must be included with the application. Non-financial institutions and appraisal management companies, subsidiaries that are owned and controlled by the financial institution and regulated by a federal financial institution regulatory agency are not required to register with or be licensed by the board. This exemption includes a panel of appraisers who are engaged to provide appraisal services and are administered by a financial institution regulated by federal financial regulatory agencies. 12-10-608, formerly 12-61-708. Errors and omissions insurance duties of the division certificate of coverage group plan made available rules. 1. Every license under this part, strike 7, unstrike 6, except an appraiser who is employed by a state or local government entity or an inactive appraiser or appraisal management company shall maintain errors and omissions insurance to cover all activities contemplated under this part, strike 7, unstrike 6. The division shall make the errors and omissions insurance available to all licensees by contracting with insurer for a group policy after a competitive bid process in accordance with Article 103 of Titles 24, strike CRS, unstrike. A group policy obtained by the division must be available to all licensees with no right on the part of the insurer to cancel any licensee. A licensee may obtain errors and omissions insurance independently if the coverage complies with the minimum requirements established by the division. 2A, if the division is unable to obtain errors and omissions insurance coverage to insure all licensees who choose to participate in the group program at a reasonable annual premium as determined by the division, a licensee shall independently obtain the errors and omissions insurance required by this section. B, the division shall solicit and consider information and comments from interested persons when determining the reasonableness of annual premiums. The division shall determine the term and conditions of coverage required under this section based on rules promulgated by the board. Each licensee shall be notified of the required terms and conditions at least 30 days before the annual premium renewal date is determined by the division. Each licensee shall file a certificate of coverage showing compliance with the required terms and conditions of the division by the annual premium renewal date is determined by the division. 4. In addition to all the powers and duties conferred by the board by this part, strike 7 on strike 6, the board is authorized and directed to adopt rules it deems necessary or proper to carry out the requirements of this section. 12-10-609, formerly 12-61-709. Upon required one, before the board issue a license to an applicant for an appraisal management company licensee, the applicant shall post with the board a surety bond in the amount of $25,000. A licensed appraisal management company shall maintain the required bond at all times. 2. The surety bond shall require the surety to provide notice to the board within 30 days if payment is made from the surety bond or if the surety bond is canceled. 12-10-610, formerly 12-61-710. Expiration of licenses, renewal, penalties, fees, rules. 1A, all licenses or certificates expired pursuant to schedule established by the director may be renewal or reinstated pursuant to this section. Upon compliance with this section and any applicable rules of the board regarding renewal, including the payment of renewal fees plus a reinstatement fee established pursuant to strike paragraph B of this subsection 1, unstrike subsection 1B of this section, that expired license or certificates shall be reinstated. A real estate appraiser's license or certificate that has not been renewed for a period greater than 2 years shall not be reinstated, and this person must submit a new application for licensure or certification. B, a person who fails to renew his or her license certificate before the applicable renewal date may have it reinstated if the person submits an application as prescribed by the board, 1, within 31 days after the date of expiration by payment of the regular renewal fee. 2, more than 31 days but within 1 year after the date of expiration by payment of the regular renewal fee and payment of reinstatement fee equal to 1/3 of the regular renewal fee. Or 3, more than 1 year but within 2 years after the date of expiration by payment of the regular renewal fee and payment of a reinstatement fee equal to 2/3 of the regular renewal fee. 2, the federal registry fee collected by the board and transmitted to the Federal Financial Institution Examination Council is increased prior to the expiration of the license or certificate. The board shall collect the amount of the increase in the fee from the holder of the license or certificate and forward the amount to the council annually. The federal registry fee does not apply to the license applicant or appraiser's license under this article 10(3)(a) if the applicant has complied with this section and the applicable rules to the board regarding renewal, except for the continuing education requirements pursuant to strike section 12-61-706, unstrike 12-10-606. The licensee may renew the license on inactive status. An inactive license may be activated if the licensee submits written certification of compliance with strike section 12-61-706, unstrike 12-10-606 for the previous licensing period. The board may adopt rules establishing procedures to facilitate reactivation of licenses. B, the holder of an inactive license shall not perform a real estate appraisal or appraisal management duty. C, the holder of an active license shall not hold himself or herself out as having an active license pursuant to this part. Strike 7, unstrike 6. 4, at the time of renewal or reinstatement, every licensee certificate holder and person or individual who owns more than 10% of an appraisal management company shall submit a set of fingerprints in the Colorado Bureau of Investigation for the purpose of conducting a state and national fingerprint-based criminal history record check utilizing records of the Colorado Bureau of Investigation and the Federal Bureau of Investigation. If the person has not previously done so for issuance of a license or certification by the board, each person submitting a set of fingerprints shall pay the fee established by the Colorado Bureau of Investigation for conducting the fingerprints-based criminal history record check to the Bureau. The Bureau shall forward the results to the board. The board may require a name-based criminal history record check for an applicant who has twice submitted to this fingerprint-based criminal history record check, and whose fingerprints are unclassifiable. The board may refuse to renew or reinstate a license or certification based on the outcome of the criminal history record check. 12-10-611, formerly 12-61-711, licensure or certification by endorsement temporary practice. 1, the board may issue a license or certification to an appraiser by endorsement to engage in the activation of real estate appraisal to any applicant who has a license or certification in good standing as a real estate appraiser under the laws of their jurisdiction if A, the applicant presents proof satisfactory to the board that at the time of application by a Colorado license or certification by endorsement, the application possesses credentials and qualifications that are substantially equivalent to the requirements of this part. Strike 7 on strike 6, or B, the jurisdiction that issued the applicant a license or certificate to engage in the occupation of real estate appraisal has a law similar to this subsection 1 pursuant to which it licenses or certifies person who are licensed real estate appraisers in this state to the board may specify by rule what constitutes substantially equivalent credentials and qualifications, the manner in which the board will review credentials and qualifications of an applicant. 3. Pursuant to section 1122A of Title 11 of the Federal Financial Institution Reform, Recovery, and Enforcement Act of 1989, publication L 10173 is amended. The board shall recognize on a temporary basis the license or certification of appraiser issued by another state if A, the appraiser's business is of a temporary nature, and B, the appraiser applies for and is granted a temporary practice permit by the board. 12-10-612, formerly 12-61-712, denial of a license certificate renewal definition. 1. The board may determine whether an applicant for licensure or certification possesses the necessary qualifications for licensure or certification required by this part, strike 7, unstrike 6. The board may consider such qualities as the applicant's fitness and prior professional licensure and whether the applicant has been convicted of a crime is used in this subsection 1. Applicant includes any individual who owns in whole or in part, directly or indirectly, an appraisal management company and any appraiser designated as a controlling appraiser by a partnership, limited liability company or corporation acting as an appraisal management company. 2. If the board determines that an applicant does not possess the applicable qualifications required by this part, strike 7, unstrike 6, or the applicant has violated this part, strike 7, unstrike 6, rules promulgated by the board, or the board may deny the applicant a license or certificate to deny the renewal or reinstatement of license or certificate pursuant to section strike 1261-710, unstrike 1210-610, and in such instance, the board shall provide the applicant with a statement in writing setting forth the basis of the board's determination the applicant does not possess qualifications or professional competence required by this part, strike 7, unstrike 6. The applicant may request a hearing on the determination as provided in section 244104-9. Strike CRS, unstrike 12-10-613, formerly 1261-713, prohibited activities. Grounds for disciplinary actions. Procedures. 1. A real estate appraiser is in violation of this part, strike 7, unstrike 6. If the appraiser A has been convicted of a felony or has had accepted by a court a plea of guilty or no contender of a felony, if the felony is related to ability to act as a real property appraiser. A certified company of the judgment of a court of competent jurisdiction of the conviction or plea is conclusive evidence of the conviction or plea. In considering the disciplinary action, the board shall be governed by the provisions of section 245101. Strike CRS, unstrike B, has violated or attempted to violate, directly or indirectly, or assisted in or abetted in violation of or conspired to violate this part, strike 7, unstrike 6, a rule promulgated pursuant to this part, strike 7, unstrike 6, or an order of the board issued pursuant to this part, strike 7, unstrike 6. C has accepted any fees, compensation, or other valuable consideration to influence the outcome of an appraisal. D is used advertising that is misleading, deceptive, or false. E has used fraud or misrepresentation in obtaining a license or certificate under this part, strike 7, unstrike 6. F has conducted an appraisal in a fraudulent manner or used misrepresentation in any such activity. G has acted or failed to act in a manner that does not meet the generally accepted standards of professional appraisal practices adopted by the board by rule. A certified copy of a malpractice judgment of a court of competent jurisdiction is conclusive evidence of the act or omission, but evidence of the act or omission is not limited to malpractice judgment. H has performed appraisal services beyond his or her level of competency. I has been subject to an adverse disciplinary action in another state, territory, or country relating to a license, certificate, or other authorization to practice as an appraiser. Disciplinary action relating to a license or certificate as an appraiser, licensed or certified under this part of strike 7, unstrike 6, or any related occupation in any other state, territory, or country for disciplinary reasons is prima facie evidence of grounds for disciplinary action or denial of license certification by the board. This strike paragraph I, unstrike subsection 1I, applies only to violations based upon acts or omissions of the other state, territory, or country that are also violations of this part, strike 7, unstrike 6. J has failed to disclose the appraisal report. The fee paid to the appraiser for residential real property appraisal if the appraiser was engaged by an appraisal management company to complete the assignment, or K has engaged in conduct that would be grounds for the denial of a license or certification under section strike 1261-712, unstrike 1210-612. 2. If an applicant, a licensee, or certified person has violated any provision of this section, the board may deny or refuse to renew the license or certificate, or as specified in subsections 3 and 6 of this section, revoke or suspend the license or certificate, issue a letter of admonition to a licensee or certified person, place a licensee or certified person on probation or impose public censure. 3, when a complaint or an investigation discloses an instance of misconduct by a licensed or certified appraiser that, in the opinion of the board, does not warrant formal action by the board but should not be dismissed as being without merit, the board may send a letter of admonition by certified mail to the appraiser against whom a complaint was made. The letter shall advise the appraiser of the right to make a written request within 20 days after receipt of the letter of the admonition to the board and begin the formal disciplinary proceedings as provided in this section to adjudicate the conduct or acts on which the letter was based.
Violation of abuse of health insurance pursuant to 13 Section 1A, 13, 119, CRS, 4, 14, II, advertising for newspapers, magazines, circulars, direct, 15, mail, directories, radio, television, or otherwise that the licensee will. 16, perform any act prohibited by Section 1A, 13, 119, 3, CRS. 17, ID, X, administering, dispensing, or prescribing any. 18, prescription drug, as defined in Section 12-42.5-102, 34, 12, 280, 103. 19, 42, already controlled substance, as defined in Section 1A, 18, 1025. 20 CRS, other than in the course of legitimate professional practice. 21. 22, DPY, engaging in any of the following activities and practices. 23. I, repeatedly ordering or performing demonstrably if necessary. 24. Laboratory tests or studies that lack clinical justification. 25. II, administering treatment that is demonstrably necessary. 26. Lacks clinical justification. 27. II, ordering or performing any service, X-ray, or treatment test. Minus 1387 to 1172. Minus 1701 is contrary to recognized standards of the practice of optometry as 2 interpreted by the board and lacks political justification. 3. E. Z. Committing a fraudulent insurance act as defined in registration according to section October 1st 128 CRS. I. FF. A. Failing to report to the board any optometrist known to have violated or upon information or belief believed to have violated 7 of the provisions of this article 275. 8. GG. BB. Failing to report to the board any surrender of a license. 9. Or any adverse action taken against a licensee by another licensing. An agency in another state, territory, or country, any governmental agency. 11. Any law enforcement agency or any court for acts of conduct that would all constitute grounds for discipline under the provisions of this article 275. 13. HHCC, engaging in a sexual act with a patient while a 14. Patient-optometrist relationship exists for the purposes of this paragraph. 15. HH, subsection 1, CC. 16. I, patient-optometrist relationship means that period of time. 17. Beginning with the initial evaluation for determination of treatment. 18. For the purposes of this paragraph, HH and 19. II, sexual act means sexual contact, sexual intrusion, or sexual. 20. Penetration as defined in section March 18-401, CRS. 21. II, DD, failing to provide a patient with copies of patient medical. 22. Records as required by section January 25th, 802, CRS. 23. JJE, failing to provide a patient with a valid written contact. 24. Length prescription as required by section 1240, 1173, 12275, 1193. 25. KKFF, the violation of any provision of this article 275 Ren. 26. Applicable provision of article 20 or 30 of this title 12. 27. LL, GG, practicing beyond the scope of education and training. Minus 1388, 1172. 1. Prescribed by rules adopted by the board. 2. Millimeters, HH, failing to respond to NRS, materially responsive. 3. Untimely manner to a complaint pursuant to section 1240, 1119, 1B. 4. 12275, 122, 1B. 5. 12275, 121, 412-118.5, mental and physical. 6. Examination of licensees, confidential agreements to limit practice. 7. 1. If the board has reasonable cause to believe, the licensee is unable. 8. The practice of reasonable skill and safety, the board may require the non-licensee to submit to a mental or physical examination by a physician or 10 qualified healthcare provider designated by the board. If the licensee 11 refuses to undergo a mental or physical examination unless due to all circumstances beyond the licensee's control, the board may suspend the 13 licensee's license until an examination has occurred. The results of the 14 examination are known, and the board has made a determination of the 15 licensee's fitness to practice. The board shall proceed with the order for 16 examination of the determination in a timely manner. 17. 2. Order to a licensee pursuant to subsection 1 of this. 18. Section 2. Undergo a mental or physical examination shall contain 19 basis of the board's reasonable cause to believe that the licensee is unable. 20. The practice of reasonable skill and safety for the purposes of any 21. Disciplinary proceeding authorized under this article 275. The licensee. 22. Shall be deemed to have waived all objections to the admissibility of the 23. examining physician's testimony or examination reports on the ground. 24, that they are privileged communications. 25, 3, the licensee may submit to the board testimony or 26, examination reports from a physician chosen by such licensee and 27, pertaining to any condition which the board is alleged may, minus 1389, 1172. 1, preclude the licensee from practicing with reasonable skill and safety. Duties may be considered by the board in conjunction with, but not elude. 3, testimony and examination reports of the physician designated by the board. 5, 4, the results of any mental or physical examination ordered by 6, the board shall not be used as evidence in any proceeding other than 1. 7, before the board, and shall not be deemed public records nor made available to the public. 9, 5, the board may enter into an agreement in accordance. 10, with section December 30th, 108 with an optometrist whose practices or may be. 11, affected by a physical illness, a physical condition, or a behavioral or mental health disorder that renders the optometrist unable to treat with. 13, reasonable skill and safety or that may endanger the health and safety of. 14, persons under the care of any optometrist. 15, I, the board believes that one or more limitations of the 16 optometrists practice would both enable the optometrist to treat with. 17, reasonable skill and safety and would protect the health and safety of. 18, persons under the care of the optometrist. And 19, I, the optometrist enters into an enforceable agreement with the. 24, 2, so limit the optometrist's practice. 21, B, an agreement entered into pursuant to this subsection. 5. 22, I, is confidential and not subject to disclosure pursuant to the 23 Colorado Open Records Act, Part 2 of Article 72 of Title 24, CRS, and 24, II, may include provisions for monitoring and reevaluation of the 25 optometrist. The parties may modify or dissolve the agreement as 26, 27, necessary based on the results of the monitoring or reevaluation. C, the board may require the licensee to submit to N, minus 1390, 1172. 1, 2, examination pursuant to this section to evaluate the extent of the physical illness, the physical condition, or the behavioral or mental health disorder, 3, and its impact on the licensee's ability to practice with reasonable skill. 4, and with safety for patients. 5, D, by entering into an agreement with the board pursuant to this. 6, section limits order practice the licensee is not engaging in. 7, unprofessional conduct. The agreement is an administrative action and 8, 9, 10, 11, 12. Does not constitute a restriction or discipline by the board. However, if the licensee fails to comply with an agreement entered into pursuant to this section, the failure constitutes unprofessional conduct pursuant to section 1240118 and the licensee becomes subject to discipline in accordance with section 1240119. 13, E, C, for purposes of this subsection. 5, physical illness. 14, physical condition or behavioral or mental health disorder does not. 15, include habitual or excessive use or abuse of alcohol, a habit forming. 16, drug or any controlled substance as defined in section 1A, 18102, 5. 17, 12, 275, 122, formerly 12, 119, discipline, procedure. 18, professional review, pre-consideration, and review of action by board. 19, rules, 1, with respect to license issued pursuant to this article. 20, 275, the board may. 21, I, impose probation with or without supervision on the licensee. 22, issue a letter of admonition to a licensee or suspend, revoke, or refuse to. 23, renew any license provided for by this article or take disciplinary order. 24, other action is authorized in section December 20th, 404 for any reason. 25, stated in section 1240118, 275, 120, or for violating any term of. 26, probation of the board. 27, II, summarily suspend the license upon the failure of the licensee. Minus 1391, 1172. 1, to comply with any condition of a stipulation or order imposed by the new board until the licensee complies with the condition and less compliance. 3 is beyond the control of the licensee. 4, II, impose a fine not to exceed $5,000 a day. 5, licensee for a violation of this article 275 or rule promulgated pursuant. 6, to this article 275 other than a violation related to a standard of practice. 7, the board shall, by rule, promulgate a fining schedule with lesser 8 amounts for first violations and increasing amounts for subsequent 9 violations of this subparagraph. II, subsection 1, II. 10, B, upon its own motion or upon its own complaint. And 11, investigation may be made if there is reasonable cause to believe that N, all optometrists licensed by the board is committed and acted unprofessional. 13, conduct pursuant to section 1240118, 275, 120, or all under. 14, probation has violated the terms of the probation. 15, C, if the licensee requests a hearing to dispute formal board action. 16, or if the board finds such probability greater that hearing is conducted. 17, such hearing shall be conducted in accordance with the provisions. 18 of sections December 20th, 403 and April 24th, 105, CRS. 19, D, the board may revoke, suspend, deny, issue, pre-issue, or 20, state licenses granted pursuant to this article 275 under 21 previous laws of the state, and the board may take such other. 22, intermediate action as may be deemed necessary under the circumstances. 23, issue case pursuant to this section. 24, 2, C, repealed. 25, D, the hearing shall be conducted in accordance with the 26 provisions of section April 24th, 105, CRS, except that the board may use N. 27, administrative law judge, who shall perform all of those functions. Minus 1392, 1172. 1, indicated in section April 24th, 105, or CRS. 2, E2, the section December 20th, 408 governs judicial review of N. Reaction of the board in refusing to grant or renew, revoking, or suspending. Or a license, issuing a letter of admonition, or placing a licensee on 5, probation or under supervision pursuant to subsection 1, I of this. 6, section may review by the Court of Appeals by appropriate. 7, proceedings under section April 24th, 106, 11, CRS. 8, 9, 10. F, I, 3, when complaint or investigation discloses an instance of misconduct that, in the opinion of the board, does not warrant formal action by the board, that action not be dismissed as being without. 11, merit, the board may send a letter of admonition may be issued and 12, set, by certified mail to the licensee under the circumstances. 13, specify in and in accordance with section December 20th, 404, or 14, II, when a letter of admonition is sent by the board, by certified. 15, 16, 17, mail to licensee. Such licensee shall be advised that he or she has replied the request in writing within 20 days after receipt of the letter. That formal disciplinary proceedings be initiated to adjudicate the 18, propriety of the conduct upon which the letter of admonition is based. 19, II, if the request for adjudication is timely made, the letter of 20, 21, admonition shall be deemed vacated, and the matter shall be processed by means of formal disciplinary proceedings. 22, 2.1, or when complaint or investigation discloses an instance. 23, 24, the conduct that does not warrant formal action by the board, and in the opinion of the board, the complaint should be dismissed at the board. 25 is notice indications of possible error conduct by the licensee that. 26 could lead to serious consequences if not directed. The board may. 27 send a confidential letter of concern may be issued and send it to a minus 1393, 1172. 1 licensee under the circumstances specified in section December 20th, 404, 5, 2, 3, 4. 2.3, no person whose license is revoked by the board may reapply for a new license under the provisions of this article for at least 2 years after any such revocation. 5, 2.5, any person participating in the person specified in section 11. December 20th, 402. Any member of the board or of the professional review. 12. Committee authorized by the board. Any member of the board's board. 13. Committee staff and any person acting as a witness or consultant to the 14. 15. 16. 17. 18. 19. One more committee. Any witness testifying in a proceeding authorized under this article and any person who lodges a complaint pursuant to this article shall be immune from liability in any civil action brought against in order for acts occurring while acting in his order capacity as board or committee member, staff, consultant, or witness, respectively, if such individual was acting in good faith within the scope of his order. 20. Respective capacity made a reasonable effort to obtain the facts of the 21 matters to which he or she acted and acted in the reasonable belief that 22. The action taken by him in order was warranted by the facts. Any person. 23. 24. 25. Participating in good faith in lodging a complaint or participating in any investigative or administrative proceeding pursuant to this article shall be immune from any civil or criminal liability that may result from such. 26. Participation committee is granted the same immunity and is 27. Subject to the same conditions for immunity as specified in -1394, 1172. 1 section December 20th, 402. 2, 4, 6, and 4. On its own motion or upon application that 3. Any time after the refusal to grant a license, the imposition of any or discipline or the ordering of probation as provided in this section in 5 section December 20th, 404 may be considered prior action and grant, reinstate. 6. Or restore such a license, terminate probation, or reduce the severity of 7. Its prior disciplinary action, the taking of any such further action. 8. Holding of a hearing with respect thereto rests in the sole discretion of 9. The board. 10. B. Upon the receipt of such the application, it may be forwarded. 11. The Attorney General for such investigations may be deemed. 12. Necessary. The proceedings shall be governed by the applicable. 13. Provisions governing formal hearings and disciplinary proceedings. 14. Attorney General may present evidence bearing upon the matters at issue. 15. The burden shall be upon the applicant seeking reinstatement 2. 16. Establishing the affirmance of the application as specified in section April 24, 105. 17. 7. CR is no application for reinstatement or for modification of the prior. 18. Order shall be accepted unless the applicant deposits with the board hall. 19. Amounts sent in under any prior order of the board. 25. 7. Upon dismissal of the complaint or status gone to. 21. Hearing. The board shall notify the complainant that he or she may receive. 22. A copy of the investigation report in the response of the optometrist or 23. Other person alleged to have violated the act upon payment of costs of. 24. Copying and mailing such information. 25. 26. 27. 6. When a complaint or an investigation discloses an instance of misconduct in the opinion of the board warrants formal action, the complaint shall not be resolved by a deferred settlement action. -1395, 1172. 1. 2. 3. 4. Judgment or prosecution. 7. If it appears to the board, based upon credible evidence as presented in a written complaint by any person, the licensee is acting in a manner that is limited to threat to the health and safety of the 5. Public, where a person is acting or has acted without the required license. 6. The board may issue an order to cease and desist such activity. The order shall 7. Set forth the statutes and rules alleged to have been violated with facts. 8. 9. Alleged to have constituted the violation and the requirement that all unlawful acts or unlicensed practices immediately cease. 10. B. Within 10 days after service of the order to cease and desist. 11. 12. 13. 14. Pursuant to paragraph of this subsection 7, the respondent may request a hearing on the question of whether acts or practices in violation of this article have occurred. Such hearing shall be conducted pursuant to sections April 24, 104 and April 24, 105 CRS. 15. 8. And if it appears to the board, based upon credible evidence as 16. 17. Presented in a written complaint by any person that person has violated any other portion of this article. 10. In addition to any specific powers. 18. Granted pursuant to this article, the board may issue to such person 19. Order to show cause as to why the board should not issue a final order. 20. Directing such person to cease and desist from the unlawful act or 21. Unlicensed practice. 22. B. A person against whom an order to show cause has been 23. Issued pursuant to paragraph of this subsection 8 shall be promptly 24. 25. 26. 27. Notified by the board of the issuance of the order, along with a copy of the order, the factual and legal basis for the order, and the date set by the board for entering on the order. Such notice may be served by personal service by first-class United States mail, posted prepaid, or may be -1396, 1172. 1. 2. 3. 4. Practicable upon any person against whom such order is issued. Personal service or mailing of an order or document pursuant to this subsection 8 shall constitute notice thereof to the person. C. I. The hearing on an order to show cause shall be commenced 5. No sooner than 10 and no later than 45 calendar days after the date. 6. The transmission or service of the notification by the board has provided in 7. Paragraph B of the subsection 8. The hearing may be continued by a agreement of all parties based upon the complexity of the matter. Number 9, 10, 11, 12, 13, 14. The parties to the matter and legal issues presented in the matter, but in no event shall the hearing commence later than 60 calendar days after the date of transmission or service of the notification. II. If a person against whom an order to show cause has been issued pursuant to paragraph of this subsection 8 does not appear at the hearing, the board may present evidence that notification was 15. Properly sent or served upon such person pursuant to paragraph B of 16, 17. This subsection 8 and such other evidence related to the matters the board deems appropriate. The board shall issue such order within 18 days after the board's determination relating to reasonable offense to 19. Notify the respondents, and the order shall become final to that person. 20, 21, 22, 23, 24, 25. By operation of law, such hearing shall be conducted pursuant to sections April 24, 104 and April 24, 105 CRS. II. If the board reasonably finds that the person against whom the order to show cause was issued is acting or has acted without the required license or has about to engage in acts or practices constituting violations of this article, a final cease and desist order may 26. Be issued, directing such person to cease and desist from further unlawful. 27. Acts or unlicensed practices, -1397, 1172. 1. I. The board shall provide notice in the manner set forth in 2. Paragraph B of the subsection 8 of the final cease and desist order. 3. 4. Within 10 calendar days after the hearing conducted pursuant to this paragraph. C. To each person against whom the final order has been 5. Issued. The final order issued pursuant to subparagraph II of this 6. Paragraph C shall be effective when issued and shall be a final order for 7. Purposes of judicial review. 8. 9. 10. 11. 12. 13. 14. 9. If it appears to the board, based upon credible evidence presented to the board, that a person has engaged in or is about to engage in any unlicensed act or practice, any act or practice constituting a violation of this article, any rule promulgated pursuant to this article, any order issued pursuant to this article, or any act or practice constituting grounds for administrative sanction pursuant to this article, the board may enter into a stipulation with such person. 15. 10. If any person fails to comply with the final cease and desist. 16. Order or stipulation. The board may request the Attorney General order. 17. 18. 19. 20. continued violation of the final order. 21. 11. Purpose agreed by the final cease, and desist order may. 22. 23. Seek judicial review of the board's determination, or of the board's final order in a court of competent jurisdiction. 24. 8. The board may issue cease and desist orders under the 25 circumstances in accordance with the procedures specified. 26 in section December 20th, 405. 27. 275. 123. Use or sale of force or invalid certificate. Degree. Minus 1398. 1172. One more license. 1. Formerly 1240. 120. It is unlawful for any person to use or attempt to use or resort to the person's own diploma event. 3. Optometry school or college, or a license of another person, or forged, or diploma or license, or any forged or false identification. 5. 2. Formerly 1240. 121. 1. It is unlawful. 6. To sell or offer to sell a diploma conferring in optometry. 7. Degree or license granted pursuant to this Article 275 or prior optometry. 8. Practice laws. 9. B. To procure a diploma or license with intent that abuse has. 10. Evidence of the right to practice optometry by a person other than one. 11. Upon whom it was conferred, or to whom such license was granted. 12. C. With fraudulent intent to offer such a diploma or license or 13. To use or attempt to use it when it is so altered. 14. 275. 124. Formerly 1240. 122. Corporate practice. 15. Prohibited exceptions. The practice of optometry in a corporate. 16. Capacity is prohibited, but this prohibition does not apply to a 17. Professional corporation form pursuant to this Article 275 or 2A. 18. Optometry practice carried on by a non-profit organization operating to. 19. Assisted indigent persons. 20. 275. 125. Formerly 1240. 123. Enforcement. Injunction. 21. Defense. 1. When the board is reasonable cause to believe that any. 22. Persons violating any provision of this Article 275 right, lawful, or law. 23. Regulation issued under this Article 275. It may, in addition to all actions. 24. Provided for in this Article 275 and without prejudice thereto. End rent. 25. Order in accordance with section December 20th, 405 requiring such. 26. Person to desist or refrain from such violation. An action may be. 27. Brought in the relation of the people of the state of Colorado by the. Minus 1399. 1172. 1. Attorney General, additionally, the board may seek injunctive. Do relief in accordance with section December 20th, 406 to enjoin such 3% from engaging in or continuing such the violation or from doing, or any active furtherance thereof, in any such action in order or judgment, may be after warning such preliminary or final injunction as may be. 16. Proper the violation. 7. 2. When legal actions are instituted against the board member or any authorized personnel for acts occurring while acting in an official. 9. Capacities in such the actions are free of malice, fraud, or willful. 10. Neglect of duty. The member or employee served shall forthwith transmit. 11. Any process served upon an order of the Attorney General who shall 12. Furnish counsel and defend against such the action without cost to the 13. Board member or employee. 14. 275. 126. Formerly 1240. 124. Unauthorized practice. 15. Penalties. Any person who practices or offers or attempts to practice. 16. Optometry without an active license issued under this article commits a. 17. Last 2 misdemeanor and shall be punished as provided in section 18-1.3-501 CRS for the first offense, and any person who commits a. 19. Second or any subsequent offense commits a class 6 felony and shall be 20 punished as provided in section 18-1.3-401 CRS 275 is subject to 21 penalties pursuant to section December 20th, 407 1. 22. 275. 127. Formerly 1240. 125. Professional service. 23. Corporations, limited liability companies, and registered limited. 24. Liability partnerships for the practice of optometry. Definitions. 25. 1. Persons licensed to practice optometry that the board may form. 26. Professional service corporations for the practice of optometry under the 27 Colorado Corporation Code, if such Colorado business. Minus 1400. 1172. 1 Corporation Act, Articles 101 to 117 of Title 7 with the corporations. They are organized and operated in accordance with the provisions of this free section. The articles of incorporation of such a corporation shall, or contain provisions complying with the following requirements. 5. And the name of the corporation shall contain the words. 6. Professional company or professional corporation or abbreviations. 7 thereof. 8. B. The corporation shall be organized solely for the purposes of not conducting the practice of optometry only through persons licensed by 10. The board to practice optometry in the state of Colorado. 11. C. The corporation may exercise the powers and privileges 12 conferred upon corporations by the laws of Colorado only in furtherance. 13. Nothing subject to its corporate purpose. 14. D. All shareholders of the corporation shall be persons who are 15. Licensed by the board to practice optometry in the state of Colorado and 16. With all times own their shares in their own right. They shall be 17. Individuals who, except for illness, accident, and time spent in the yard. 18. Services, on vacations, and on leaves of absence not to exceed 1 year. 19. Not actively engaged in the practice of optometry in the offices of the 20 corporation. 21. E. Provisions shall be made requiring any shareholder who. 22. Ceases to be, or for any reason is ineligible to be a shareholder to dispose. 23. Alters the shareholder's shares forthwith, even to the corporation. 24. To any person having the qualifications described in paragraph D of. 25. To subsection 1, subsection 1D of this section. 26. F. The president shall be a shareholder and director, and to the 27 extent possible, all other directors and officers shall be persons having. Minus 1401. 1172. 1. The qualifications described in paragraph D of this subsection 1. To subsection 1D of this section. Lay directors and officers shall not. Free exercise any authority whatsoever over professional matters as defined, or in this Article 275, or in the rules and regulations as promulgated by the 5 Board. 6. G. The articles of incorporation shall provide, and all 7 shareholders of the corporation shall agree, and all shareholders of the corporation shall be jointly and severally liable for all acts, matters, and 9 omissions of the employees of the corporation, for all shareholders of 10. The corporation shall be jointly and severally liable for all acts, matters, and 11 omissions of the employees of the corporation, except during periods of 12 time when the corporation shall maintain a good standing professional. 13. Liability insurance which shall meet the following minimum. 14. Standards. 15. I. The insurance shall insure the corporation against liability. 16. Imposed upon the corporation by law and the performance of professional. 17. Services for others by those officers and employees of the corporation. 18. Who are licensed by the board to practice optometry. 19. II. Such the policies shall insure the corporation against liability. 20. Imposed upon it by law for damages arising out of the acts, matters, and 21. Omissions upon unprofessional employees. 22. II. The insurance shall be an amount for each claim of at least 23. $50,000 multiplied by the number of persons licensed to. 24. Practice optometry employed by the corporation. The policy may provide. 25. For an aggregate maximum limit liability per year for all claims of 1. 26. $150,000 also multiplied by the number of persons. 27. Licensed to practice optometry employed by the corporation, but no firm. Minus 1402. 1172. 1 shall be required to carry insurance in excess of $300,000. $2 for each claim with an aggregate maximum limit liability for. For all claims during the year of $900,000. 4. 5. The policy may provide that it does not apply to any 5. Dishonest, fraudulent, criminal, or malicious act or omission of the 6. Insured corporation or any stockholder or employee thereof. The conduct. 7. Of any business enterprise as distinguished from the practice of the optometry in which the insured corporation under this section is not. None permitted to engage, but which that nevertheless may be owned by the 10. Insured corporation, or in which the insured corporation may be a partner. 11. Or which that may be controlled, operated, or managed by the insured. 12. Corporation in its own, or in a fiduciary capacity including the ownership. 13. Maintenance, or use of any property in connection with, or not. 14. Resulting from breach of professional duty, bodily injury to, or sickness. 15. Disease or death of any person, or to injury to or destruction of any. 16. Tangible property, including the loss of use thereof, and the policy may. 17. Contain reasonable provisions with respect to policy periods, territory. 18. Claims, conditions, and other usual matters. 19. 2. Repealed. 23, 2. The corporation shall do nothing which, if done by 21, a person employed by and licensed to practice optometry in the state of 22, Colorado, would violate the standards of professional conduct as 23 provided for in this Article 275. Any violation by the corporation of this 24 section shall be grounds for the board to terminate or suspend its right to 25. Practice optometry. 26. 4. 3. Nothing in this section shall be deemed to diminish or 27. Change the obligation of each person employed by the corporation and -1403, 1172. 1. License to practice optometry in the state to conduct his licensees. 2. Practice in accordance with the standards of professional conduct. 3. Provided for in this Article 275. Any person licensed by the board to 4. Practice optometry who by act or omission causes the corporation to act. 5. Or fail to act in a way which violates such standards of 6. Professional conduct, including any provision of this section, shall be 17. Personally responsible for such the act or omission shall be 8. Subject to discipline or 4. 9. 5. Or a professional service corporation may adopt a pension. 10. Cash profit sharing, deferred profit sharing, whether cash or 11. Deferred health and accident insurance, or welfare plan for all or part of all of its employees, including lay employees, if such a plan does not require. 13. Result in the sharing of specific or identifiable fees with lay employees. 14. And if any payments made to lay employees or to any such plan. 15. Behalf of lay employees are based upon their compensation or lingo. 16. Service for both, rather than the amount of fees or income received. 17. 6. 5. Except as provided in this section, corporations shall not. 18. Practice optometry. 19. 7. 6. As used in this section, unless the context otherwise. 20. Requires. 21. Articles of incorporation includes operating agreements of 22. Limited liability companies and partnership agreements of registered. 23. Limited liability partnerships. 24. B. Corporation includes a limited liability company organized. 25. Under the Colorado Limited Liability Company Act, Article 8 of Title 26. 7. CRS and limited liability partnership registered under section 27. 7. 60. 1447 64 1002 CRS. -1404 1172. 1. C. Director and officer of the corporation includes a member, being a manager of a limited liability company and a partner registered. 3. Limited liability partnership. 4. D. Employees includes employees, members, and managers of 5. Limited liability company and employees and partners of a registered. 6. Limited liability partnership. 7. E. Chair includes a member's rights in a limited liability. 8. Company and a partner's rights in a registered limited liability partnership. 9. F. Shareholder includes a member of a limited liability. 10. Company and a partner in a registered limited liability partnership. 11. 12275 128 formerly 1240 126 Financial responsibility. 12 rules. 1. Every optometrist will provide healthcare services within the 13. State of Colorado shall establish financial responsibility as follows. 14. By maintaining commercial professional liability insurance. 15. Coverage with an insurance company authorized to do business in this. 16. State a minimum indemnity amount of $1 million per incident. 17. And $3 million annual aggregate per year. Or 18. B. By maintaining a surety bond in a form acceptable to the 19. Commissioner of Insurance of the amounts set forth in paragraph 20 subsection 1 subsection 1 of this section. Or 21. C. By depositing cash or cash equivalents as security with 22. Commissioner of Insurance of the amounts set forth in paragraph 23 subsection 1 subsection 1 of this section. Or 24. D. By providing any other security acceptable to the 25. Commissioner of Insurance, which may include approved plans of 26. Self-insurance. 27. 2. And the board may, by rule, establish lesser financial -1405 1172. 1. Responsibility standards and those required in subsection 1 of this new section for classes of license holders who have an active license or who, 3. Unlimited or occasional optometry services because of administrative 4. Are non-clinical duties, partial or complete retirement, or for other 5 reasons that title limits provided in paragraph 9 subsection 1 6 subsection 1 of this section unreasonable or unattainable. 7. B. Nothing in this section precludes or otherwise prohibits a 8. Licensed optometrist from rendering appropriate patient care on an 9. Occasional basis when the circumstances surrounding the need for such 10. So warrant. 11. 3. Each optometrist, as a condition of receiving and maintaining 12. An active license to provide optometry services in the state shall furnish 13. Report evidence of compliance with subsection 1 of this section. No. 14. License shall be issued or renewed unless such evidence of compliance 15 has been furnished. 16. 4. Notwithstanding the amounts specified in subsection 1 of 17. This section, if the board receives 2 or more reports concerning any 18 optometrists pursuant to section 1240 12712 275 129 during any 19 1-year period, the minimum financial responsibility requirement shall 20 be 2 times the amount specified in subsection 1 of this section. 21. However, upon motion filed by the optometrist in the presentation of 22. Sufficient evidence to the board that 1 or more such reports involved. 23. An action or claim which that did not represent any substantial failure. 24. To adhere to accepted professional standards of care, the board may 25. Reduce such the additional amount to that which would be fair. 26. Optionable. 27. 5. Repealed. -1406 1172. 1. 12 275 129 formerly 1240 127 judgments and settlements. 2. Reporting any final judgment, settlement, or arbitration award against 3. An optometrist for malpractice shall be reported within 14 days by 4. Such the optometrist malpractice insurance carrier in accordance with 5. Section October 1st 125 CRS or by such the optometrist if no commercial 6. Malpractice insurance coverage is involved to the board for review. 7. Investigation and or appropriate disciplinary or other action. 20. The optometrist who knowingly fails to report as required by this section shall 9. Be subject to a civil penalty of not more than $2,510. Such the penalty shall be determined and collected in that action. 11. Brought by the board in the district court in the city and county of Denver. 12. Which court shall have exclusive jurisdiction in such matters. All 13. Penalties collected pursuant to this section shall be transmitted to the state. 14. Treasurer who shall credit the same to the general fund. 15. 12 275 130 formerly 1240 128 repealed article subject to 16. Sunset Law 1. This article 275 is repealed effective September 1st 2022. 17. Before the repeal, the functions of the board performed. 18. Pursuant to this article 275 are scheduled for review in 19. Accordance with section 24 34 104. 22. The provisions of section 24 34 104 CRS concerning the 21. Termination schedule for regulatory bodies of the state unless extended. 22. As provided in that section are applicable to the functions performed. 23. Pursuant to this article. 24. Article 280. 25. Pharmacists, pharmacy businesses, and pharmaceuticals. 26. Part 1. 27. General provisions. -1407 1172. 1. 12 280 101 formerly 12-42.5-101 public interest rules. 2. Practice of pharmacy is a professional practice affecting the public health. 3. Safety and welfare is subject to regulation and control of the public for interest. It is a matter of public interest and concern that the practice of 5. Pharmacy, as defined in this article 280, merits and receives the 6 confidence of the public, and that only qualified persons be permitted to 7. Practice pharmacy in the state. This article 280 is literally construed to it carry out these objects and purposes pursuant to these standards and 9. Obligations. The state board of pharmacy may adopt rules of professional 10. Conduct in accordance with article 4 title 94 CRS 11 12 280 102 applicability of common provisions articles 1 12 20 and 3 of this title apply according to their terms to this. 13. Article 280 14 12 280 103 formerly 12-42.5-102 definitions rules as used. 15. In this article 42.5 280 unless the context otherwise requires for the term. 16 is otherwise defined in another part of this article 42.5 280. 17. 1. Administer means the direct application of the drug to the 18 body of a patient or research subject by injection, inhalation, ingestion. 19. Or any other method. 22. Advertise means to publish or display information about 21. Prescription prices or drugs in any medium. 22. 3. Anabolic steroid is same meaning is set forth in 23 Section 1A, 1A, 1023 CRS. 24, 3.5, 4. Authorized distributor of record means wholesaler. 25. With payment manufacturer has established an ongoing relationship to. 26. Distribute the manufacturer's prescription drug for purposes of this. 27. Subsection 3.5, 4. An ongoing relationship is between distribute minus 1408, 1172. When a wholesaler and the manufacturer of the wholesaler, including any affiliated group of the wholesalers defined in Section 1504 of the Free Federal Internal Revenue Code of 1986, as amended, complies with the following. 5. The wholesaler has a agreement currently in effect. 6. With the manufacturer evidencing such the ongoing relationship. And 7. B. The wholesaler is listed on the manufacturer's current list of the authorized distributors of record, which list is updated by the non-manufacturer on no less than a monthly basis. 10. 3.7. 5. Biological product has the same meaning as. 11. Biological product as defined set forth in 42 U.S.C. Section 262. I-1. Well, 4. 6. Board means the state board of pharmacy created in 13 Section 12280 104. 14. 5. 7. Bureau means the Drug Enforcement Administration. Or 15. Successor agency of the United States Department of Justice. 16. 6. 8. Casual sale means transfer, delivery, or distribution to. 17. Corporation, individual, or other than a consumer entitled. 18. To possess prescription drugs, except that the amount of drugs transferred. 19. Delivered or distributed in such manner by any registered. 20. Prescription drug outlet or hospital outlet shall not exceed 10. 21% of the total number of posted units of drugs dispensed and. 22. Distributed on an annual basis by such the outlet. 23. 6.5. 9. Chain pharmacy warehouse means a physical location. 24. For prescription drugs that serves as a central warehouse and performs. 25. Intercompany sales or transfers of prescription drugs to a group of chain. 26. Pharmacies or other chain pharmacy warehouses that are under common. 27. Ownership or control, notwithstanding any other provision of this article. Minus 1409, 1172. 1. 280. A chain pharmacy warehouse receiving distributions on behalf of or making distributions to an intercompany pharmacy need not be a free authorized distributor of record to be part of the normal distribution or channel. 5. 7. 10. A compounding means preparation, mixing, 6. Assembling, packaging, or labeling of a drug or device. 7. I. As the result of a practitioner's prescription drug order, chart. In order, or initiative, based on the relationship between the practitioner, non-patient, and pharmacist in the course of professional practice, or 10. II. For the purpose of, residence of 2. Research, teaching, or 11. Chemical analysis, and not for sale or dispensing. 12. B. Compounding also includes the preparation of drugs, or 13. Devices in anticipation of prescription drug orders based on routine. 14. Regularly observed prescribing patterns. 15. 8. 11. Controlled substance shall have the same meaning as. 16. In Section 1A, 1A, 1025 CRS. 17. 9. Well, delivery means the actual, constructive, or attempted. 18. Transfer of the drug or device from one person to another, whether or not. 19. For consideration. 20. 10. 13. Device means an instrument, apparatus, implement. 21. Machine, contrivance, implant, or similar related article that is required. 22. Under federal law, the guard label. Caution. Federal law requires. 23. Dispensing by on the order of a physician. Device also includes. 24. Any component part of or accessory or attachment to any such article. 25. Whether or not the component part, accessory, or attachment is separately. 26. Labeled. 27. 11. 14. Dispense means to interpret, evaluate, and implement. Minus 14. 10. 1172. When a prescription drug or drug order, including the preparation of a new drug or device preparation for a patient staged in a suitable container, free appropriately labeled for subsequent administration for use by a patient. Or 12. 15. Distribution means the transfer of the drug or device. 5. Other than by administering or dispensing. 6. 13. 16. A drug means. 7. I. Substances recognized as drugs of the official compendia. 8. II. Substances intended for use in the diagnosis, cure, mitigation, non-treatment, or prevention of disease in individuals or animals. 10. III. Substances other than food intended to affect the structure. 11. Or any function of the body of individuals or animals. And 12. I. Substances intended for use as a component of any substance. 13. Specified in subparagraph I, or II of this paragraph. 14. Subsection 16. I. 16. II or 16. II of this section. 15. B. Drug does not include devices or their components, parts. 16. Or accessories. 17. 13.5. 17. FDA means the Federal Food and Drug. 18. Administration. 19. 14. 18. Generic drug type means the chemical or generic. 20. Name as determined by the United States adopted names using. 21. Counsel and accepted by the Federal Food and Drug Administration. 22. FDA of those drug products having exactly the same active. 23. Chemical ingredients in exactly the same strength and quantity. 24. 15. 19. Hospital means a general hospital or specialty hospital. 25. Having a license or certificate of compliance issued by the Department of. 26. Public Health and Environment. 27. 16. 20. Hospital satellite pharmacy means a satellite app. Minus 14. 11. 1172. 1. Registers pursuant to Section 12-42.5-117 10 12 280 119 10 for the due purpose of administration of drugs to patients while being treated in the free facility. 4. 16.5. 21. Interchangeable in reference to a biological. 5. Product means. 6. Interchangeable interchangeability as determined by. 7. The FDA pursuant to 42 U.S.C. Section 262 K or 8. B. That the FDA has deemed a biological product non-therapeutically equivalent to another biological product as set forth in the 10 latest edition or supplement of the FDA approved drug products with 11 therapeutic equivalence evaluations also referred to as the Orange 12 book. 13. 17. 22. Intermediate person who is 14. I. Enrolled in a professional degree program of Explorer. 15. College of Pharmacy that has been approved by the board. 16. II. Guaranteed licensed by the board to engage in the practice of. 17. Pharmacy. 18. II. Satisfactorily progressing or meeting the requirements. 19. For licensure as a pharmacist. 20. B. Repealed. 21. C. B. A graduate and approved professional degree program of. 22. A school or college of pharmacy or graduate who has established. 23. Application equivalency by obtaining the board approved foreign pharmacy. 24. Graduate certification and who is currently licensed by the board for the 25. Purpose of obtaining practical experience as a requirement for licensure. 26. As a pharmacist. Or 27. D. C. A qualified applicant awaiting examination for licensure. Minus 14. 12. 1172. What is a pharmacist? Or meeting board requirements for licensure. 2. 18. 23. Labeling means the process of preparing and affixing. 3. Labeled to any drug container. Exclusive, however, of labeling by a. 4. Manufacturer, packet, or distributor of a non-prescription drug or. 5. Commercially packaged drug or device. Any such label shall. 6. Include all information required by federal and state law or regulation. 7. 19. 24. Location means the physical confines of an individual. A building or at the same address. 9. 19.5. 25. Long-term care facility means a nursing facility. S. 10. Defined in Section 25.103 14 CRS. That is licensed pursuant to. 11. Section 25-1.5-103 CRS. 12. 20. 26. Manufacture means to cultivate, grow, or prepare by. 13, not a processed drugs for sale to wholesalers or other persons entitled to. 14, purchase drugs other than the ultimate user, but manufacturer does not. 15, include the compounding and dispensing of a prescription drug pursuant. 16, to a prescription order. 17, 20.5, 27, manufacturer's exclusive distributor means the person. 18, new contracts with the manufacturer to provide or coordinate warehousing. 19, distribution or other services on behalf of the manufacturer and who takes. 20, title to the manufacturer's prescription drug, but who does not have. 21, general responsibility to direct the sale or disposition of the. 22, manufacturer's prescription drug, to be considered part of the normal. 23, distribution channel, as defined in section 12-42.5-301-612-80301. 24, 6, a manufacturer's exclusive distributor shall be unauthorized. 25, distributor of record. 26, 21, 28, non-prescription drug means a drug that may be sold. 27, without a prescription that is labeled for use by the consumer in. Minus 14, 13, 1172. In accordance with the requirements of the land rules of the state and. To the federal government. 3, 22, 29, nuclear pharmacy means a specialized pharmacy that. 4, deals with the preparation and delivery of radioactive materials defined. 5, in section November 25th, 101, CRS. 6, 23, 30, official compendium means the official United States. 7, pharmacopoeia, national formulary homeopathic pharmacopoeia of 8 in the United States, or any supplements thereto. 9, 24, 31, order means. 10, a prescription order that is any order, other than a chart order. 11, authorizing the dispensing of a single drug or device that is written. 12, mechanically produced, computer generated and signed by the. 13, practitioner, transmitted electronically or by facsimile, or produced by. 14, other means of communication by a practitioner to a licensed pharmacy. 15, or pharmacist that includes the name or identification of the patient. 16, the date, the system or purpose for which the drug is being prescribed. 17, if included by the practitioner of the patient's authorization and sufficient. 18, information for compounding, dispensing, and labeling, or. 19, B, a chart order, which is an order for inpatient drugs, or. 20, medications that are to be dispensed by a pharmacist or by a pharmacy. 21, entered under the direct supervision of a pharmacist and administered by. 22, an authorized person only during the patient's stay at a hospital, medical. 23, clinic operated by a hospital, ambulatory surgical center, hospice, or. 24, long-term care facility. The chart order shall contain the name of the. 25, patient and the medicine ordered, and such the directions as the. 26, practitioner may prescribe concerning strain, dosage, frequency, and. 27, route of administration, minus 14, 14, 1172. 1, 25, 32, better outlet means. 2, at a hospital that does not operate a registered pharmacy, or free health clinic, a federally qualified health center, as defined in section. 4, 1861, AA, 4, of the Federal Social Security Act, 42 U.S.C. Sections 1395X. 5, AA, 4, a family planning clinic, and a treatment unit license title. 6, Department of Public Health and Environment, a school, a jail, a county order. 7, District Public Health Agency, a community health clinic, a university, or. 8, college act. 9, I, as facilities of the state, registered pursuant to this article. 10, 280, and 11, I, engages in the compounding, dispensing, and delivery of. 12, drugs or devices. 13, B, an ambulatory surgical center license pursuant to Part 1 of. 14, Article 3 of Title 85, CRS, a medical clinic operated by a hospital, RA. 15, hospice license pursuant to Part 1 of Article 3 of Title 85, CRS, RA. 16, I, as facilities of the state, registered pursuant to this article. 17, 280, and 18, I, engages in the compounding, dispensing, and delivery of. 19, drugs or devices for administration to patients, all being treated in the 20 facility, or. 21, C, and leprosy outlet. 22, 26, 33, patient counseling means the oral communication by. 23, a pharmacist or information to the patient about order. 24, to improve therapy by ensuring proper use of drugs and devices. 25, 27, 34, pharmaceutical care means the provision of drug. 26, therapy and other pharmaceutical patient care services by a pharmacist. 27, intended to achieve outcomes related to the cure or prevention of A. Minus 14, 15, 1172. 1, disease elimination or reduction of the patient's symptoms or rescue or. Use slowing of the disease process, in addition to the preparation, dispensing, free and distribution of medications, pharmaceutical care may include. 4, assessment and evaluation of the patient's medication-related needs and. 5, development and communication of the therapeutic plan with defined. 6, outcomes and consultation with the patient and the patient's other health. 7, care professionals to obtain the desired outcome. This function includes 8, efforts to prevent, detect, and resolve medication-related problems for 9, individual patients. Pharmaceutical care does not include prescriptive. 10, authority, except that a pharmacist may prescribe only over the counter. 11, medications to a recipient under the Colorado Medical Assistance Act. 12, is authorized pursuant to section 25.322 or pursuant to A. 13, collaborative pharmacy practice agreement is defined in section. 14, 12-42.5-601, 1B, 12, 601, 1B. 15, 28, 35, pharmacist means an individual licensed by the state. 16, to engage in the practice of pharmacy. 17, 29, 36, pharmacist manager means an individual licensed in. 18, to stay as a pharmacist who has direct control of the pharmaceutical. 19, affairs of a prescription drug outlet and was not the manager of any. 20, other prescription drug outlet. 21, 29.5, 37, pharmacy buying cooperative warehouse means A. 22, permanent physical location that acts as a central warehouse for. 23, prescription drugs and from their sales of prescription drugs are made. 24, to an exclusive group of pharmacies that are members or member owners. 25, of the buying cooperative operating the warehouse. 26, 30, 38, pharmacy technician means an unlicensed person who. 27, performs those functions set forth in paragraph B of subsection 31. Minus 14, 16, 1172. 1, subsection 39, B of the section under the supervision of a pharmacist. 2, 31, 39, practice of pharmacy means. 3, the interpretation, evaluation, implementation, and dispensing. 4, orders, recipitation, route and device selection, drug administration. 5, program and reviews, and drug-related research, provision of. 6, patient counseling, and the provision of those acts or services necessary. 7, to provide pharmaceutical care in all areas of patient care. 8, B, I, the preparation, mixing, assembling, packaging, labeling. 9, or delivery of a drug or device. 10, II, proper and safe storage of drugs or devices. 11, II, the maintenance of proper records for such drugs and. 12, devices. 13, C, the provision of a therapeutic interchange selection array. 14, therapeutic equivalent selection to a patient to bring the patients. 15, stay at a nursing care facility or long-term acute care hospital licensed. 16, under Part 1, Article 3 of Title 85, CRS, the selection has been. 17, approved for the patient. 18, I, in accordance with written guidelines and procedures for. 19, making therapeutic interchange or therapeutic equivalent selections. 20 is developed by a quality assessment and assurance committee that. 21 includes a pharmacist licensed under this Article 280 and is formed by the. 22, nursing care facility or long-term acute care hospital in accordance. 23 with 42 CFR 483.75 and. 24, II, by one of the following healthcare providers. 25, A, a physician licensed under Article 36, 240 of this Title 12. 26, B, a physician assistant licensed under Section 12-36-107.4. 27, 1240, 113, if the physician assistant is under the supervision of A. Minus 1417, 1172. 1 licensed physician, or 2, C, an advanced practice nurse prescribed or licensed as A. 3 professional nurse under Section 1238, 11112, 255, 110, registers N. 4 advanced practice nurse under Section 12-38-111.5, 12, 255, 111, and 5 authorized to prescribe controlled substances or prescription drugs. 6 pursuant to Section 12-38-111.6, 12, 255, 112, if the advanced practice. 7 nurse prescriber has developed and articulated plan to maintain ongoing in collaboration with physicians and other healthcare professionals. 9. 32, 40, practitioner means a person authorized by law to 10, prescribe any drug or device acting within the scope of such 11, authority, including a pharmacist who is participating within the parameters of a statewide therapy protocol pursuant to a 13 collaborative pharmacy practice agreement as defined in section 14, 12-42.5-601, 1B, 12-280, 601, 1B, or prescribing over the counter. 15 medications pursuant to section 25.322. 16, 33, 41, prescription means the finished product of the 17, dispensing of a prescription order and appropriately labeled and suitable. 18, container. 19, 34, 42, prescription drug means a drug that. 20, is required by any applicable federal or state law or rule to be. 21, dispensed only pursuant to an order. 22, B, is restricted by any applicable federal or state law or rule to. 23, used by practitioners only. 4. 24, C, prior to being dispensed or delivered, is required under federal. 25, law to be labeled with one of the following statements. 26, I, RX only. 4. 27, II, caution, federal law restricts this drug to use by minus 14, 18, 1172. One order of a licensed veterinarian. 2. 35, 43, prescription drug outlet or pharmacy means any free pharmacy outlet registered pursuant to this article 280 where all prescriptions are compounded and dispensed. Prescription drug outlet. 5 includes without limitation a compounding prescription drug outlet. 6 registered pursuant to section 12-42.5-117 9 12 280 119 9 4. 7 specialized prescription drug outlet registered pursuant to section 8 12-42.5-117 11 12 280 119 11 9. 36, 44, refill means the compounding and dispensing of any 10 drug pursuant to a previously executed order. 11, 36.3, 45, repackaging means repackaging or otherwise. Bulk changing the container, wrapper, or labeling to further distribution of. 13, a prescription drug, excluding repackaging or labeling completed by the 14, pharmacist responsible for dispensing product to the patient. 15, 36.5, 46, repackager means a person who repackages. 16, prescription drugs. 17, 37, 47, sample means any prescription drug given free of. 18, charge to any practitioner for any reason, except for bona fide research. 19, program. 20, 38, 48, satellite means an area outside the prescription drug. 21, outlet where pharmaceutical clearance services are provided, and that is in. 22, the same location. 23, 39, 49, supervision means the licensed pharmacist is under. 24, location and readily available to consult with and assist in licensed. 25% are performing tasks described in paragraph B of subsection 31. 26, subsection 39B of this section, if the unlicensed person is A. 27, pharmacy technician located at registered pharmacy outlet, minus 1419, 1172. One licensed pharmacist need not be physically present at the pharmacy. Do outlet as long as the licensed pharmacist is connected to the pharmacy. 3 outlet 5 computer link, video link, and audio link, or by other, 4 telecommunication equipment with equivalent functionality and is readily. 5 available to consult with and assist the pharmacy technician in. 6, performing tasks described in paragraph B of subsection 31. 7, subsection 39B of this section. 8. 39.5, 50, and 11 outlet means remote pharmacy, 9 side that. 10, I is registered as another outlet under this article 280. 11, II, at the time of registration, is located more than 20 miles. Bulk from the nearest prescription drug outlet and from any other. 13, 11 outlet registered under this article 280. 14, II, is connected by computer link, video link, and audio link. 15, or by other functionally equivalent telecommunication equipment with. 16, a central pharmacy that is registered under this article 280. And 17, I, has a pharmacy technician on site who, under the remote. 18, supervision of a licensed pharmacist located at the central pharmacy. 19, perform the tasks described in paragraph B of subsection 31. 20, subsection 39B of this section. 21B, the board may adopt rules as necessary to specify additional. 22, criteria for an emergency outlet that the board deems necessary. 23, 39.7, 51, therapeutic interchange means the substitution of. 24, one drug for another drug with similar therapeutic effects. 25, 40, 52, therapeutically equivalent or equivalent means. 26, those compounds containing the identical active chemical ingredients of. 27, identical strength, quantity, and dosage form, and the same generic. Minus 14, 20, 1172. One drug type, which, when administered in the same amounts, will provide. Do the same therapeutic effects as evidenced by the control of the same tumor. 3 disease. 4, 41, 53, ultimate user means a person who lawfully possesses. 5, prescription drug for disorder or use for the use of a member of the 6 person's household, or for use in administering to an animal owned by the 7 person or a member of his or her household. 8, 42, 54, and wholesale distribution means distribution of. 9, prescription drugs to persons or entities other than consumer or patient. 10, B, wholesale distribution does not include. 11, I, intercompany sales or transfers of prescription drugs, all including a transaction or transfer between a division, subsidiary, parent. 13, or affiliated or related company under common ownership or control of. 14, entity. 15, II, the sale, purchase, distribution, trade, or transfer of A. 16, prescription drug or offer to sell, purchase, distribute, trade, or transfer. 17, prescription drug for emergency medical reasons or during a stay order. 18, national declaration of emergency. 19, II, the sale or transfer of the drug for medical reasons by retail. 20, pharmacy to another retail pharmacy to alleviate a temporary shortage. 21, I, the distribution of prescription drug samples by A. 22, manufacturer's representative. 23, B, drug returns when conducted by a hospital, healthcare. 24, entity or charitable institution in accordance with 21 CFR 200.3.23. 25, B, the sale of minimal quantities of prescription drugs by retail. 26, pharmacies to licensed practitioners for office use. 27, I, a retail pharmacy's delivery of prescription drugs to A. Minus 14, 21, 1172. 1, patient or patient station pursuant to the lawful order of a licensed. 2, practitioner. 3, 8, the sale, transfer, merger, or consolidation of all or part of. 4, the business of a pharmacy or pharmacies from or with another pharmacy. 5, or pharmacies, whether accomplished as a purchase and sale of stock or. 6, business assets. 7, IX, the direct sale, purchase, distribution, trade, or transfer of. 8, a prescription drug from a manufacturer to an authorized distributor of. 9, record to an additional authorized distributor of record, but only if N. 10, authorized distributor of record that purchases a prescription drug from. 11, an authorized distributor of record that purchases a prescription drug, all directly from the manufacturer. 13, A, provide the supplying authorized distributor of record with. 14, a verifiable statement that the product is unavailable from the 15, manufacturer. And 16, B, receives a verifiable statement from the supplying authorized. 17, distributor of record that the product was purchased directly from the 18, manufacturer. 19, X, the delivery of or offer to deliver a prescription drug by A. 20, common carriers fully the common carrier's usual course of business. 21, transporting prescription drugs where the common carrier does not. 22, store, warehouse, or take legal ownership of the prescription drug. 23, site, the sale or transfer from a retail pharmacy or chain. 24, pharmacy warehouse expired, damaged, returned, or recalled. 25, prescription drugs to the original manufacturer or to a third party returns. 26, processor. 27, CI, the sale or transfer of compounded drugs compounded by. Minus 14, 22, 1172. 1, retail pharmacy as defined in subsection 7, 10 of this section and has. Be authorized by section 12-42.5-118, 6B, 1280, 120, 6B. 3, CI, the transfer of prescription drugs within Colorado. 4, purchased with public funds by the Department of Public Health and 5, Environment, created in Section January 25th, 102, CRS, for District Dark County. 6, Public Health Agency, created pursuant to Section January 25th, 506, CRS, and 7, Procurator by a physician licensed in Colorado, was legally executive. 8, Director or the Chief Medical Officer appointed pursuant to Section 9, January 25th, 105, CRS, for a Public Health Director or Medical Officer of the county. 10, or District Public Health Agency selected pursuant to Section January 25th, 508. 11, 5, C.I. CRS, the transfers may only be made to the Department of Both Public Health and Environment pursuant to the Colorado Medical License. 13, the Executive Director or Chief Medical Officer at District Dark County. 14, Public Health Agency pursuant to the Colorado Medical License of the 15, Public Health Director or Medical Officer for a physician licensed in 16, Colorado. 17, the distribution of naloxone. 18, XV, the distribution, donation, for sale by a manufacturer or 19, wholesaler of a stock supply of epinephrine auto-injectors to the public. 20, schools or non-public schools for emergency use by designated school. 21, in accordance with the requirements of Section January 22nd, 119.5, 22 CRS, for other entities for emergency use in accordance with the 23 requirements of Article 47 of Title 85 CRS. 24, 43, 55, wholesaler means a person engaged in the wholesale. 25, distribution of prescription drugs to persons other than consumers. New. 26, are entitled to possess prescription drugs, including repackagers. 27, own label distributors, private label distributors, jobbers, brokers. Minus 1423, 1172. 1. Warehouses, including manufacturers and distributors' warehouses. 2, manufacturers, exclusive distributors, authorized distributors of record. 3, drug wholesalers or distributors, independent wholesale drug traders. 4, pharmacy buying cooperative warehouses, retail pharmacies that conduct. 5, wholesale distribution, and chain pharmacy warehouses that conduct. 6, wholesale distribution. 7, 12280 104, formerly well, #42.5, #103, State Board of Pharmacy. 8, creation, subject to determination, regular parts. 1, the responsibility for enforcement of this Article 280 is vested in the state. 10, Board of Pharmacy, which is hereby created. The Board has 11 duties, powers, and authorities specifically granted by necessary to the enforcement of this Article 280, as well as other duties, powers, and 13, authorities may be granted by statute from time to time, except as 14, otherwise provided to the contrary, the Board shall exercise all its duties. 15, powers and authority in accordance with the State Administrative. 16, Procedure Act, Article 4 of Title 94, CRS. 17, 2, the Board shall exercise its powers and perform its duties and 18, functions specified by this Article 280 under the Department of Regulatory. 19, agencies of the Executive Director of the Department, as the same work. 20, transfer to the Department by a Type 1 transfer, as is defined in the 21, Administrative Organization Act of 1968, Article 1 of Title 24, CRS. 22, 23, 24, 3. Section 24, 104, CRS, concerning the determination. Schedule for regulatory bodies of the state, unless extended as provided. In that section, applies to the State Board of Pharmacy created by this. 25, Section 26, B, Parts 1 to 3 of this Article 280 are repealed, effective September 27, 2021. Prior to the further repeal, the Department of minus 1424, 1172. 1, regulatory agencies shall review the board and the regulation of the 2 packets of pharmacy pursuant to Parts 1 to 3 of this Article as provided. 3 of 280 are scheduled for review in accordance with Section 4, 24, 34, 104, CRS. 5, 12, 280, 105, formerly well, #42.5, #104, membership of the board. 6, removal, compensation, meetings. 1, and the board is composed of 7, 5 licensed pharmacists, each having at least 5 years experience in 8, the state actively engaged in the practice of pharmacy in the state. 9, non-pharmacists who have no financial interest in the practice of 10, pharmacy. 11, B, the governor shall make all appointments to the board in 12 accordance with this section. 13, C, for purposes of achieving a balance of the membership on the 14 board, the governor shall consider 15, I, whether the appointee's home is in 16, A, and more rural location, and 17, B, an area already represented geographically by another 18, appointee on the board, and 19, II, the type of practice of the appointee, so the various types of 20 practices are represented on the board. 21, DI, the term of office of each member is 4 years. 22, II, in the case of an appointment to fill a vacancy, the appointee. 23 shall complete the unexpired term of the former board member. 24, II, no member of the board may serve more than 2. 25, consecutive full terms. 26, E, no more than 4 members of the board shall be members of. 27, the same major political party. Minus 1425, 1172. 1, F, the governor shall appoint the pharmacist members in A. 2 managers to ensure that the term of the board member expires July 1st of each 3 year. 4, 2, the governor may remove any board member from misconduct. 5, incompetence or neglect of duty. 6, 3, each member of the board shall receive the compensation. 7, provided for in section 24, 34, 102, 13, CRS, December 20th, 103, 6. 8, 4, the board shall hold meetings at least once every 4 months. 9, at the times and places fixed by the board. At one meeting, the board 10 shall elect a president and a vice president. The majority of the members. 11 of the board constitutes a quorum for the conduct of business, except, if otherwise, provided in this part 1, all actions of the board must be by 13, a majority of the quorum. The board shall give full and timely notice of all 14 meetings of the board pursuant to any requirements of state laws. All 15 board meetings and hearings are open to the public, except that the board may 16 conduct any portion of its meetings in executive session close to 17 the public, as may be permitted by law. 18, 12, 280, 106, formerly well, #42.5, #104.5, veterinary. 19, pharmaceutical advisory committee, creation, appointments, rules. 20, repeal. 1, 9, there is created in the Department of Regulatory. 21 agencies, the veterinary pharmaceutical advisory committee comprised of 22 3 members, each appointed by the state veterinary service authority. 23, the commissioner of agriculture pursuant to section 3550104 CRS has 24 follows. 25, A, 1 member who is a licensed veterinarian who 26, predominantly works on large animals, having at least 5 years. 27, experience in the state, in good standing, and actively engaged in the minus 1426, 1172. 1, practice of veterinary medicine. 2, B, 1 member who is either licensed pharmaceutical. 3, wholesaler engaged in the distribution of animal drugs, having at least 4 5 years experience in the state, in good standing, and actively engaged. 5, in the practice of wholesale pharmacy or licensed veterinarian, having 6, at least 5 years experience in the state, in good standing, and actively. 7, engaged in the practice of veterinary medicine, but who is not both A. 8, pharmaceutical wholesaler and veterinarian, and 9, C, 1 member who has a background in agriculture, and 2, 10 is not a pharmacist, pharmaceutical wholesaler, or veterinarian. 11, II, the state veterinarian shall choose a person who does not do all business along the front range for at least one other professional. 13, appointments on the advisory committee. 14, B, the members of the advisory committee serve for a year. 15 terms, except that the state veterinarian shall appoint one of the initial 16 members of the advisory committee for a 2-year term. If there is a 17 vacancy on the advisory committee, the state veterinarian shall appoint 18 a successor to the unexpired portion of the member's term. 19, C, I, the advisory committee shall elect a member to serve as 20, chart of the advisory committee. The advisory committee shall meet as 21, required by the board in accordance with subsection 2 of this section. 22, II, members of the advisory committee serve without 23, compensation or reimbursement of expenses. 24, II, a member of the advisory committee shall not perform an 25, official act that 26, A, may provide direct economic benefit to a business or other. 27, undertaking in which the member has direct or substantial financial. Minus 1427, 1172. 1, interest, or 2, B, involves a person with whom the member has engaged in a 3, substantial number of business transactions. Or D, the Department of Regulatory Agencies shall provide staff. 5, assistance to the advisory committee. unless a matter presented to the board constitutes an 7 emergency requiring prompt resolution, the board shall refer the following matters that concern veterinary pharmaceuticals to the advisory. 9 committee for recommendation on how the board should proceed on the 10 matter. 11. I, whether and to what extent action, if any, should be taken on. 12. An investigation into or complaint of any violation of this article. 13. 280, including whether to. 14. A. Suspend or revoke a license or registration. 15. B. Impose a fine against a licensee or registrant, whether the 16 violation is egregious and the amount of any fine recommended. 17. C. Seek a restraining order or injunction in civil court against A. 18% or. 19. D. Pursue other disciplinary action against a licensee, registrant. 21. Other person. 21. II. Review of license and registration applications and renewal. 22. Reactivation and reinstatement applications. 23. II. Promulgation of rules. 24. B. Upon being referred a matter by the board, the advisory. 25. Committee shall meet in person or by teleconference as soon as. 26. Practical to review matter. The board shall share all documents. 27. Recordings and other materials that are relevant to the matter referred. Minus 1428, 1172. 1. The advisory committee for the advisory committee's review of the matter. The advisory committee shall treat all shared materials as free confidential. The advisory committee shall provide the board written for recommendation on how the board should proceed on the matter referred. 5. Setting forth its findings and conclusions. At the advisory committee's 6. Discretion. The advisory committee may also present its recommendations. 7. To the board in person or by teleconference. 8. C. The board shall adopt the advisory committee's 9. Recommendation on a referred matter unless the board determines that 10. There exists material and substantial evidence or information related to 11. Matter that warrants a resolution of the matter that is distinct from the 12. Advisory committee's recommendation. If the board deviates from the 13. Advisory committee's recommendation, the board shall make a record of 14. The reasons for the deviation. 15. 3. The board, in consultation with the state veterinarian, may 16. Promulgate rules to implement this section. 17. 4. If this section is repealed, effective September 1st, 2026. 18. B. Before the repeal of this section, the Department of Regulatory 19 agencies shall review the advisory committee pursuant to a schedule 20 for review in accordance with section February 3rd, 1203 CRS 21. 12380 formerly 12-42.5-105 rules. 1. The board shall 22. Make, adopt, amend, or repeal rules in accordance with Article 4 of Title 24 CRS and Section December 20th, 204 that the board deems necessary for 24. The proper administration and enforcement of the responsibilities and 25. Duties delegated to the board by this Article 280, including those relating 26. To nuclear pharmacies. 27. 2. On or before January 1st, 2016, the board shall adopt or amend minus 1429, 1172. 1. Rules as necessary to permit the dispensing of an opiate antagonist in accordance with Section 12-42.5-123, Sections December 30th, 110 and 3. 12280, 123, 4. 12280, 108, formerly 12-42.5-106, powers and duties. 5. 1. The board shall 6. Inspect or direct inspectors who are licensed pharmacists to 7. Inspect, allow, let, and investigate violations of this Article 280. 8. B. Prescribe forms and receive applications for licensure and non-registration and grant, renew, reactivate, and reinstate licenses and registrations. 11. C. Deny, suspend, or revoke licenses or registrations. 12. D. Apply to the courts for and obtain in accordance with the 13 Colorado Rules of Civil Procedure restraining orders and injunctions and 14. Accordance with Section December 20th, 406 to enjoin violations of the laws. 15. That the board is invited to enforce. 16. E. Administer examinations to and determine the qualifications. 17. And fitness of applicants for licensure or registration. 18. F. Keep a record of. 19. I. All licenses, registrations, and license and registration. 20. Renewals, reactivations, and reinstatements for a reasonable period. 21. II. All suspensions, revocations, and any other disciplinary. 22. Actions. And 23. III. Its own proceedings. 24. G. Collect all fees prescribed by this Article 280 in section. 25. December 20th, 105. 26. H. Fine registrants when consistent with the provisions of this 27. Article 280 and rules adopted pursuant to this Article 280. Minus 1430, 1172. 1. I. Conduct investigations, hold hearings, and take evidence. B. In all matters relating to the exercise and performance of the powers and free duties of the board in accordance with Section December 20th, 403. 4. II. A. The board or an administrative law judge may administer 5 votes, take affirmations of witnesses, and issue subpoenas to compel 6. 7. 8. 9. 10. 11. 12. 13. 14. 15. 16. 17. 18. 19. Attendance of witnesses in the production of all relevant papers, books, records, documentary evidence, and materials in any hearing, investigation, accusation, or other matter before the board. B. The board may appoint an administrative law judge pursuant to the content of Article 30 of Title 24 CRS to take evidence, make findings, and report the findings to the board. II. Upon failure of any witness to comply with the subpoena or process, the district court of the county in which the subpoenaed person or licensee resides or conducts business upon application by the board, with notice to the subpoenaed person or licensee may issue to the person or licensee an order requiring that person or licensee to appear before the board to produce the relevant papers, books, records, documentary evidence, or materials if so ordered, or to give evidence touching the matter under investigation or in question. The court may hold the person or licensee in contempt of court for failure to obey the order of the court. 21. J. Review and approve or reject applications for participation in 22. The Pharmacy Care Health Assistance Diversion Program pursuant to Part 23. 2 of this Article 280 and perform any other functions that were before. 24. By the Rehabilitation Evaluation Committee prior to its repeal. 25. 2. The board's other duties, powers, and authorities may be 26. Necessary to enforce this Article 280 and the rules adopted pursuant to this. 27. Article 280 minus 1431, 1172. 1. 3. The board may 2. Adopt a seal to be used only in the manner of the board. 3. Prescribes. 4. B. Promulgate rules governing the compounding of 5. Pharmaceutical products, which rules must address the following. 6. I. Training and qualifications. 7. II. Quality control. 8. II. Internal operating procedures. 9. I. Procurement of compounding materials. 10. B. Formulation, documentation, and testing requirements. 11. B. Equipment standards. 12. I. Facility standards. And 13. 8. A recall system. 14. 4. I. Whenever duly authorized agent of the board finds order. 15. Has probable cause to believe that in any registered outlet, any drug, 16. Non-prescription drug, or device is adulterated or misbranded within the 17. Meaning of the Colorado Food and Drug Act, Part 4, Article 5 of Title 18. 25. CRS. The agent shall affix to the article tag or other appropriate. 19. Marking giving notice. 20. A. That the articles are suspected of being adulterated or 21. Misbranded. 22. B. That the article has been obtained or part of. And 23. C. Warning all persons not to remove or dispose of the article by 24. Sale or otherwise until the board, its agent, or the court gives permission. 25. For removal or disposal. 26. II. No person shall remove or dispose of an embargoed article by 27. Sale or otherwise without the permission of the board or its agent or after. Minus 1432, 1172. 1. Summary proceedings have been instituted without permission from the court. 3. B. If the board or the court removes the embargo, neither. 4. Board or the state is liable liable for damages because of the embargo. 5 court finds that there was probable cause for the embargo. 6. C. When an agent finds that an article contained or embargoed. 7 under paragraph of this subsection 4. Subsection 4 of this 8 section is adulterated or misbranded. The agent shall petition the judge. 9 of the district court of whose jurisdiction the article is contained or 10 embargoed for an order for condemnation of the article by the agent. 11 finds that an article so contained or embargoed is not adulterated or 12 misbranded. He or she shall remove the tag or other marking. 13. D. I. If the court finds that a contained or embargoed article is 14 adulterated or misbranded except as provided in subparagraph I of this 15 paragraph D subsection 4 D I of this section. The court shall 16 order the article after entry of the decree to be destroyed at the expense. 17 of the owner of the article under the supervision of the agent, the owner. 18 of the article or the owner's agent shall bear all court costs and fees. 19 storage and other proper expense. 20 I when the owner can direct the adulteration or misbranding. 21 by proper labeling or processing of the article after entry of the decree. 22 after the owner has paid the costs, fees, and expenses and has posted. 23 good and sufficient bond condition that the article be properly. 24 labeled or processed. The court may direct order that the article be. 25 delivered to the owner for proper labeling or processing under. 26 supervision of an agent. The owner shall pay the expense of the agents. 27 supervision. The bond must be returned to the owner of the article once. Minus 1433 1172. When the board represents to the court that the article is no longer in violation due to the embargo and that the owner has paid the expenses of supervision. 3. E. It is the duty of the Attorney General or the District Attorney to reporting the board reports any violation of this subsection 4 to institute 5 appropriate proceedings in the proper courts without delay. 2. 6. Prosecute the matter in the manner required by law. Nothing in this 7th paragraph E subsection 4 E requires the board to report violations. 8. When the board believes the public interest will be adequately served in under circumstances by suit or with notice or warning. 10. 120 formerly 12-42.5-107 drugs, devices, and other. 11 materials. 1. The board is responsible for the control and regulation of 12 drugs, including the following. 13. For the regulation of the sale, retailing, and dispensing of drugs. 14. B. The specification of minimum professional and technical. 15. Equipment, environment, supplies, and procedures for the compounding. 16. Or dispensing of medications and drugs. 17. C. The control of the purity and quality of drugs. 18. 2. The board is responsible for the control and regulation of the 19 sale of devices at retail, except that the board shall not regulate the sale. 20. Any disposable veterinary device. The board may also exempt from. 21. Regulation of veterinary devices. 22. That are regulated by the FDA or 23. B. For which the board determines regulations is necessary. 24. 110 formerly 12-42.5-108 publications. The board. 25 shall issue its publications that are circulated in quantity outside the 26 executive branch in accordance with section January 24, 136. CRS the board. 27 shall circulate its publications to a registered prescription route less. Minus 1434 1172. 1 that will be directly affected by the publications. 2. 120 formerly 12-42.5-109 reporting malpractice. 3 claims. 1. Each insurance company licensed to do business in this state or engaged in the writing of malpractice insurance for licensed. 5 pharmacists and pharmacies and each pharmacist or pharmacy that 6 self-insurers shall send to the board in the form prescribed by the board 7 information relating to each malpractice claim against the licensed. 8 pharmacist that is settled or in which judgment is rendered against the not insured. 10. 2. The insurance company or self-insured pharmacist or 11 pharmacy shall provide information relating to each malpractice claim as 12 is deemed necessary by the board to conduct a further investigation and 13 hearing. 14. 3. Information relating to each malpractice claim provided by 15 insurance companies or self-insured pharmacists or pharmacies is exempt. 16 from the provisions of any law requiring that the proceedings of the 17 board be conducted publicly for the minutes and records of the board. 18 be open to public inspection unless the board takes final disciplinary. 19 action. The board may use the information in any formal hearing. 20 involving a licensee or a registrant. 21. 112 formerly 12-42.5-110 fees. 1. The director of. 22. The division of professions and occupations shall determine. And 23. Board shall collect fees pursuant to section 2434105 CRS December 20th 105. 24. For the following licenses and registrations. 25. After certifying to another state the grades of a person who has. 26. Taken a pharmacist examination in this state. 27. B. For the initial licensure upon examination as a pharmacist. Minus 1435 1172. 1 as provided in section 12-42.5-112 or 120 4. 2. C. For the initial licensure without examination and upon presentation of evidence of licensure in another state as a pharmacist as or provided in section 12-42.5-112 8. 120 8. 5. D. For the renewal of the license as a licensed pharmacist as 6 provided in section 12-42.5-114 1. 120 116 1. 7. E. For reinstatement as a licensed pharmacist as provided in 8 section 12-42.5-114 2. 120 116 2. 9. F. For the transfer of the prescription route outlet registration to A. And the owner as provided in section 12-42.5-116 2. 120 118 2. 11. G. For the transfer of the manager's name as provided in section 12-42.5-116 1. 120 118 1. 13. H. For the issuance of a duplicate certificate to a license. 14. Pharmacist. 15. I. For the initial licensure as a pharmacy intern. 16. J. For the issuance of a duplicate license of a pharmacy intern. 17. K. For the transfer of the prescription route outlet registration to A. 18. New location as provided in section 12-42.5-116 2. 120 118 2. 19. L. For reissuing a prescription route outlet registration to new 20 store name without change of owner or manager as provided in section 21 12-42.5-116 2. 120 118 2. 22. M. For the initial registration or the renewal of the registration. 23. Of the prescription route outlet as provided in section 12-42.5-116 2. 24. 120 118 2. 25. N. For the initial certificate evidence in the section for all. 26. Pharmacists. 27. O. For the initial and renewal registration of all other less. Minus 1436 1172. 1 under section 12-42.5-117 120 119 not covered in this section. 2. P. For the initial and renewal registration of all non-resident. 3. Prescription route outlets under section 12-42.5-130 120 133. 4. Q. For the initial and renewal registration of humane societies. 5. And animal control agencies pursuant to section 12-42.5-117 12. 6. 120 119 12. 7. 2. Any pharmacist licensed in Colorado for 50 years or more. Any pharmacist is exempt from the payment of fees under this article 280. None is allowed to practice as a licensed pharmacist. 10. 120 113 formerly 12-42.5-111 approval of schools 1A. 11 school or college of pharmacy that is approved by the board of the school. 12 or college of pharmacy from which graduation is required in order for the 13 graduate of the school or college of pharmacy to apply for a license as A. 14 pharmacists must meet the requirements set forth by the board. 15. 2. The board may utilize the facilities, reports, requirements, and 16 recommendations of any recognized accrediting organization and 17 determining the requirements for a school or college of pharmacy. 18. 3. The board shall maintain a list of approved schools or 19 colleges. 20, 114, formerly 12-42.5-112, licensure registrations. 21, applicability, applications, licensure requirements, rules. 1, this. 22, Article 280 applies to all persons in the state engaged in the practice of. 23, pharmacy and outlets in the state engaged in the manufacture. 24, dispensing, production, sale, and distribution of drugs, devices, and other. 25, materials used in the treatment of injury, illness, and disease. 26, 2, have the applicant for a license under this Article 280 must. 27, read and write the English language, or if the applicant is a partnership. Minus 1437, 1172. When each member of the partnership must read and write the English language. If the applicant is a Colorado corporation, the corporation must. 3, being good standing, and if the applicant is a foreign corporation, it must. 4, be qualified to do business in this state. 5, B, the board shall issue the appropriate registration to each. 6, manufacturer and wholesaler that meets the requirements of this article. 7, 280, unless the board determines that the issuance of the registration it would be inconsistent with the public interest in determining the public. 9, interest, the board shall consider the following factors. 10, I, maintenance of effective controls against diversion of. 11, controlled substances to legitimate medical, scientific, or industrial. 12, channels. 13, II, compliance with applicable state and local laws. 14, III, any conviction of the applicant under any federal or state. 15, relating to a controlled substance. 16, I, past experience of the manufacture or distribution of. 17, controlled substances in the existence in the applicant's establishment. 18, of effective controls against diversion. 19, B, any false or fraudulent information in an application filed. 20, under this part 1. 21, B, suspension or revocation of the applicant's federal. 22, registration to manufacture, distribute, or dispense a controlled substance. 23 is authorized by federal law. 24, I, any other factors relevant to and consistent with the public. 25, peace, health, and safety. 26, 3, every applicant for license or registration under this article. 27, 280 shall make written application in the manner and form prescribed by. Minus 1438, 1172. When the board, setting forth the applicant's name and address, the applicant's 2, qualifications for the license or registration, and other information. 3, required by the board, the applicant shall submit with the application of 4, required fee, and if the applicant is required to take an examination. 5, applicant shall appear for examination at the time and place fixed by the 6th board. 7, 4, I, an applicant who has graduated from a school or a college of pharmacy approved by the board may take an examination. 9, before the board. 10, II, the examination must be designed fairly to test the applicants. 11, knowledge of pharmacy and other related subjects, and must be uniform. 12, approved by the board. The examination cannot be administered orally. 13, III, an applicant for licensure by examination shall have. 14, complete an internship as prescribed by the board. 15, B, a person who produces evidence satisfactory to the board that. 16, the person has graduated and obtained a degree from a school of. 17, pharmacy outside the United States and has passed a foreign graduate. 18, equivalency test given or approved by the board may apply to take the 19 examinations set forth in paragraph of this subsection or subsection. 24 of this section. 21, 5, every applicant for licensure as a pharmacist, whether by. 22, examination, transfer of license, reactivation, or reinstatement shall take. 23, interest examination approved by the board that just such. 24, applicant's knowledge of the laws of the state. 25, 6, no applicant shall exercise the privileges of licensure or. 26, registration until the board grants the license or registration. 27, 7, the board may require any applicant for licensure to display. Minus 1439, 1172. 1, with moral competency in English, the board may utilize a. Do standardized test to determine language proficiency. 3, 8, a person licensed by examination and in good standing in. 4, another state may apply for a license transfer. The board shall designate 5, clearinghouse for license transfer applicants and the person applying for. 6, a license transfer shall apply for the clearinghouse designated by the 7 board. 8, 9, the board shall adopt rules as necessary to ensure that 90% manufactures drugs and any wholesaler of drugs possesses 10 minimum qualifications required for wholesale drug distributors. 11, pursuant to the Federal Prescription Drug Marketing Act of 1987. 21. 12 U.S.C. Section 353 as amended. 13, 10, a person whose license has been revoked shall not reapply. 14, licensure earlier than 2 years after the effective date of the 15, revocation. 16, 11, 10, issuance of license or registration under this section. 17 in section 12-42.5-117, 1, 2, 3, 0, 119 does not entitle licensee or 18 registered facility or outlet to wholesale, manufacture, distribute, 19 dispense or professionally use controlled substances beyond the scope, 20 disorder the licensees or registrants federal registration. 21, 1, 2, 3, 0, 115, formerly 12-42.5-113, exceptions from licensure. 22, hospital residency programs or renal analysis, research. 23, companies. 1, the board is authorized to approve hospital residency. 24, programs in the practice of pharmacy, persons accepted into and approved. 25, hospital residency program who are licensed to practice pharmacy in. 26, knowledge data are exempt from the licensing requirements of this article. 27, 280, so long as their practice is limited to participation in the residency. Minus 1440, 1172. 17 by the board, to provide assistance to veterinarians needing content, 18 treating with physical, emotional, or psychological conditions that may, 19 reduce their ability to practice veterinary medicine. 1 program. The board shall select 1 or more. 2, this article 280 does not apply to the sale or delivery of a free dialysis solution if all of the following conditions are met. 4, the sale or delivery is made directly by the manufacturer. 2, 5, a person with chronic kidney failure or to the destiny of the person. 6, B, the sale or delivery is for the purpose of self-administration. 7, by the person pursuant to an order by a physician lawfully practicing in. 8, the state. And 9, C, the solution is sold or delivered in original packages properly. 10, labeled and adulterated in accordance with the requirements of the emotional or psychological conditions. Social work. Evaluate the extent of physical, emotional, or psychological. Social work. Examine for the veterinary for appropriate treatment. Social work. 11 Colorado Food and Drug Act, Part 4, Article 5 of Title 85, CRS. 12 the Federal Food, Drug, and Cosmetic Act, 21 U.S.C. Section 301 and the following. 13 was amended. 14, 3, a manufacturer that must obtain a prescription drug or device. 15, solely for use in research, development, or testing procedures of that. 16 does not further distribute the drug or device may apply to the board for. 17, waiver of registration pursuant to the subsection 3, the board may. 18, grant waiver if the manufacturer submits to the board the name of the 19 drug or device it requires and an affidavit certifying that the drug or 20 device will only be used for necessary research, development, or testing. 21 procedures and will not be further distributed. A waiver granted pursuant. 22 to subsection 3 does not apply to a controlled substance as defined. 23 in section 1818102.5 CRS or in federal law. 24, 4, an employee of the facility as defined in section 25-1.5-301. 25 CRS who is administering and monitoring medications to persons. 26 under the general jurisdiction of the facility pursuant to part 3 of article. 27, 1.5 of title 25 CRS need not be licensed by the board lawfully. Minus 1441, 1172. 1 possess controlled substances under this article 280. 2, 1, 2, 3, 0, 116, formerly 12-42.5-114, expiration and renewal of. 3 licenses or registrations. 1, all licenses and registrations expire. 4, pursuant to a schedule established by the director of the division of. 5 professions and occupations within the Department of Regulatory Agencies. 6 must be renewed or reinstated pursuant to Section 24, 34, 1028, 7, 8, 9, 10, 11. CRS the Director of the Division of Professions and Occupations may establish renewal fees and delinquency fees for reinstatement pursuant to Section 24, 34, 105. CRS if the person fails to renew his or her license or registration pursuant to the schedule established by the Director of the Division of Professions and Occupations. The license or registration all expires issued pursuant to this Article 280 are subject to the 13 renewal, expiration, reinstatement, and delinquency fee. 14 provisions specified in Section December 20th, 202, 1, and 2. Any person 15 whose license or registration expires is subject to the penalties provided. 16 in this Article 280 or Section 24, 34, 1028, 8. CRS December 20th, 202, 1. 17. 2. A pharmacist who fails to renew his or her license or 18 before the applicable renewal term may have his or her license reinstated. 19 in accordance with Section December 20th, 202, 2. For the remainder of the 20 current renewal period by filing a proper application satisfying the board. 21 that the pharmacist is fully qualified in practice and payment. 22 reinstatement fee as provided in Section 12-42.5-110 1E 12 112 23 1E and all delinquent fees. 24 3 except for depository. The board shall not mandate 25 license to a pharmacy under more than 2 years after the applicant has. 26 cease to be enrolled student in a college or school of pharmacy. 27 approved by the board. Minus 1442 1172. 1 1 2 2 0 117 formerly 12-42.5-115 continuing education. 2 exceptions. Negative status 1 except as permitted in subsections 2. 3 and 3 of this section. The board shall not renew, reinstate, or reactivate for the license of any pharmacist until the pharmacist presents evidence that 5 he or she has completed 24 hours of approved continuing 6 pharmaceutical education within the preceding 2 years. Subject to 7 subsection 9 of this section. The evidence may be provided by checking. It is unauthorized on the license renewal application. 9 2. The board may renew the license of a pharmacist who 10 presents or acceptable evidence that the pharmacist was unable to comply. 11 with subsection 1 of this section. 12b. The board may grant a 6-month compliance extension to 13 pharmacists who are unable to comply with subsection 1 of this section. 14 3. The board may renew the license for the first renewal period. 15 following the issuance of the original license without requiring a 16 pharmacists to complete any continuing pharmaceutical education. 17 pharmacists obtains a license within 1 year after the completion of the 18 pharmacists pharmaceutical education. 19 4. To qualify for continuing education credit, a program of 20 continuing pharmaceutical education must be currently approved by the 21 Accreditation Council on Pharmaceutical for Pharmacy Education or 22 equivalent accrediting body as determined by the board. 23 5. Each program of continuing pharmaceutical education must 24 consist of at least 1 continuing education unit, which is 1 hour of 25 participation in organized continuing educational experience. 26 including postgraduate studies, institutes, seminars, lectures, conferences. 27 workshops, correspondence courses, essay programs, programmed. Minus 1443 1172. 1 learning courses, audiovisual programs, internet programs, and any other due form of presentation that is accredited. 3 6. Any aspect of the practice of pharmacy may be the subject of or a program of continuing pharmaceutical education, including 5 pharmaceutics, compounding, pharmacology, pharmaceutical chemistry, 6 biochemistry, physiology, microbiology, pharmacy administration, and 7 professional practice management. 8 7. A program of continuing pharmaceutical education may not include the following. 10. A definite stated objective. 11. B. Presentation in an organized manner. And 12. C. A method of program evaluation that is suitable to the type of. 13. Program being presented. 14. 8. A program of continuing pharmaceutical education must meet 15 requirements as established by the accrediting body. 16. 9. The board may annually audit up to 5% of the 17 pharmacists licensed and residing in Colorado to determine compliance. 18 with this section. 19. 10. If a licensed pharmacist fails to obtain the 24 hours. 20 of approved continuing pharmaceutical education, the pharmacist's 21 license becomes inactive. An inactive licensee is not required to comply. 22 with any continuing pharmaceutical education requirement, so long as the 23 licensee remains inactive, but the licensee must continue to pay 24 applicable fees, including renewal fees. The board shall note inactive. 25 status on the face of any license issues to a licensee while the licensee. 26 remains inactive. Should an inactive pharmacist wish to resume the 27 practice of pharmacy after being placed on an inactive list, the pharmacist. Minus 1444 1172. 1 shall file an application to activate his or her license, pay the license, do renewal fee, and subject to subsections 2 and 3 of this section meet 3 to 24-hour continuing education requirement. If a licensed 4 pharmacist engages in the practice of pharmacy while in an active status, 5 that conduct may be grounds for license revocation under this Article 280. 6 1 2 280 118 formerly 12-42.5-116 prescription route outlet. 7 under charge of pharmacist 1 and prescription route outlet must be 3 under the direct charge of the pharmacist manager, a proprietor who is not. None of the pharmacists shall comply with this requirement and shall provide a 10 manager who is a pharmacist. 11 B. The registration of any prescription route outlet becomes void. 12 the pharmacist manager whose name the prescription route outlet. 13 registration was issued ceases to be engaged as the manager, the owner. 14 shall close the prescription route outlet unless the owner. 15 I. Employs a new pharmacist manager. 16 II. Within 30 days after termination of the former managers. 17 employment. 18 A. Applies to transfer the registration to the new pharmacist. 19 manager. 20 B. Pays the registration transfer fee. 21 C. At the time the pharmacist manager whose name 22 registration was obtained ceases to be employed as the pharmacist. 23 manager. He or she shall immediately report to the board the fact that he. 24 she is no longer manager of the prescription route outlet. 25 pharmacist manager is responsible as the manager until the cessation of. 26 employment is reported. The proprietor of the prescription route outlet. 27 shall also notify the board of the termination of managership. Minus 1445 1172. 1 2. A prescription route outlet shall not commence business until. Unit applies to the board for registration and receives from the board A. Pre-registration showing the name of the proprietor and the name of the board manager. Upon transfer of the ownership of the prescription route outlet. 5. The new proprietor shall submit to the board an application to transfer the 6 registration of the prescription route outlet. And upon approval of the 7 transfer by the board shall transfer the registration to the new 8 proprietor. Upon the change of name or location of the prescription drug 9 outlet, the registrant shall submit an application to change the name or 10 location of the applicable fee. And upon approval of the application. 11 board shall issue a new registration showing the name or new 12 location. 13 3. A prescription route outlet operated by the state of 14 Colorado or any political subdivision of the state is not required to be 15 registered, but in lieu of registration must apply to the board on a form. 16 approved by the board for a certificate of compliance. The board shall 17 determine whether the prescription route outlet is operated in accordance. 18 with the laws of the state and rules of the board, if the board. 19 determines that the prescription route outlet is operated in accordance. 20 with state laws and board rules, except for the holding of a prescription. 21 route outlet registration. The board shall issue a certificate of compliance. 22 whose certificate expires and may be renewed in accordance with section 23 24 34 1028 CRS December 20th 202 1. Once the board issues the certificate. 24 of compliance. The prescription route outlet has the rights and privileges. 25 of and is treated in all respects as a registered prescription route outlet. 26 the provisions of this Article 280 with respect to the denial, suspension. 27 or revocation of the prescription route outlet registration applied to A. Minus 1446 1172. 1 certificate of compliance. 2 B. An outlet is recognized in section 12-42.5-117 1 D. 3, 1, 2, 3, 0, 1, 1, 9, 1, D, need not be under the direct charge of the pharmacist. 4, a licensed pharmacist shall either initially interpret all prescription. 5, orders compounded or dispensed from the outlet or provide written. 6, protocols for compounding and dispensing by licensed persons. N. 7, outlet qualifying for registration under this paragraph. B, subsection. 8, 3, B, may also apply to the board for waiver of the requirements, not concerning physical space, equipment, inventory, or business hours as. 10, necessary and consistent with the outlet's limited public welfare purpose. 11, in determining the granting or denial of the waiver application, the board. 12, shall ensure that the public interest criteria set forth in section 13, 12-42.5-101, 1, 2, 3, 0, 1, 0, 1 are satisfied. All other provisions of this article. 14, 280, except as specifically waived by the board, apply to the outlet. 15, 4, every outlet and every pharmacist and pharmacy intern. 16, regularly practicing, shall conspicuously display the registration and 17, license, respectively, within the premises of the place of practice or 18, outlet. 19, 5, the pharmacist responsible for the prescription order or chart. 20, order may delegate certain specific tasks described in section 12-42.5-102. 21, 31, B, 1, 2, 3, 0, 103, 39, B, to a person who is not a pharmacist or. 22, pharmacy intern, but who is a licensed assistant under the pharmacists. 23, supervision in the pharmacist's professional judgment, the delegation. 24 is appropriate, except that the pharmacist shall not make the delegation. 25, the delegation jeopardizes the public health, safety, or welfare. 26, prohibited by rule of the board, or violates section 12-42.5-126, 1. 27, 1, 2, 3, 0, 1, 2, 9, 1, minus 1447, 1172. 1, 1, 2, 3, 0, 1, 1, 9, formerly 12-42.5-117, registration of facilities. 2, rules. 1, all outlets with facilities of the state shall register with the 3.1 of the following classifications. 4, a prescription drug outlet. 5, B, wholesale drug outlet. 6, C, manufacturing drug outlet. 7, D, any other outlet, as may be authorized by this Article 280 order. 8, that meets the definition of outlet as set forth in section 12-42.5-102, 25. 9, 1, 2, 3, 0, 103, 32. 10, 2, the board shall establish by rule criteria consistent with 11, section 12-42.5-112, 1, 2, 3, 0, 114, and with the public interest as set forth. 12 in section 12-42.5-101, 1, 2, 3, 0, 101, and outlet that is employees or. 13, personnel engaged in the practice of pharmacy must meet the qualified for. 14, registration in each classification. 15, 3, the board shall specify under the registration procedures. 16, applicants must follow, including the specifications for application for. 17, registration of the information needed. 18, 4, registrations issued by the board pursuant to this section are. 19, transferable or signable only pursuant to this Article 280 rules. 20, established by the board. 21, 5, it is lawful for a person to sell and distribute non-prescription. 22, drugs, any person engaged in the sale and distribution of non-prescription. 23, drugs is not improperly engaged in the practice of pharmacy, and 24, board shall not promulgate any rule pursuant to this Article 280 that. 25, permits the sale of non-prescription drugs only by a licensed pharmacist. 26, or only under the supervision of a licensed pharmacist or that would. 27, otherwise apply to, or interfere with the sale and distribution of, minus 1448, 1172. 26, any lending institution to require the purchase of home worthy. 27, insurance as a condition for granting financing for the purchase of the, minus 180, 1172.
It says nuance power.
Nuance?
Whatever that
There's a lot of nuance in there.
is. Yeah, there is. Well said.
Guess you're back on, Andrew.
We know where we ended. Should we stand in the, oh, we can't stand in the center. We just have to say where we look at each other. We're not done. Cookie, it's not. I can text you guys when we're getting close. Oh. You trying to do something?
How long do they go for? And what time is it? 2 and 3.
Current statute number 123910.
So that's good to know that we have I'll try to let people know that. So this is a conspiracy theory. Okay, so we got to page 1969, and it was because of all just the format of it. Okay, the columns and the dots and the things. But I think we can be pretty confident that we know we've read and haven't read because of the nature of that page. Okay. Thank you. I like this pen. I can keep this. slow 50 pages. Mercy roll yet, buddy? Mercy roll yet? Or are we just gonna read the index? Who's this guy? This is what we have to read. Who's that guy?
That's carried on. Some guy sleeping in the chambers.
Or just blinking.
Hey, you should have said, I don't know, I'm not in the chamber. I was in part, I was listening to sure you were in my office. Charlie Brown's teacher. Oh, what are we going to try to do something? Yeah, I keep it.
Hey, James.
So give me some time to figure this out. All right, bye-bye.
Last 50 pages.
Regarding proposed statute no. Statute no. 12-38.1-111 1P 12260114 1M 12-38.1-111 1Q 1260114 10 12-38.1-111 1R 1260114 1P 12-38.1-111 1S 1260114 1Q 12-38.1-111 1U 1260114 1R 12-38.1-111 1B 1260114 1S 12-38.1-111 1W 1260114 1T 12-38.1-111 1X 12260 1U 12-38.1 12-38.1-111 4 12260 114 3 12-38.1-112 12260 115 12-38.1 1 12260 115 IP 1 12-38.1-112 1 12260 115 1 12-38.1-112 IP 1 B 12260 115 IP 1 B 12-38.1-112 1 B I 12260 115 1 B I 12-38.1-112 1 B I 12260 115 1 B I 12-38.1-112 1 C 12260 115 1 C 12-38.1-112 1 D 12260 115 1 D 12-38.1-112 1 E 12260 115 1 E 12-38.1-113 12260 116 12-38.1-113 1 12260 116 1 12-38.1-113 2 12260 116 2 12-38.1-113 2 B 12260 116 2 B 12-38.1-113 3 12260 116 3 12-38.1-113 4 12260 116 4 12-38.1-113 5 12260 116 5 12-38.1-114 12260 117 12-38.1-114 1 12260 117 1
It's reading the index.
12-38.1-114 2 12260 117 2 12-38.1-114 3 12260 117 3 12-38.1-114 4 12260 117 4 12-38.1-114 5 12260 117 5 12-38.1-114 6 repealed 12-38.1-114 7 12260 117 6 12-38.1-114 8 12260 117 7 12-38.1-114 9 12260 117 8 12-38.1-114 9 B 12260 117 8 B 12-38.1-114 10 12260 117 9 12-38.1-114 10 B repealed 12-38.1-114 10.5 12260 117 10 12-38.1-114 11 repealed 12-38.1-114 12 12260 117 11 12-38.1-114 13 12260 117 12 12-38.1-114 14 28 12260 117 13 12-38.1-115 12260 118 12-38.1-115 1 12260 118 1 12-38.1-115 2 12260 118 2 12-38.1-115 3 12260 118 3 12-38.1-115 4 12260 118 4 12-38.1-116 12260 119 12-38.1-117 12260 120 12-38.1-117 IP 1 12260 120 IP 1 12-38.1-117 1 12260 120 1 12-38.1-117 1 B 12260 120 1 B 12-38.1-117 1 C 12260 120 1 C Current proposed statute no 12-38.1-117 1 D 12260 120 1 D 12-38.1-117 1 E 12260 120 1 E 12-38.1-117 1 F 12260 120 1 F 12-38.1-118 12260 121 12-38.1-118 2 12260 121 12-38.1-119 12260 122 12-38.1-120 12260 123 1239 101 12265 101 1239 102 IP 12265 103 IP 1239 102 1 12265 103 1 1239 102 2 12265 103 2 1239 102 3 12265 103 3 1239 102 4 12265 103 4 1239 102 5 12265 103 5 1239 102 6 12265 103 6 1239 103 12265 104 12-39-103.5 12265 105 1239 104 12265 106 1239 104 IP 1 12265 106 IP 1 1239 104 1 I 12265 106 1 I 1239 104 1 I 12265 106 1 I 1239 104 1 B 12265 106 1 B 1239 104 2 12265 106 3 1239 104 2 B 12265 106 3 B 1239 104 3 12265 106 4 1239 104 4 12265 106 5 1239 104 5 12265 106 6 1239 104 6 repealed 12-39-104.5 IP 1 12265 106 IP 2 12-39-104.5 1 12265 106 2 I 12-39-104.5 1 B 12265 106 2 I 12-39-104.5 1 C 12265 106 2 I 12-39-104.5 2 12265 106 2 B 1239 105 12265 107 1239 105 IP 1 12265 107 IP 1 1239 105 1 I A 12265 107 1 1239105 1I B 123651071 B 1239105 1I 123651071 C 1239105 1I 123651071 D 1239105 1I 123651071 E 1239105 1 V 123651071 F I 1239105 1 B 123651071 F I 1239105 1 C repealed 1239105 3 123651072 1239105 3 B 123651072 B 1239105 4 123651073 123910612251008 1239106 ID 1 123651008 ID 1 1239106 1 123651008 1 1239106 1 B 123651008 1 B 1239106 1 C I 123651008 1 C I 1239106 1 C I 123651008 1 C I 1239106 2 123651008 2 1239107 122651009 1239107 1 122651009 1 minus 1968 1172 Current proposed statute no 1239107 3 122651009 2 1239107 4 122651009 3 1239107 6 122651009 4 12-39-107.5 122651007 4 1239108 1226510 1239108 1 1226510 1 1239108 3 1226510 2 1239108 4 1226510 3 1239108 5 1226510 4 1239108 6 1226510 5 1239108 7 1226510 6 1239108 8 9 repealed 1239108 10 1226510 7 1239109 1226511 1239109 1 1226511 1 1239109 2 1226511 2 1239109 3 1226511 3 1239110 26511 1239110 ID 1 1226511 ID 1 1239110 1 I 1226511 1 I 1239110 1 I 1226511 1 I 1239110 1 B 1226511 1 B 1239110 ID 2 1226511 ID 2 1239110 2 1226511 2 1239110 2 B 1226511 2 B 1239110 2 C I 1226511 2 C I 1239110 2 C I 1226511 2 C I 1239111 26513 1239111 ID 1 1226513 ID 1 1239111 1 1226513 1 1239111 1 B 1226513 1 B 1239111 1 C 1226513 1 C 1239111 1 D 1226513 1 D 1239111 1 E 1226513 1 E 1239111 1 F 1226513 1 F 1239111 1 G 1226513 1 G 1239111 1 H 1226513 1 H 1239111 1 I 1226513 1 I 1239111 1 J 1226513 1 J 1239111 1 K 1226513 1 K 1239111 1 L 1226513 1 L 1239111 1 M 1226513 1 M 1239111 1 N 1226513 1 N 1239111 1 O 1226513 1 O 1239111 2 1226513 2 1239111 3 1226513 3 1239111 3 B 3 C repealed 1239111 4 1226513 4 1239111 5 repealed 1239112 26514 1239113 26515 1239113 1 1226515 1 1239113 1 B 1226515 1 B 1239113 2 1226515 2 1239113 3 1226515 3 Current proposed statute no 1239114 26516 1239114 1 repealed 1239114 2 1226516 1 1239114 3 1226516 2 1239114 4 1226516 3 1239114 5 repealed 1239114 6 1226516 4 4 B 1239114 7 1226516 5 1239114 8 1226516 6 1239115 26517 1239115 1 1226517 1 1239115 2 1226517 2 1239115 3 1226517 3 1239116 26518 1239116 2 1226518 1239117 26519 1239117 1 to 5 1226519 1239118 265 1239119 265 121 1239120 265 122 1239121 265 123 1239121 12 265 123 140 101 275 101 140 102 275 103 140 102 1 275 103 1 140 102 ID 1 B 12275 103 ID 1 B 140 102 1 B I 12275 103 1 B I 12401029B 1B II 122751031 1B II 12401021B II A 122751031 B II A 12401021B II B 122751031 B II B 12401021 B II C 122751031 B II C 12401021 B II 122751031 B II 12401021 B I 122751031 B I 12401021 B B 122751031 B V 12401021 B B 122751031 B V 12401021 B V I 122751031 B V I 12401021 B 8 122751031 B 8 12401021 B X 122751031 B X 12401021 B X 122751031 B X 12401021 B Z 122751031 B Z 12401021 C 122751031 C 12401029 B 1 D 122751031 B 1 D 12401021 D I 122751031 D I 12401021 D I I 122751031 D I I 12401021 D I I 122751031 D I I 12401021 D I 122751031 D I 12401022 122751032 12401023 122751033 1240102 B 122751034 1240102 122751035 1240103 1240104 1240103 1 12275 104 1 1240103 1 12275 104 1 1240103 B 12275 104 1 B 1240103 1 C 12275 104 1 C minus 1969 1172 got it proposed
No.
statute no statute no
No.
124010412 275 105 105 106 1240105 ID 1 12275 106 ID 1 1240105 1 12275 106 1 1240105 1 B 12275 106 1 B 1240105 1 C 12275 106 1 C 1240105 1 D 12275 106 1 D 1240106 12275 107 1240106 1 12275 107 1 1240106 1 B 12275 107 1 B 1240106 1 C 12275 107 1 C 1240106 1 D 12275 107 1 D 1240106 2 12275 107 2 1240107 12275 108 1240107 ID 1 12275 108 ID 1 1240107 1 12275 108 1 1240107 1 B 12275 108 1 B 1240107 1 D 12275 108 1 C 1240107 1 G repealed 1240107 1 J 12275 108 1 D 1240107 1 K 12275 108 1 E 1240107 1 L 12275 108 1 F 1240107 1 M I 2 1 M I 12275 108 1 G 1240107 1 N 12275 108 1 H 12-40-107.2 12275 109 12-40-107.2 ID 1 12275 109 ID 1 12-40-107.2 1 12275 109 1 12-40-107.2 1 B 12275 109 1 B 12-40-107.2 ID 2 12275 109 ID 2 12-40-107.2 ID 2 12275 109 ID 2 12-40-107.2 2 I 12275 109 2 I 12-40-107.2 2 I 12275 109 2 I 12-40-107.2 ID 2 B 12275 109 ID 2 B 12-40-107.2 2 B I 12275 109 2 B I 12-40-107.2 2 B I 12275 109 2 B I 12-40-107.2 2 B I 12275 109 2 B I 12-40-107.2 2 B I 12275 109 2 B I 12-40-107.2 3 12275 109 3 12-40-107.2 4 12275 109 4 12-40-107.2 5 12275 109 5 12-40-107.2 6 12275 109 6 12-40-107.5 12275 108 2 1240108 12275 110 1240108 ID 1 12275 110 ID 1 1240108 1 12275 110 1 1240108 1 B 12275 110 1 B 1240108 1 C 12275 110 1 C 1240108 1 D 12275 110 1 D 1240108 1 E 12275 110 1 E 1240108 1 F 12275 110 1 F 1240108 ID 3 12275 110 ID 2 1240108 3 I A 12275 110 2 I A 1240108 3 I B 12275 110 2 I B 1240108 3 I A 12275 110 2 I A 1240108 3 I B 12275 110 2 I B got it proposed statute no statute no 1240108 B 122751102 B 12-40-108.5 1227511 124010912 1240109 112751121 1240109 112751122 1240109 3 122751123 1240109 4 122751124 12-40-109.5 122751113 12-40-109.5 112751131 12-40-109.5 1.5 122751132 12-40-109.5 2 122751133 12-40-109.5 3 122751134 12-40-109.5 4 I 2 4 I 122751135 12-40-109.5 4 B 2 4 D repealed 12-40-109.5 4 E 122751135 E 12-40-109.7 122751114 12-40-109.7 1 122751141 12-40-109.7 2 122751142 1240111 repealed 124011312751115 1240113 112751151 1240113 B 122751152 1240113 F 122751153 1240114 1240113 1240114 1240115 1240116 1240117 1240119 1240117 1240117 1240117 1240172 1240173 1240173 1240118 1240175 120 1240119 1 1240175 1 1240118 1 1240118 1 B 1240175 1 B 1240118 C 1240175 1 C 1240118 1 D 1240175 1 D 1240118 E 1240175 1 E 1240118 H 1240175 1 F 1240118 I 1240175 1 G 1240118 J 1240175 1 H 1240118 K 1240175 1 I 1240118 L 1240175 1 J 1240118 1 M 1240175 1 K 1240118 M I 12475 1 K I 1240118 1 M I 12475 1 K I 1240118 1 M I 12475 1 K I 1240118 1 N 12475 1 L 1240118 1 O 12475 1 M 1240118 1 P 12475 1 N 1240118 1 Q 12475 1 O 1240118 1 R 12475 1 P 1240118 1 S 12475 1 Q 1240118 1 T 12475 1 R 1240118 1 U 12475 1 S minus 1970 1172 Regarding proposed statute no 1240118 1 B 12475 1 T 1240118 1 W 12475 1 U 1240118 1 Y 12475 1 V 1240118 1 A I 12475 1 W I 1240118 1 A I 12475 1 W I 1240118 1 BB 12475 1 X 1240118 1 DD 12475 1 ID 1 Y 1240118 1 DD I 12475 1 Y I 1240118 1 DD I 12475 1 Y I 1240118 1 DD I 12475 1 Y I 1240118 1 E 12475 1 Z 1240118 1 FF 12475 1 A 1240118 1 GG 12475 1 BB 1240118 1 HH 12475 1 ID 1 GC 2 1 GC II 1240118 1 II 12475 1 DD 1240118 1 JJ 12475 1 E 1240118 1 KK 12475 1 FF 1240118 1 LL 12475 1 GG 1240118 1 millimeters 12475 1 HH 12-40-118.5 12475 121 12-40-118.5 1 12475 121 12-40-118.5 2 12475 121 12-40-118.5 3 12475 121 3 12-40-118.5 4 12475 121 4 12-40-118.5 IB 5 12475 121 IB 5 12-40-118.5 5 I 12475 121 5 I 12-40-118.5 5 I 12475 121 5 I 12-40-118.5 5 B I 5 B I 12475 121 5 B 12-40-118.5 5 C 5 D repealed 12-40-118.5 5 E 12475 121 5 C 1240119 125 122 1240119 B 1 12475 129 B 1 1240119 1 I 12475 122 1 I 1240119 1 I 12475 122 1 I 1240119 NII 1275122 1 NII 1240119 1B 1275122 1B 1240119 C 1275122 1C 1240119 1D 1275122 1D 1240119 2D repealed 1240119 2E 1275122 1240119 FI 1275122 3 1240119 F repealed 1240119 2.1 1275122 4 1240119 2.3 2.5 repealed 1240119 3B 1275122 5 1240119 4 1275122 6 1240119 4B 1275122 6B 1240119 5 1275122 7 1240119 6 repealed 1240119 7 to 1 1275122 8 1240120 to 121 1275123 1240120 275 123 1 1240129B 1 1275123 IB 2 1240121 1 1275123 2 1240121 1B 1275123 2B Got it proposed. Statute no. Statute no. 1240121 1 C 1275123 2 C 1240122 275 124 1240123 275 125 1240123 1 12751 125 1 1240123 2 12751 125 2 1240124 275 126 1240125 275 127 1240125 IB 1 12475 127 IB 1 1240125 1 12475 127 1 1240125 1 B 12475 127 1 B 1240125 1 C 12475 127 1 C 1240125 1 D 12475 127 1 D 1240125 1 E 12475 127 1 E 1240125 1 F 12475 127 1 F 1240125 IB 1 G 12475 127 IB 1 G 1240125 1 G I 12475 127 1 G I 1240125 1 G I 12475 127 1 G I 1240125 1 G I 12475 127 1 G I 1240125 1 G I 12475 127 1 G I 1240125 3 12475 127 2 1240125 4 12475 127 3 1240125 5 12475 127 4 1240125 6 12475 127 5 1240125 IB 7 12475 127 IB 6 1240125 7 12475 127 6 1240125 7 B 12475 127 6 B 1240125 7 C 12475 127 6 C 1240125 7 D 12475 127 6 D 1240125 7 E 12475 127 6 E 1240125 7 F 12475 127 6 F 1240126 12475 128 1240126 IB 1 12475 128 IB 1 1240126 1 12475 128 1 1240126 1 B 12475 128 1 B 1240126 1 C 12475 128 1 C 1240126 1 D 12475 128 1 D 1240126 2 12475 128 2 1240126 2 B 12475 128 2 B 1240126 3 12475 128 3 1240126 4 12475 128 4 1240127 12275 129 1240128 12275 130 1240128 1 12275 130 1240128 2 repealed 12-40.5-101 12270 101 12-40.5-102 12270 102 12-40.5-102 1 12270 102 1 12-40.5-102 1 12270 102 1 12-40.5-102 1 B 12270 102 1 B 12-40.5-102 1 C 12270 102 1 C 12-40.5-102 1 C I 12270 102 1 C I 12-40.5-102 1 C I 12270 102 1 C I 12-40.5-102 2 12270 102 2 12-40.5-103 IP 12270 104 IP 12-40.5-103 1 12270 104 1 minus 1971 1172 Got it proposed. Statute no. Statute no. 12-40.5-103 2 12270 104 2 12-40.5-103 3 2 5 repealed 12-40.5-103 6 12270 104 3 12-40.5-103 6.5 repealed 12-40.5-103 7 12270 104 4 12-40.5-103 8 12270 104 5 12-40.5-103 IP 9 12270 104 IP 6 12-40.5-103 IP 9 12270 104 IP 6 12-40.5-103 9 I 12270 104 6 I 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 12-40.5-103 9 V 12270 104 6 V 12-40.5-103 IP 9 B 12270 104 IP 6 B 12-40.5-103 9 B I 12270 104 6 B I 12-40.5-103 9 BII 12270-1046 BII 12-40.5-103 9 BII 12270-1046 BII 12-40.5-103 9 BI 12270-1046 BI 12-40.5-103 IP 9 C 12270-104 IP 6 C 12-40.5-103 9 CI 12270-104 6 CI 12-40.5-103 9 CII 12270-104 CII 12-40.5-103 9 CII 12270-104 CII 12-40.5-103 9 CI 12270-104 CI 12-40.5-103 9 CV 12270-104 CV 12-40.5-103 9 CV 12270-104 CV 12-40.5-103 9 CVI 12270-104 CVI 12-40.5-103 9 C8 12270-104 C8 12-40.5-103 9 CX 12270-104 CX 12-40.5-103 9 CX 12270-104 CX 12-40.5-103 9 C side 12270-104 C side
What did you just
12-40.5-103 9 C side 12270-104 C side 12-40.5-103 9 C side 12270-104 C side 12-40.5-103 9 C 12270-104 C 12-40.5-103 10 12270-104 7 12-40.5-103 12 12270-104 8 12-40.5-103 13 12270-104 9 12-40.5-104 12270-105 12-40.5-104 1 12270-105 1 12-40.5-104 2 12270-105 2 12-40.5-105 12270-106 12-40.5-105 2 12270-106 1 12-40.5-105 IP 2 B 12270-106 IP 1 B 12-40.5-105 2 B I 12270-106 1 B I 12-40.5-105 2 B I 12270-106 1 B I 12-40.5-105 2 B I 12270-106 1 B I 12-40.5-105 2 C 12270-106 1 C 12-40.5-105 3 12270-106 2 12-40.5-106 12270-107 12-40.5-106 IP 1 12270-107 IP 1 12-40.5-106 1 12270-107 1 12-40.5-106 1 B 12270-107 1 B 12-40.5-106 2 12270-107 2 12-40.5-106 2 12270-107 2 12-40.5-106 2 B 12270-107 2 B 12-40.5-106 3 12270-107 3 Got it proposed. Statute no. Statute no. 12-40.5-106 4 12270-107 4 12-40.5-106 5 12270-107 5 12-40.5-106 5 12270-107 5
let you know
12-40.5-106 5 B 12270-107 5 B 12-40.5-106 5 C 12270-107 5 C 12-40.5-106 5 D 12270-107 5 D 12-40.5-106 6 12270-107 6 12-40.5-106 6 6 B 12270-107 6 12-40.5-106 7 repealed 12-40.5-106.5 12270-108 12-40.5-106.5 IB 1 12270-109 B 1 12-40.5-106.5 1 12270-108 1 12-40.5-106.5 1 B 12270-108 1 B 12-40.5-106.5 IB 2 12270-109 B 2 12-40.5-106.5 2 12270-108 2 12-40.5-106.5 2 B 12270-108 2 B 12-40.5-106.5 3 12270-108 3 12-40.5-106.5 4 12270-108 4 12-40.5-106.5 5 12270-108 5 12-40.5-106.5 5 12270-108 5 12-40.5-106.5 5 B 12270-108 5 B 12-40.5-106.5 5 C 12270-108 5 C 12-40.5-106.5 5 D 12270-108 5 D 12-40.5-106.5 6 12270-108 6 12-40.5-106.5 6 repeal 12-40.5-106.5 6 B 12270-108 6 12-40.5-106.5 7 repeal 12-40.5-107 12270-109 12-40.5-107 1 12270-109 1 12-40.5-107 2 12270-109 2 12-40.5-107 2 12270-109 2 12-40.5-107 2 B 12270-109 2 B 12-40.5-107 2 C 12270-109 2 C 12-40.5-107, 3, 12270-109, 3, 12-40.5-108, 12270-110, 12-40.5-189B, 1, 12270-110IB, 1, 12-40.5-108, 1, 12270-110, 1, 12-40.5-108, 1B, 12270-110, 1B, 12-40.5-108, 1C, 12270-110, 1C, 12-40.5-108, 1D, 12270-110, 1D, 12-40.5-109, 12270-111, 12-40.5-109.3, 12270-112, 12-40.5-109.3, 1, 12270-112, 1, 12-40.5-109.3 IB, 1B, 12270-112 IB, 1B, 12-40.5-109.3, 1BI, 12270-112, 1BI, 12-40.5-109.3, 1BII, 12270-112, 1BII, 12-40.5-109.3, 1BII, 12270-112, 1BII, 12-40.5-109.3 IB, 2, 12270-112 IB, 2, 12-40.5-109.3, 2, 12270-112, 2, 12-40.5-109.3, 2B, 12270-112, 2B, 12-40.5-109.3, 3, 12270-112, 3, 12-40.5-109.3, 3B, 12270-112, 3B, 12-40.5-109.3 IB, 4, 12270-112 IB, 4, 12-40.5-109.3, 4, 12270-112, 4, 12-40.5-109.3, 4B, 12270-112, 4B, minus 1972, 1172. Current proposed. Statute no. Statute no. 12-40.5-109.3, 5, 12270-112, 5. 12-40.5-109.5, 12270-113. 12-40.5-109.5 IB, 1, 12270-113 IB, 1. 12-40.5-109.5, 1, 12270-113, 1. 12-40.5-109.5, 1B, 12270-113, 1B. 12-40.5-109.5, 1C, 12270-113, 1C. 12-40.5-109.5, 2, 12270-113, 2. 12-40.5-109.5, 3, 12270-113, 3. 12-40.5-109.5, 4, 12270-113, 4. 12-40.5-109.5, 5, 12270-113, 5. 12-40.5-110, 12270-114. 12-40.5-110, 1, 12270-114, 1. 12-40.5-110 IB, 2, 12270-114 IB, 2. 12-40.5-110 IB, 2, 12270-114 IB, 2. 12-40.5-110, 2, I, 12270-114, 2, I. 12-40.5-110, 2, I, 12270-114, 2, I. 12-40.5-110, 2, B, 12270-114, 2, B. 12-40.5-110, 2, C, 12270-114, 2, C. 12-40.5-110, 2, D, I, 12270-114, 2, D, I. 12-40.5-110, 2, D, I, 12270-114, 2, D, I. 12-40.5-110, 2, D, I, 12270-114, 2, D, I. 12-40.5-110, 2, E, 12270-114, 2, E. 12-40.5-110, 2, F, 12270-114, 2, F. 12-40.5-110, 2, G, 12270-114, 2, G. 12-40.5-110, 2, H, 12270-114, 2, H. 12-40.5-110, 2, I, 12270-114, 2, I. 12-40.5-110, 2, J, 12270-114, 2, J. 12-40.5-110 IB, 2, K, 12270-114 IB, 2, K. 12-40.5-110, 2, K, I, 12270-114, 2, K, I. 12-40.5-110, 2, K, I, 12270-114, 2, K, I. 12-40.5-110, 2, K, I, 12270-114, 2, K, I. 12-40.5-110, 2, L, 12270-114, 2, L. 12-40.5-110, 2, M, 12270-114, 2, M. 12-40.5-110, 3, 12270-114, 3. 12-40.5-110, 4, 12270-114, 4. 12-40.5-110, 4, B, 12270-114, 4, B. 12-40.5-110, 5, 12270-114, 5. 12-40.5-110, 6, 12270-114, 6. 12-40.5-110, 6, B, 12270-114, 6, B. 12-40.5-110, 6, C, 12270-114, 6, C. 12-40.5-110, 7, 12270-114, 7. 12-40.5-110, 7, B, I, 12270-114, 8. 12-40.5-110, 7, B, I, 1220403, 1. 12-40.5-110, 7, B, I, 1220403, 2. 12-40.5-110, 7, B, I, December 2403 IB, 2, B, I, 2, 2, B, I. 12-40.5-110, 7, C, 1220403, 3. 12-40.5-110, 7, B, I, 2, 8, repealed. 12-40.5-110, 9, 12270-114, 9. 12-40.5-110, 10, 12270-114, 10. 12-40.5-110, 11, repealed. 12-40.5-110, 12 to 16, 12270-114, 11. 12-40.5-110, 17, 12270-114, 12. 12-40.5-110, 17, B, 17, C, repealed. 12-40.5-110, 18, 12270, 114, 13. 12-40.5-110, 19, repealed. Regarding proposed. Statute no. Statute no. 12-40.5-111, 12270, 115. 12-40.5-112, 12270, 116. 12-40.5-113, repealed. 12-40.5-114, 12270, 117. 12-40.5-114, 1, 12270, 117, 12-40.5-114, 2, 12270, 117, 2. 12-40.5-114, 3, 12270, 117, 3. 12-40.5-114, 4, 12270, 117, 4. 12-40.5-114.5, 12270, 118. 12-40.5-114.5, 1 to 4, 12270, 118. 12-40.5-114.7, 12270, 119. 12-40.5-114.7, 1, 12270, 119, 1. 12-40.5-114.72, 12270, 119, 2. 12-40.5-115, 12270, 120. 1241, 101, 12, 285, 101, 1241, 102, 12, 285, 102. 1241, 1029B, 1, 12285, 1029B, 1, 1241, 102, 1, 12285, 102, 1. 1241, 102, 1B, 12285, 102, 1B. 1241, 102, 1C, 12285, 102, 1C. 1241, 103IB, 12285, 104IB. 1241, 103, 1, 12285, 104, 1. 1241, 103IB, 1.3, 12285, 104IB, 2. 1241, 103, 1.3, 12285, 104, 2. 1241, 103, 1.3B, 12285, 104, 2B. 1241, 103, 1.3 C, 12285, 104, 2 C. 1241, 103, 1.3 D, 12285, 104, 2 D. 1241, 103, 1.3 E, 12285, 104, 2 E. 1241, 103, 1.3 F, 12285, 104, 2 F. 1241, 103, 1.5, 12285, 104, 3. 1241, 103, 2, 3, repealed. 1241, 103, 5, 12285, 104, 4. 1241, 103, 5.5, 12285, 104, 5. 1241, 103, 6 I, 12285, 104, 6 I. 1241, 103 IB, 6 I, 12285, 104 IB, 6 I. 1241, 103, 6 I, A, 12285, 104, 6 I, A. 1241, 103, 6 I, B, 12285, 104, 6 I, B. 1241, 103, 6 I, C, 12285, 104, 6 I, C. 1241, 103, 6 I, D, 12285, 104, 6 I, D. 1241, 103, 6 I, E, 12285, 104, 6 I, E. 1241, 103, 6 I, F, 12285, 104, 6 I, F. 1241, 103 IB, 6 B, 12285, 104 IB, 6 B. 1241, 103, 6 B, I, 12285, 104, 6 B, I. 1241, 103, 6 B, I, A, 12285, 104, 6 B, I, A. 1241, 103, 6 B, I, B, 12285, 104, 6 B, I, B. 1241, 103, 6 B, I, 12285, 104, 6 B, I. 1241, 103, 7, 12285, 104, 7. 12-41-103.3, 12285, 105. 12-41-103.3, 1, 12285, 105, 1. 12-41-103.3, 1B, repealed. 12-41-103.3, 1C, 12285, 105, 1B. 12-41-103.3 IB, 2, 12285, 105 IB, 2. 12-41-103.3, 2, 12285, 105, 2. 12-41-103.3, 2, B, 12285, 105, 2, B. 12-41-103.3, 3, 12285, 105, 3. Minus 1973, 1172. Regarding proposed. Statute no. Statute no. 12-41-103.6, 12285, 106. 12-41-103.6, 1, 12285, 106, 1. 12-41-103.6 IB, 2, 12285, 106 IB, 2. 12-41-103.6, 2, 12285, 106, 2. 12-41-103.6 IB, 2, B, 12285, 106 IB, 2, B. 12-41-103.6, 2, B, I, 12285, 106, 2, B, I. 12-41-103.6, 2, B, I, 12285, 106, 2, B, I. 12-41-103.6, 2, C, I, 12285, 106, 2, C. 12-41-103.6, 2, C, I, repealed. 12-41-103.6, 2, D, 12285, 106, 2, D. 12-41-103.6, 2, E, 12285, 106, 2, E. 12-41-103.6 IB, 2, F, 12285, 106 IB, 2, F. 12-41-103.6, 2, F, I, 12285, 106, 2, F, I. 12-41-103.6, 2, F, I, 12285, 106, 2, F, I. 12-41-103.6, 2, F, I, 12285, 106, 2, F, I. 12-41-103.6, 2, F, I, 12285, 106, 2, F, I. 12-41-103.6, 2, F, B, 12285, 106, 2, F, V. 12-41, 104, 12285, 107. 12-41, 105, 12285, 108. 12-41, 105 IB, 1, 12285, 108 IB, 1. 12-41, 105, 1, 12285, 108, 1. 12-41, 105, 1, B, 12285, 108, 1, B. 12-41, 105, 2, 12285, 108, 2. 12-41, 106, 12285, 109. 124110711285 12411079p 1 12385110ip 1 12411079p 1 12385110ip 1 12411071i 1 12385110i 1 12411071i 1 12385110i 1 12411079p 1b 1 12385110ip 1b 1 12411071bi 1 12385110 1bi 1 12411071bii 1 12385110 1 12411071c 1 12385110 c 1 12411071d 1 12385110 d 1 12411072 1 12385110 1 12411073 1 12385110 12-41-107.5 1 12385111 12-41-107.5 ip 1 12385111 ip 1 12-41-107.5 1 12385111 12-41-107.5 1b 1 12385111 1b 12-41-107.5 2 1 12385111 2 12-41-107.5 3 1 12385111 3 1 241-109 1 285 1 2 1 241-109 1 1 285 1 1 1 209 1 1 285 1 1 2 1 1 241-109 1b 1 285 1 1 2 1b 1 241-109 1c 1 285 1 1 2 1c 1 241-109 2 1 285 1 1 2 2 1 241-109 3 1 285 1 1 2 3 1 241-109 3 1 285 1 1 2 3 1 241-109 3 b 1 285 1 1 2 3 b 1 241-109 b 3 c 1 285 1 1 2 b 3 c 2 3 c I 1 241-109 3 c I 1 285 1 1 2 3 c I 3 c I 1 241-109 5 1 285 1 1 2 4 1 241-111 1 2 285 1 1 3 Carried proposed. Statute no. Statute no. 1 241-111 ip 1 1 285 1 1 3 ip 1 1 241-111 1 1 285 1 1 3 1 1 241-111 1 b 1 285 1 1 3 1 b 1 241-111 1 c 1 285 1 1 3 1 c 1 241-111 1 d 1 285 1 1 3 1 d 1 241-111 1 e 1 285 1 1 3 1 e 1 241-111 2 1 285 1 1 3 2 1 241-111 3 1 285 1 1 3 3 1 241-112 1 285 1 1 4 12-41-112.5 1 285 1 1 5 1 241-113 1 285 1 1 6 1 241-113 1 1 285 1 1 6 1 1 241-113 2 1 285 1 1 6 2 1 241-113 3 1 285 1 1 6 3 1 241-113 4 1 285 1 1 6 4 1 241-113 4 1 285 1 1 6 4 1 241-113 4 b 1 285 1 1 6 4 b 1 241-113 ip 5 1 285 1 1 6 ip 5 1 241-113 5 1 285 1 1 6 5 1 241-113 5 I 1 285 1 1 6 5 I 1 241-113 5 I 1 285 1 1 6 5 I 1 241-113 5 I 1 285 1 1 6 5 I 1 241-113 5 b 1 285 1 1 6 5 b 1 241-113 5 c 1 285 1 1 6 5 c 1 241-114 1 285 1 1 7 1 241-114 ip 1 1 285 1 1 7 ip 1 1 241-114 1 1 285 1 1 7 1 1 241-114 1 c 1 285 1 1 7 1 b 1 241-114 1 d 1 285 1 1 7 1 c 1 241-114 1 e 1 285 1 1 7 1 d 1 241-114 1 f 1 285 1 1 7 1 e 1 241-114 1 g 1 285 1 1 7 1 f 1 241-114 1 h 1 285 1 1 7 1 g 1 241-114 1 I 1 285 1 1 7 1 h 12-41-114.5 1 285 1 18 12-41-114.5 1 1 285 1 18 1 12-41-114.5 2 1 285 1 18 2 12-41-114.5 3 1 285 1 18 3 12-41-114.6 1 285 119 12-41-114.6 1 1 285 119 1 12-41-114.6 ip 1 b 1 285 119 ip 1 b 12-41-114.6 1 b I 1 285 119 1 b I 12-41-114.6 1 b I 1 285 119 1 b I 12-41-114.6 1 b I 1 285 119 1 b I 12-41-114.6 ip 1 c 1 285 119 ip 1 c 12-41-114.6 1 c I 1 285 119 1 c I 12-41-114.6 1 c I 1 285 119 1 c I 12-41-114.6 1 c I 1 285 119 1 c I 12-41-114.6 1 d I 1 285 119 1 d I 12-41-114.6 1 d I 1 285 119 1 d I 12-41-114.6 1 e 1 285 119 1 e 12-41-114.6 2 1 285 119 2 12-41-114.6 3 1 285 119 3 1 241 115 1 285 120 1 241 115 ip 1 1 285 120 ip 1 minus 1974 1172 Carried proposed. Statute no. Statute no. 1 241 115 1 1 285 120 1 1 241 115 1 b 1 285 120 ip 1 b 2 1 b I 1 1241151 C 12385 120 C 1241151 D 12385 120 D 1241151 E 12385 120 E 1241151 F 12385 120 F 1241151 G 12385 120 G 1241151 H I 12385 120 H I 1241151 H I 12385 120 H I 1241151 I 12385 120 I 1241151 J 12385 120 J 1241151 K 12385 101 K 1241151 L 12385 101 L 1241151 M I 12385 101 M I 1241151 M I 12385 101 M I 1241151 M I 12385 101 M I 1241151 N 12385 101 N 1241151 O 12385 101 O 1241151 P 12385 101 P 1241151 Q 12385 101 Q 1241151 R 12385 101 R 1241151 S 12385 101 S 1241151 T 12385 101 T 1241151 U 12385 101 U 1241151 B 12385 101 V 1241151 W 12385 101 W 1241151 X 12385 101 X 1241151 ID 1 Y 12385 120 ID 1 Y 1241151 Y I 12385 101 Y I 1241151 Y I 12385 101 Y I 1241151 Z 12385 101 Z 12-41-115.5 12385 121 12-41-115.5 ID 1 12385 121 ID 1 12-41-115.5 1 12385 121 1 12-41-115.5 1 B 12385 121 1 B 12-41-115.5 1 C 12385 121 1 C 12-41-115.5 2 12385 121 2 12-41-115.5 3 12385 121 3 12-41-115.5 4 12385 121 4 1241161 235 122 1241161 12385 122 1 1241161 C 12385 122 1 B 1241162 12385 122 2 1241162 B 2 C repealed 1241116 ID 3 12385 122 ID 3 1241163 12385 122 3 1241163 B 12385 122 3 B 1241163 C 12385 122 3 C 1241163 D 12385 122 3 D 1241163.5 12385 122 4 1241164 12385 122 5 1241165 repealed 1241166 12385 122 6 1241171 12385 123 1241171 12385 123 1 Got it proposed. Statute no. Statute no. 1241172 12385 123 2 1241173 12385 123 3 1241173 B 12385 123 3 B 1241175 repealed 1241176 12385 123 4 1241177 repealed 1241178 12385 123 5 1241179 12385 123 6 1241110 repealed 1241111 to 15 12385 123 7 1241118 12385 124 1241118 1 12385 124 1 1241118 2 12385 124 2 1241118 3 12385 124 3 1241118 4 12385 124 4 12-41-118.5 12385 125 12-41-118.5 1 to 3 12385 125 1241119 12385 126 1241199 ID 1 12385 126 ID 1 1241119 1 12385 126 1 1241119 1 B 12385 126 1 B 1241119 1 C 12385 126 1 C 1241119 2 12385 126 2 1241119 3 12385 126 3 1241120 12385 127 1241120 1 12385 127 1 1241120 1 B 12385 127 1 B 1241120 2 12385 127 2 1241121 12385 128 1241121 2 12385 128 1241122 12385 129 1241122 1 to 3 12385 129 1241123 1 130 130 12412 135 131 12412 ID 1 12385 131 ID 1 12412 1 12385 131 1 12412 1 B 12385 131 1 B 12412 1 C 12385 131 1 C 12412 1 D I 12385 131 1 D I 12412 1 D I 12385 131 1 D I 12412 1 E 12385 131 1 E 12412 1 F 12385 131 1 F 12412 ID 1 G 12385 131 ID 1 G 12412 1 G I 12385 131 1 G I 12412 1 G I 12385 131 1 G I 12412 1 G I 12385 131 1 G I 1241 124 ID 1G5 12385 131 ID 1G5 1241 124 1G5A 12385 131 1G5A 1241 124 1G5B 12385 131 1G5B 1241 124 1GB 12385 131 1GB 1241 124 2 12385 131 2 1241 124 3 12385 131 3 1241 124 4 12385 131 4 1241 124 5 12385 131 5 1241 124 ID 5B 12385 131 ID 5B minus 1975 1172 Regarding proposed statute no 1241 124 5BI 12385 131 5BI 124 5BII 12385 131 5BII 124 5BII 12385 131 5BII 124 5BI 12385 131 5BI 124 5BV 12385 131 5BV 124 5C 12385 131 5C 124 5D 12385 131 5D 124 ID 6 12385 131 ID 6 124 6 12385 131 6 124 6 A5 repealed 124 6 B 12385 131 6 B 124 6 C 12385 131 6 C 124 6 D 12385 131 6 D 124 6 D3 repealed 124 6 D5 12385 131 6 E 124 6 E 12385 131 6 F 124 6 F 12385 131 6 G 124 127 12385 106 3 124 128 repealed 124 130 125 132 124 130 2 B 12385 132 124 201 285 201 124 201 ID 1 12385 201 ID 1 124 201 1 12385 201 1 124 201 1 B 12385 201 1 B 124 201 1 C 12385 201 1 C 124 201 1 D 1 E repealed 124 201 1 F 12385 201 1 D 124 201 2 repealed 124 201 3 12385 201 2 124 202 285 202 124 203 285 203 124 203 ID 1 12385 203 ID 1 124 203 1 12385 203 1 124 203 1 B 12385 203 1 B 124 203 2 12385 203 2 124 204 285 204 124 205 285 205 124 205 ID 1 12385 205 ID 1 124 205 1 I 12385 205 1 I 124 205 1 I 12385 205 1 I 124 205 ID 1 B 12385 205 ID 1 B 124 205 1 B I 12385 205 1 B I 124 205 1 B I 12385 205 1 B I 124 205 1 C 12385 205 1 C 124 205 1 D 12385 205 1 D 124 205 2 12385 205 2 124 205 3 12385 205 3 124 206 12385 206 124 206 ID 1 12385 206 ID 1 124 206 1 12385 206 1 124 206 1 B 12385 206 1 B 124 206 1 C 12385 206 1 C 124 206 2 12385 206 2 124 206 ID 3 12385 206 ID 3 Regarding proposed statute no 124 206 3 12385 206 3 124 206 3 B 12385 206 3 B 124 206 3 C 12385 206 3 C 124 206 4 12385 206 4 124 207 12385 207 124 207 ID 1 12385 207 ID 1 124 207 1 12385 207 1 124 207 1 B 12385 207 1 B 124 207 1 C 12385 207 1 C 124 207 1 D 12385 207 1 D 124 207 1 E 12385 207 1 E 124 207 2 12385 207 2 124 207 3 12385 207 3 124 208 12385 208 well dash 41 dash 208.5 12385 209 well dash 41 dash 208.5 1 12385 209 1 well dash 41 dash 208.5 ID 1 B 12385 209 ID 1 B well dash 41 dash 208.5 1 B I 12385 209 1 B I well dash 41 dash 208.5 1 B I 12385 209 1 B I well dash 41 dash 208.5 1 B I 12385 209 1 B I well dash 41 dash 208.5 ID 1 C 12385 209 ID 1 C well dash 41 dash 208.5 1 C I 12385 209 1 C I well dash 41 dash 208.5 1 C I 12385 209 1 C I well dash 41 dash 208.5 1 D I 12385 209 1 D I well dash 41 dash 208.5 1 D I 12385 209 1 D I well dash 41 dash 208.5 1 E 12385 209 1 E well dash 41 dash 208.5 2 12385 209 2 well dash 41 dash 208.5 3 12385 209 3 124 209 12385 210 1241209B 112852110IP 1241209 112852101 1241209 B 124252101B 1241209 C 124252101C 1241209 D 124252101D 1241209 E 124252101E 1241209 F 124252101F 1241210128521 1241210IP 1 124252111IP 1 1241210 124252111 1241201 B 124252111B 1241201 C 124252111C 1241201 D 124252111D 1241201 E I 124252111 EI 1241201 E I 124252111 EI 1241201 F 124252111 F 1241201 G 124252111 G 1241201 H 124252111 H 1241201 I 124252111 I 1241201 I 124252111 I 1241201 I 124252111 I 1241201 J 124252111 J 1241201 K 124252111 K 1241201 L 124252111 L 1241201 M 124252111 M 1241201 N 124252111 N minus 1976 1172 Guardian proposed statute no 1241201 O 124252111 O 1241201 P 124252111 P 1241201 Q 124252111 Q 1241201 R 124252111 R 1241211 1241211 124252121 B 124252121 B 1241212 124252122 1241212 B 2 C repealed 1241211 B 3 124252129 B 3 1241211 3 1242521 3 1241211 3 B 1242521 3 B 1241211 3 C 1242521 3 C 1241211 3 D 1242521 3 D 1241211 4 1242521 4 1241211 5 1242521 5 1241211 6 repealed 1241211 7 1242521 6 1241212 12412 3 1241212 1 1242521 3 1 1241212 2 1242521 2 1241213 3 1242521 3 1241213 B 1242521 3 B 1241212 4 repealed 1241212 5 1242521 4 1241212 6 repealed 1241212 7 1242521 5 1241212 8 1242521 6 1241212 9 repealed 1241212 10 1 1242521 7 1241212 4 1241213 1 1242521 1 1241213 2 1242521 2 1241213 3 1242521 3 1241213 4 1242521 4 1241214 1241225 1241214 1 to 3 1242521 1241215 1 6 1241215 1 12425 1 1241215 1 B 12425 1 B 1241215 2 12425 6 2 1241216 1 2 7 similar 1241216 2 0 407 1 B 1241217 2 8 2 8 1241217 1 to 3 12425 2 8 1241218 2 9 1241219 2 8 2 0 1 3 1241220 repealed 1241221 2 0 well dash 41.5 dash 101 12300 101 well dash 41.5 dash 102 12300 102 well dash 41.5 dash 103 IP 12300 104 IP well dash 41.5 dash 103 123 repealed well dash 41.5 dash 103 4 12300 104 1 well dash 41.5 dash 103 5 12300 104 2 Guardian proposed statute no well dash 41.5 dash 103 IP 6 12300 104 IP 3 well dash 41.5 dash 103 6 12300 104 3 well dash 41.5 dash 103 6 B 12300 104 3 B well dash 41.5 dash 103 6 C 12300 104 3 C well dash 41.5 dash 103 IP 6 D 12300 104 IP 3 D well dash 41.5 dash 103 6 D I 12300 104 3 D I well dash 41.5 dash 103 6 D I 12300 104 3 D I well dash 41.5 dash 103 6 E 12300 104 3 E well dash 41.5 dash 103 6 F 12300 104 3 F well dash 41.5 dash 104 12300 105 well dash 41.5 dash 105 12300 106 well dash 41.5 dash 106 12300 107 well dash 41.5 dash 106 1 12300 107 1 well dash 41.5 dash 106 IP 2 12300 107 IP 2 well dash 41.5 dash 106 2 12300 107 2 well dash 41.5 dash 106 2 B 12300 107 2 B 12-41.5-106-2, C 12-300-1072, C 12-41.5-107-12300-108, 12-41.5-107-1-12300-108-1, 12-41.5-107-2, 12300-108-2, 12-41.5-108 repealed, 12-41.5-109, 12300-109, 12-41.5-109, 1-12300-109, 12-41.5-109B2, 1-230-109B2, 12-41.5-109-2, 1-230-109-2, 12-41.5-109B2, BI, 1-230-109B2, BI, 12-41.5-109-2, BIA, 1-230-109-2, BIA, 12-41.5-109-2, BIB, 1-230-109-2, BIB, 12-41.5-109-2, BII, 1-230-109-2, BII, 12-41.5-109-2, C, 1-230-109-2, C, 12-41.5-109-2, D, 1-230-109-2, D, 12-41.5-109-2, E, 1-230-109-2, E, 12-41.5-109-2, F, 1-230-109-2, F, 12-41.5-109-2, G, 1-230-109-2, G, 12-41.5-109-2, H, 1-230-109-2, H, 12-41.5-109-2, I, 1-230-109-2, I, 12-41.5-109-2, I, 1-230-109-2, I, 12-41.5-109-2, I, 1-230-109-2, I, 12-41.5-109-2, J, 1-230-109-2, J, 12-41.5-109-2, J, I, 1-230-109-2, J, I, 12-41.5-109-2, J, I, 1-230-109-2, J, I, 12-41.5-109-2, K, 1-230-109-2, K, 12-41.5-109-2, K, I, 1-230-109-2, K, I, 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 12-41.5-109-2, L, 1-230-109-2, L, 12-41.5-109-2, M, 1-230-109-2, M, 12-41.5-109-2, N, 1-230-109-2, N, 12-41.5-109-2, O, 1-230-109-2, O, 12-41.5-109-2, P, 1-230-109-2, P, 12-41.5-109-2, Q, 1-230-109-2, Q, 12-41.5-109-2, R, 1-230-109-2, R, 12-41.5-109-2, S, 1-230-109-2, S, 12-41.5-109-B, 2.5, 1-230-109-B, 3, minus 1977, 1172. Carries proposed. Statute no. Statute no. 12-41.5-109, 2.5, 1-230-109, 3. 12-41.5-109, 2.5, B, 1-230-109, 3, B. 12-41.5-109, 3, 1-230-109, 4. 12-41.5-109, 4, 1-230-109, 5. 12-41.5-109, 5, 1-230-109, 6. 12-41.5-109, 5.5, 1-230-109, 7. 12-41.5-109, 5.5, B, I, 1-230-109, 7, B. 12-41.5-109, 5.5, B, I, 5.5, B, I, repealed. 12-41.5-109, 6, 1-230-109, 8. 12-41.5-109, 7, 1-230-109, 9. 12-41.5-109, 8, repealed. 12-41.5-109, 9, 1-230-109, 10. 12-41.5-109, 10, 1-230-109, 11. 12-41.5-109, 10, I, 1-230-109, 11, I. 12-41.5-109, 10, I, 1-230-109, 11, I. 12-41.5-109, 10, B, 1-230-109, 11, B. 12-41.5-109, 11, 1-230-109, 12. 12-41.5-109, 11, B, 11, C, repealed. 12-41.5-109, 11.5, 1-230-109, 13. 12-41.5-109, 12, repealed. 12-41.5-109, 13, to 17, 1-230-109, 14. 12-41.5-109, 18, repealed. 12-41.5-109.5, 1-230-110. 12-41.5-109.5, 1, 1-230-110, 1. 12-41.5-109.5 IB, 1B, 1-230-110 IB, 1B. 12-41.5-109.5, 1B, I, 1-230-110, 1B, I. 12-41.5-109.5 IB, 1B, I, 1-230-110 IB, 1B, I. 12-41.5-109.5, 1B, I, A, 1-230-110, 1B, I, A. 12-41.5-109.5, 1B, I, B, 1-230-110, 1B, I, B. 12-41.5-109.5, 1C, 1-230-110, 1C. 12-41.5-109.5, 2, 1-230-110, 2. 12-41.5-109.5, 3, 1-230-110, 3. 12-41.5-109.5, 4, 1-230-110, 4. 12-41.5-109.7 12300 12-41.5-109.7 123 12300 111 12-41.5-109.7 12300 112 12-41.5-110 12300 112 12-41.5-110 IB 2 12300 112 IB 1 12-41.5-110 2 I 12300 112 1 I 12-41.5-110 2 I 12300 112 1 I 12-41.5-110 2 I 12300 112 1 I 12-41.5-110 2 B 12300 112 1 B 12-41.5-110 2 C 12300 112 1 C 12-41.5-110 2 D 12300 112 1 D 12-41.5-110 2 E 12300 112 1 E 12-41.5-110 2 F 12300 112 1 F 12-41.5-110 2 G 12300 112 1 G 12-41.5-110 2 H 12300 112 1 H 12-41.5-110 IB 2 I 12300 112 IB 1 I 12-41.5-110 2 I 12300 112 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 1 I 12-41.5-110 2 I B 12300 112 1 I V 12-41.5-110 2 I B 12300 112 1 I V Regarding proposed statute no 12-41.5-110 2 I V I 12300 112 1 I V I 12-41.5-111 12300 113 12-41.5-112 12300 114 12-41.5-112 2 12300 114 12-41.5-113 12300 115 12-41.5-114 repealed 12-41.5-115 12300 116 12-41.5-115 12300 116 1ported 10112 295 101 1ported 102 ID 12 295 103 ID 1ported 102 1 295 103 1 1ported 102 2 295 103 2 1ported 102 3 295 103 3 1ported 102 4 295 103 4 1ported 103 1 295 104 1ported 103 1 295 104 1 1ported 103 2 2 B 295 104 2 1ported 104 1 295 105 1ported 104 1 295 105 1 1ported 104 2 295 105 2 1ported 104 3 295 105 3 1ported 105 1 295 106 1ported 105 IB 1 295 106 IB 1 1ported 105 1 295 106 1 1ported 105 1 B 295 106 1 B 1ported 105 1 C 295 106 1 C 1ported 106 1 295 107 1ported 106 1 295 107 1 1ported 106 2 295 107 2 1ported 107 1 295 107 3 1ported 109 1 295 108 1ported 110 repealed 1ported 111 1 295 109 1ported 111 1 295 109 1 1ported 111 IB 1 B 295 109 IB 1 B 1ported 111 1 B I 295 109 1 B I 1ported 111 1 B I 295 109 1 B I 1ported 111 1 B I 295 109 1 B I 1ported 111 1 B I 295 109 1 B I 1ported 111 2 295 109 2 1ported 111 3 295 109 3 1ported 111 4 295 109 4 1ported 112 295 110 1ported 112 1 295 110 1 1ported 112 3 295 110 2 1ported 113 295 111 1ported 113 IB 1 295 111 IB 1 1ported 113 1 295 111 1 1ported 113 1 B I 295 111 1 B I 1ported 113 1 B I A 295 111 1 B I 1ported 113 1 B I B 295 111 1 B I 1ported 113 1 C 295 111 1 C 1ported 113 1 D 295 111 1 D 1ported 113 1 E 295 111 1 E 1ported 113 1 F 295 111 1 F minus 1978 1172 regarding proposed statute no 1ported 113 1 G 295 111 1 G 1ported 113 1 H 295 111 1 H 1ported 113 1 I 295 111 1 I 1ported 113 1 J 295 111 1 J 1ported 113 1 K 295 111 1 K 1ported 113 1 L 295 111 1 L 1ported 113 1 M 295 111 1 M 1ported 113 1 N 295 111 1 N 1ported 113 1 O 295 111 1 O 1ported 113 1 P 295 111 1 P 1ported 113 1 Q 295 111 1 Q 1ported 114 295 112 1 2 4 2 1 1 4 1 1 2 2 9 5 1 1 2 1 1 2 4 2 1 1 4 2 1 2 2 9 5 1 1 2 2 1 2 4 2 1 1 4 3 1 2 2 9 5 1 1 2 3 1 2 4 2 1 1 4 4 1 2 2 9 5 1 1 2 4 1 2 4 2 1 1 4 5 1 2 2 9 5 1 1 2 5 1 2 4 2 1 1 4 6 1 2 2 9 5 1 1 2 6 12-42-115.3 1 2 2 9 5 1 1 3 12-42-115.5 1 2 2 9 5 1 1 4 12-42-115.5 1 1 2 2 9 5 1 1 4 1 12-42-115.5 2 1 2 2 9 5 1 1 4 2 12-42-115.7 1 2 2 9 5 1 1 5 12-42-115.7 1 1 2 2 9 5 1 1 5 1 12-42-115.7 2 1 2 2 9 5 1 1 5 2 12-42-115.7 3 1 2 2 9 5 1 1 5 3 12-42-115.7 4 1 2 2 9 5 1 1 5 4 12-42-115.9 1 2 2 9 5 1 1 6 1 2 4 2 1 1 6 1 2 2 9 5 1 1 7 1 2 4 2 1 1 6 1 1 2 2 9 5 1 1 7 1 1 2 4 2 1 1 6 IB 2 1 2 2 9 5 1 1 7 IB 2 2 1 2 4 2 1 1 6 3 1 2 2 9 5 1 1 7 2 B 2 C similar 1 2 4 2 1 1 6 3 B 1 2 2 9 5 1 1 7 2 D 1 2 4 2 1 1 6 3 C 1 2 2 9 5 1 1 7 2 E 1 2 4 2 1 1 7 1 2 2 9 5 1 1 7 3 1 2 4 2 1 1 8 119 1 2 2 9 5 1 1 8 1 2 4 2 1 1 8 1 2 2 9 5 1 1 8 1 1 2 4 2 1 1 9 2 1 2 2 9 5 1 1 8 2 1 2 4 2 1 2 0 1 2 2 9 5 1 1 9 IB 1 1 1 2 4 2 1 2 1 2 2 9 5 1 1 9 1 B 12-42.5 101 1 2 2 0 1 0 1 12-42.5 102 IB 1 2 3 0 1 0 3 IB 12-42.5 102 1 1 2 3 0 1 0 3 1 12-42.5 102 2 1 2 3 0 1 0 3 2 12-42.5 102 3 1 2 3 0 1 0 3 3 12-42.5 102 IB 3.5 1 2 3 0 1 0 3 IB 4 12-42.5 102 3.5 1 2 3 0 1 0 3 4 12-42.5 102 3.5 B 1 2 3 0 1 0 3 4 B 12-42.5 102 3.7 1 2 3 0 1 0 3 5 12-42.5 102 4 1 2 3 0 1 0 3 6 12-42.5 102 5 1 2 3 0 1 0 3 7 12-42.5 102 6 1 2 3 0 1 0 3 8 12-42.5 102 6.5 1 2 3 0 1 0 3 9 12-42.5 102 IB 7 1 2 3 0 1 0 3 IB 10 12-42.5 102 7 I 1 2 3 0 1 0 3 10 I Current proposed statute no 12-42.5 102 7 I 1 2 3 0 1 0 3 10 I 12-42.5 102 7 B 1 2 3 0 1 0 3 10 B 12-42.5 102 8 1 2 3 0 1 0 3 11 12-42.5 102 9 1 2 3 0 1 0 3 12 12-42.5 102 10 1 2 3 0 1 0 3 13 12-42.5 102 11 1 2 3 0 1 0 3 14 12-42.5 102 12 1 2 3 0 1 0 3 15 12-42.5 102 IB 13 1 2 3 0 1 0 3 IB 16 12-42.5 102 13 I 1 2 3 0 1 0 3 16 I 12-42.5 102 13 I 1 2 3 0 1 0 3 16 I 12-42.5 102 13 I 1 2 3 0 1 0 3 16 I 12-42.5 102 13 I 1 2 3 0 1 0 3 16 I 12-42.5 102 13 B 1 2 3 0 1 0 3 16 B 12-42.5 102 13.5 1 2 3 0 1 0 3 17 12-42.5 102 14 1 2 3 0 1 0 3 18 12-42.5 102 15 1 2 3 0 1 0 3 19 12-42.5 102 16 1 2 3 0 1 0 3 20 12-42.5 102 IB 16.5 1 2 3 0 1 0 3 IB 21 12-42.5 102 16.5 1 2 3 0 1 0 3 21 12-42.5 102 16.5 B 1 2 3 0 1 0 3 21 B 12-42.5 102 IB 17 1 2 3 0 1 0 3 IB 22 12-42.5 102 17 I 1 2 3 0 1 0 3 22 I 12-42.5 102 17 I 1 2 3 0 1 0 3 22 I 12-42.5 102 17 I 1 2 3 0 1 0 3 22 I 12-42.5 102 17 C 1 2 3 0 1 0 3 22 B 12-42.5 102 17 D 1 2 3 0 1 0 3 22 C 12-42.5 102 18 1 2 3 0 1 0 3 23 12-42.5 102 19 1 2 3 0 1 0 3 24 12-42.5 102 19.5 1 2 3 0 1 0 3 25 12-42.5 102 20 1 2 3 0 1 0 3 26 12-42.5 102 20.5 1 2 3 0 1 0 3 27 12-42.5 102 21 1 2 3 0 1 0 3 28 12-42.5 102 22 1 2 3 0 1 0 3 29 12-42.5 102 23 1 2 3 0 1 0 3 30 12-42.5 102 IB 24 1 2 3 0 1 0 3 IB 31 12-42.5 102 24 1 2 3 0 1 0 3 31 12-42.5 102 24 B 1 2 3 0 1 0 3 31 B 12-42.5 102 IB 25 1 2 3 0 1 0 3 IB 32 12-42.5 102 IB 25 1 2 3 0 1 0 3 IB 32 12-42.5 102 25 I 1 2 3 0 1 0 3 32 I Well, dash 42.5 dash 102 25 II 1230 103 32 II. Well, dash 42.5 dash 109 B 25 B 1230 103 IP 32 B. Well, dash 42.5 dash 102 25 B I 1230 103 32 B I. Well, dash 42.5 dash 102 25 B I 1230 103 32 B I. Well, dash 42.5 dash 102 25 C 1230 103 32 C. Well, dash 42.5 dash 102 26 1230 103 33. Well, dash 42.5 dash 102 27 1230 103 34. Well, dash 42.5 dash 102 28 1230 103 35. Well, dash 42.5 dash 102 29 1230 103 36. Well, dash 42.5 dash 102 29.5 1230 103 37. Well, dash 42.5 dash 102 30 1230 103 38. Well, dash 42.5 dash 109 B 31 1230 103 IP 39. Well, dash 42.5 dash 102 31 1230 103 39. Well, dash 42.5 dash 102 31 B I 1230 103 39 B I. Well, dash 42.5 dash 102 31 B I 1230 103 39 B I minus 1979 1172. Got it proposed. Statute no. Statute no. Well, dash 42.5 dash 102 31 B I 1230 103 39 B I. Well, dash 42.5 dash 109 B 31 C 1230 103 IP 39 C. Well, dash 42.5 dash 102 31 C I 1230 103 39 C I. Well, dash 42.5 dash 109 B 31 C I 1230 103 IP 39 C I. Well, dash 42.5 dash 102 31 C I A 1230 103 39 C I A. Well, dash 42.5 dash 102 31 C I B 1230 103 39 C I B. Well, dash 42.5 dash 102 31 C I C 1230 103 39 C I C. Well, dash 42.5 dash 102 32 1230 103 40. Well, dash 42.5 dash 102 33 1230 103 41. Well, dash 42.5 dash 109 B 34 1230 103 IP 42. Well, dash 42.5 dash 102 34 1230 103 42. Well, dash 42.5 dash 102 34 B 1230 103 42 B. Well, dash 42.5 dash 109 B 34 C 1230 103 IP 42 C. Well, dash 42.5 dash 102 34 C I 1230 103 42 C I. Well, dash 42.5 dash 102 34 C I 1230 103 42 C I. Well, dash 42.5 dash 102 35 1230 103 43. Well, dash 42.5 dash 102 36 1230 103 44. Well, dash 42.5 dash 102 36.3 1230 103 45. Well, dash 42.5 dash 102 36.5 1230 103 46. Well, dash 42.5 dash 102 37 1230 103 47. Well, dash 42.5 dash 102 38 1230 103 48. Well, dash 42.5 dash 102 39 1230 103 49. Well, dash 42.5 dash 109 B 39.5 1230 103 IP 50. Well, dash 42.5 dash 102 39.5 I 1230 103 50 I. Well, dash 42.5 dash 102 39.5 I 1230 103 50 I. Well, dash 42.5 dash 102 39.5 I 1230 103 50 I. Well, dash 42.5 dash 102 39.5 I 1230 103 50 I. Well, dash 42.5 dash 102 39.5 B 1230 103 50 B. Well, dash 42.5 dash 102 39.7 1230 103 51. Well, dash 42.5 dash 102 40 1230 103 52. Well, dash 42.5 dash 102 41 1230 103 53. Well, dash 42.5 dash 102 42 1230 103 54. Well, dash 42.5 dash 109 B 42 B 1230 103 IP 54 B. Well, dash 42.5 dash 102 42 B I 1230 103 54 B I. Well, dash 42.5 dash 102 42 B I 1230 103 54 B I. Well, dash 42.5 dash 102 42 B I 1230 103 54 B I. Well, dash 42.5 dash 102 42 B I 1230 103 54 B I. Well, dash 42.5 dash 102 42 B B 1230 103 54 B V. Well, dash 42.5 dash 102 42 B B 1230 103 54 B V. Well, dash 42.5 dash 102 42 B I 1230 103 54 B I. Well, dash 42.5 dash 102 42 B 8 1230 103 54 B 8. Well, dash 42.5 dash 109 B 42 B X 1230 103 IP 54 B X. Well, dash 42.5 dash 102 42 B X A 1230 103 54 B X A. Well, dash 42.5 dash 102 42 B X B 1230 103 54 B X B. Well, dash 42.5 dash 102 42 B X 1230 103 54 B X. Well, dash 42.5 dash 102 42 B X 1230 103 54 B X. Well, dash 42.5 dash 102 42 B X 1230 103 54 B X. Well, dash 42.5 dash 102 42 B X 1230 103 54 B X. Well, dash 42.5 dash 102 42 B X 1230 103 54 B X. Well, dash 42.5 dash 102 42 B X V 1230 103 54 B X V. Well, dash 42.5 dash 102 43 1230 103 55. Well, dash 42.5 dash 103 1230 104. Well, dash 42.5 dash 103 1230 104 1. Well, dash 42.5 dash 103 2 1230 104 2. Well, dash 42.5-103, 3, B, 12380, 104, 3. Regarding proposed. Statute no. Statute no. Well, dash 42.5-104, 12380, 105. Well, dash 42.5-104, 12380, 105, 1. Well, dash 42.5-104, 1B, 12380, 105, 1B. Well, dash 42.5-104 1C, 12380, 105 1C. Well, dash 42.5-104 1C, I, 12380, 105 1C, I. Well, dash 42.5-104 1C, I, A, 12380, 105 1C, I, A. Well, dash 42.5-104 1C, I, B, 12380, 105 1C, I, B. Well, dash 42.5-104 1C, I, 12380, 105 1C, I. Well, dash 42.5-104 1D, I, 12380, 105 1D, I. Well, dash 42.5-104 1D, I, 12380, 105 1D, I. Well, dash 42.5-104 1D, I, 12380, 105 1D, I. Well, dash 42.5-104 1E, 12380, 105 1E. Well, dash 42.5-104 1F, 12380, 105 1F. Well, dash 42.5-104 2, 12380, 105 2. Well, dash 42.5-104 3, 12380, 105 3. Well, dash 42.5-104 4, 12380, 105 4. Well, dash 42.5-104.5, 12380, 106. Well, dash 42.5-104.5 ID 19, 12380, 106 ID 19. Well, dash 42.5-104.5, 19A, 12380, 106 19A. Well, dash 42.5-104.5, 19B, 12380, 106 19B. Well, dash 42.5-104.5, 19C, 12380, 106 19C. Well, dash 42.5-104.5, 19I, 12380, 106 19I. Well, dash 42.5-104.5, 1B, 12380, 106 1B. Well, dash 42.5-104.5, 1C, I, 12380, 106 1C, I. Well, dash 42.5-104.5, 1C, I, 12380, 106 1C, I. Well, dash 42.5-104.5 ID 1C, I, 12380, 106 ID 1C, I. Well, dash 42.5-104.5, 1C, I, A, 12380, 106 1C, I, A. Well, dash 42.5-104.5, 1C, I, B, 12380, 106 1C, I, B. Well, dash 42.5-104.5, 1D, 12380, 106 1D. Well, dash 42.5-104.5 ID 2, 12380, 106 ID 2. Well, dash 42.5-104.5 ID 2, 9, 12380, 106 ID 2, 9. Well, dash 42.5-104.5 2, 9A, 12380, 106 2, 9A. Well, dash 42.5-104.5 2, 9B, 12380, 106 2, 9B. Well, dash 42.5-104.5 2, 9C, 12380, 106 2, 9C. Well, dash 42.5-104.5 2, 9D, 12380, 106 2, 9D. Well, dash 42.5-104.5 2, 9, 12380, 106 2, 9. Well, dash 42.5-104.5 2, 9, 12380, 106 2, 9. Well, dash 42.5-104.5 2, B, 12380, 106 2, B. Well, dash 42.5-104.5 2, C, 12380, 106 2, C. Well, dash 42.5-104.5 3, 12380, 106 3. Well, dash 42.5-104.5 4, B, 12380, 106 4. Well, dash 42.5-105, 12380, 107. Well, dash 42.5-105, 1, 12380, 107 1. Well, dash 42.5-105 2, 12380, 107 2. Well, dash 42.5-106, 12380, 108. Well, dash 42.5-106 ID 1, 12380, 108 ID 1. Well, dash 42.5-106 1, 12380, 108 1. Well, dash 42.5-106 1, B, 12380, 108 1, B. Well, dash 42.5-106 1, C, 12380, 108 1, C. Well, dash 42.5-106 1, D, 12380, 108 1, D. Well, dash 42.5-106 1, E, 12380, 108 1, E. Well, dash 42.5-106 ID 1, F, 12380, 108 ID 1, F. Well, dash 42.5-106 1, F, I, 12380, 108 1, F, I. Well, dash 42.5-106 1, F, I, 12380, 108 1, F, I. Well, dash 42.5-106 1, F, I, 12380, 108 1, F, I. Minus 1980. 1172. Regarding proposed. Statute no. Statute no. Well, dash 42.5-106 1G, 12380, 108 1G. Well, dash 42.5-106 1H, 12380, 108 1H. Well, dash 42.5-106 1I, 2, 1I, 12380, 108 1I. Well, dash 42.5-106 1J, 12380, 108 1J. Well, dash 42.5-106 2, 12380, 108 2. Well, dash 42.5-106 ID 3, 12380, 108 ID 3. Well, dash 42.5-106 3, 12380, 108 3. Well, dash 42.5-106 ID 3, B, 12380, 108 ID 3, B. Well, dash 42.5-106 3, B, I, 12380, 108 3, B, I. Well, dash 42.5-106 3, B, I, 12380, 108 3, B, I. Well, dash 42.5-106 3, B, I, 12380, 108 3, B, I. Well, dash 42.5-106 3, B, I, 12380, 108 3, B, I. Well, dash 42.5-106 3, B, B, 12380, 108 3, B, B. Well, dash 42.5-106, 3B, 12380, 108, 3B, well, dash 42.5-106, 3B, VI, 12380, 108, 3B, VI. Well, dash 42.5-106, 3B, 8, 12380, 108, 3B, 8. Well, dash 42.5-106 ID, or I, 12380, 108 ID, or I. Well, dash 42.5-106, or I, A, 12380, 108, or I, A. Well, dash 42.5-106, or I, B, 12380, 108, or I, B. Well, dash 42.5-106, or I, C, 12380, 108, or I, C. Well, dash 42.5-106, or I, 12380, 108, or I. Well, dash 42.5-106, or B, 12380, 108, or B. Well, dash 42.5-106, or C, 12380, 108, or C. Well, dash 42.5-106, or D, I, 12380, 108, or D, I. Well, dash 42.5-106, or D, I, 12380, 108, or D, I. Well, dash 42.5-106, or E, 12380, 108, or E. Well, dash 42.5-107, 12380, 109. Well, dash 42.5-107 ID, 1, 12380, 109 ID, 1. Well, dash 42.5-107, 1, 12380, 109, 1. Well, dash 42.5-107, 1, B, 12380, 109, 1, B. Well, dash 42.5-107, 1, C, 12380, 109, 1, C. Well, dash 42.5-107 ID, 2, 12380, 109 ID, 2. Well, dash 42.5-107, 2, 12380, 109, 2. Well, dash 42.5-107, 2, B, 12380, 109, 2, B. Well, dash 42.5-108, 12380, 110. Well, dash 42.5-109, 12380, 111. Well, dash 42.5-109, 1, 12380, 111, 1. Well, dash 42.5-109, 2, 12380, 111, 2. Well, dash 42.5-109, 3, 12380, 111, 3. Well, dash 42.5-110, 12380, 112. Well, dash 42.5-110 ID, 1, 12380, 112 ID, 1. Well, dash 42.5-110, 1, 12380, 112, 1. Well, dash 42.5-110, 1, B, 12380, 112, 1, B. Well, dash 42.5-110, 1, C, 12380, 112, 1, C. Well, dash 42.5-110, 1, D, 12380, 112, 1, D. Well, dash 42.5-110, 1, E, 12380, 112, 1, E. Well, dash 42.5-110, 1, F, 12380, 112, 1, F. Well, dash 42.5-110, 1, G, 12380, 112, 1, G. Well, dash 42.5-110, 1, H, 12380, 112, 1, H. Well, dash 42.5-110, 1, I, 12380, 112, 1, I. Well, dash 42.5-110, 1, J, 12380, 112, 1, J. Well, dash 42.5-110, 1, K, 12380, 112, 1, K. Well, dash 42.5-110, 1, L, 12380, 112, 1, L. Well, dash 42.5-110, 1, M, 12380, 112, 1, M. Well, dash 42.5-110, 1, N, 12380, 112, 1, N. Got it proposed. Statute no. Statute no. Well, dash 42.5-110, 1, O, 12380, 112, 1, O. Well, dash 42.5-110, 1, P, 12380, 112, 1, P. Well, dash 42.5-110, 1, Q, 12380, 112, 1, Q. Well, dash 42.5-110, 2, 12380, 112, 2. Well, dash 42.5-111, 12380, 113. Well, dash 42.5-111, 1, 12380, 113, 1. Well, dash 42.5-111, 2, 12380, 113, 2. Well, dash 42.5-111, 3, 12380, 113, 3. Well, dash 42.5-112, 12380, 114. Well, dash 42.5-112, 1, 12380, 114, 1. Well, dash 42.5-112, 2, 12380, 114, 2. Well, dash 42.5-112 ID, 2, B, 12380, 114 ID, 2, B. Well, dash 42.5-112, 2, B, I, 12380, 114, 2, B, I. Well, dash 42.5-112, 2, B, I, 12380, 114, 2, B, I. Well, dash 42.5-112, 2, B, I, 12380, 114, 2, B, I. Well, dash 42.5-112, 2, B, I, 12380, 114, 2, B, I. Well, dash 42.5-112, 2, B, B, 12380, 114, 2, B, V. Well, dash 42.5-112, 2, B, B, 12380, 114, 2, B, V. Well, dash 42.5-112, 2, B, V, I, 12380, 114, 2, B, V, I. Well, dash 42.5-112, 3, 12380, 114, 3. Well, dash 42.5-112, or I, 12380, 114, or I. Well, dash 42.5-112, or I, 12380, 114, or I. Well, dash 42.5-112, or I, 12380, 114, or I. Well, dash 42.5-112, or B, 12380, 114, or B. Well, dash 42.5-112, 5, 12380, 114, 5. Well, dash 42.5-112, 6, 12380, 114, 6. Well, dash 42.5-112, 7, 12380, 114, 7. Well, dash 42.5-112, 8, 12380, 114, 8. Well, dash 42.5-112, 9, 12380, 114, 9. Well, dash 42.5-112, 10, repealed. Well, dash 42.5-112, 11, 12380, 114, 10. Well, dash 42.5-113, 12380, 115. Well, dash 42.5-113, 1, 12380, 115, 1. Well, dash 42.5-113 ID, 2, 12380, 115 ID, 2. Well, dash 42.5-113, 2, 12380, 115, 2. 12-42.5-113-2, B12380-1152, B. 12-42.5-113-2, C, 12380-1152, C. 12-42.5-113-3, 12380-115, 12-42.5-113-4, 12380-115, 12-42.5-114, 12380-116, 12-42.5-114, 1, 12380-116, 1, 12-42.5-114, 2, 12380-116, 2, 12-42.5-114, 3, 12380-116, 3, 12-42.5-115, 12380-117, 12-42.5-115, 1, 12380-117, 1, 12-42.5-115, 2, 12380-117, 2, 12-42.5-115, 2, B, 12380-117, 2, B. 12-42.5-115, 3, 12380-117, 3, 12-42.5-115, 4, 12380-117, 4, 12-42.5-115, 5, 12380-117, 5, 12-42.5-115, 6, 12380-117, 6, 12-42.5-115, ID, 7, 12380-117, ID, 7, 12-42.5-115, 7, 12380-117, 7, 12-42.5-115, 7, B, 12380-117, 7, B. 12-42.5-115, 7, C, 12380-117, 7, C. Minus 1981, 1172. Carry proposed. Statute no. Statute no. 12-42.5-115, 8, 12380-117, 8. 12-42.5-115, 9, 12380-117, 9. 12-42.5-115, 10, 12380-117, 10. 12-42.5-116, 12380-118. 12-42.5-116, 1, 12380-118, 1. 12-42.5-116, 1, B, 12380-118, 1, B. 12-42.5-116, 1, B, I, 12380-118, 1, B, I. 12-42.5-116, 1, B, I, 12380-118, 1, B, I. 12-42.5-116, 1, B, I, A, 12380-118, 1, B, I, A. 12-42.5-116, 1, B, I, B, 12380-118, 1, B, I, B. 12-42.5-116, 1, C, 12380-118, 1, C. 12-42.5-116, 2, 12380-118, 2. 12-42.5-116, 3, 12380-118, 3. 12-42.5-116, 3, B, 12380-118, 3, B. 12-42.5-116, 4, 12380-118, 4. 12-42.5-116, 5, 12380-118, 5. 12-42.5-117, 12380-119. 12-42.5-117, 1, 12380-119, 1. 12-42.5-117, 1, 12380-119, 1. 12-42.5-117, 1, B, 12380-119, 1, B. 12-42.5-117, 1, C, 12380-119, 1, C. 12-42.5-117, 1, D, 12380-119, 1, D. 12-42.5-117, 2, 12380-119, 2. 12-42.5-117, 3, 12380-119, 3. 12-42.5-117, 4, 12380-119, 4. 12-42.5-117, 5, 12380-119, 5. 12-42.5-117, 6, 12380-119, 6. 12-42.5-117, 7, 12380-119, 7. 12-42.5-117, 8, 12380-119, 8. 12-42.5-117, 9, 12380-119, 9. 12-42.5-117, 9, B, 12380-119, 9, B. 12-42.5-117, 9, B, I, 12380-119, 9, B, I. 12-42.5-117, 9, B, I, 12380-119, 9, B, I. 12-42.5-117, 9, C, 12380-119, 9, C. 12-42.5-117, 9, B, 10, 12380-119, 9, B, 10. 12-42.5-117, 10, I, 12380-119, 10, I. 12-42.5-117, 10, I, 12380-119, 10, I. 12-42.5-117, 10, B, 12380-119, 10, B. 12-42.5-117, 11, 12380-119, 11. 12-42.5-117, 12, 12380-119, 12. 12-42.5-117, 12, B, 12380-119, 12, B. 12-42.5-117, 12, C, 12380-119, 12, C. 12-42.5-117, 12, D, 12380-119, 12, D. 12-42.5-117, 13, 12380-119, 13. 12-42.5-117, 14, 12380-119, 14. 12-42.5-118, 12380-120. 12-42.5-118, 1, 12380-120, 1. 12-42.5-118, ID, 2, 12380-120, ID, 2. 12-42.5-118, 2, 12380-120, 2. 12-42.5-118, 2, B, 12380-120, 2, B. 12-42.5-118, 2, C, 12380-120, 2, C. 12-42.5-118, 2, D, 12380-120, 2, D. 12-42.5-118, 2, E, 12380-120, 2, E. 12-42.5-118, ID, 3, 12380-120, ID, 3. 12-42.5-118, 3, I, 12380-120, 3, I. Carry proposed. Statute no. Statute no. 12-42.5-118, 3, I, 12380-120, 3, I. Well, dash 42.5-118, 3, NII, 1230, 120, 3, NII. Well, dash 42.5-118, 3, NII, 1230, 120, 3, NII. Well, dash 42.5-118, 3, V, 1230, 120, 3, V. Well, dash 42.5-118, 3, V, 1230, 120, 3, V. Well, dash 42.5-118, 4, 1230, 120, 4. Well, dash 42.5-118, IV, 5, 1230, 120, IV, 5. Well, dash 42.5-118, 5, I, 1230, 120, 5, I. Well, dash 42.5-118, 5, I, 1230, 120, 5, I. Well, dash 42.5-118, IV, 5, I, 1230, 120, IV, 5, I. Well, dash 42.5-118, 5, I, A, 1230, 120, 5, I, A. Well, dash 42.5-118, 5, I, B, 1230, 120, 5, I, B. Well, dash 42.5-118, 5, I, C, 1230, 120, 5, I, C. Well, dash 42.5-118, 5, I, D, 1230, 120, 5, I, D. Well, dash 42.5-118, IV, 5, B, 1230, 120, IV, 5, B. Well, dash 42.5-118, 5, B, I, 1230, 120, 5, B, I. Well, dash 42.5-118, 5, B, I, 1230, 120, 5, B, I. Well, dash 42.5-118, 5, B, I, 1230, 120, 5, B, I. Well, dash 42.5-118, 5, C, 1230, 120, 5, C. Well, dash 42.5-118, 6, 1230, 120, 6. Well, dash 42.5-118, 6, B, I, 1230, 120, 6, B, I. Well, dash 42.5-118, 6, B, I, A, 1230, 120, 6, B, I, A. Well, dash 42.5-118, 6, B, I, B, 1230, 120, 6, B, I, B. Well, dash 42.5-118, 6, C, 1230, 120, 6, C. Well, dash 42.5-118, 7, 1230, 120, 7. Well, dash 42.5-118, 8, 1230, 120, 8. Well, dash 42.5-118, 9, 1230, 120, 9. Well, dash 42.5-118, 10, 1230, 120, 10. Well, dash 42.5-118, 11, 1230, 120, 11. Well, dash 42.5-118, 12, 1230, 120, 12. Well, dash 42.5-118, 13, 1230, 120, 13. Well, dash 42.5-118, 14, 1230, 120, 14. Well, dash 42.5-118, 15, 1230, 120, 15. Well, dash 42.5-118, IV, 15, B, 1230, 120, IV, 15, B. Well, dash 42.5-118, 15, B, I, 1230, 120, 15, B, I. Well, dash 42.5-118, 15, B, I, 1230, 120, 15, B, I. Well, dash 42.5-118, 15, B, I, 1230, 120, 15, B, I. Well, dash 42.5-118, 15, C, I, 1230, 120, 15, C, I. Well, dash 42.5-118, 15, C, I, 1230, 120, 15, C, I. Well, dash 42.5-118, 16, 1230, 120, 16. Well, dash 42.5-118, IV, 17, 1230, 120, IV, 17. Well, dash 42.5-118, 17, I, 1230, 120, 17, I. Well, dash 42.5-118, 17, I, 1230, 120, 17, I. Well, dash 42.5-118, 17, B, 1230, 120, 17, B. Well, dash 42.5-118, 18, 1230, 120, 18. Well, dash 42.5-118.5, 1230, 121. Well, dash 42.5-118.5, 1, 1230, 121, 1. Well, dash 42.5-118.5, IB, 2, 1230, 121, IB, 2. Well, dash 42.5-118.5, 2, I, 1230, 121, 2, I. Well, dash 42.5-118.5, 2, I, 1230, 121, 2, I. Well, dash 42.5-118.5, 2, B, 1230, 121, 2, B. Well, dash 42.5-118.5, 3, 1230, 121, 3. Well, dash 42.5-118.5, 4, 1230, 121, 4. Well, dash 42.5-118.5, IB, 5, 1230, 121, IB, 5. Well, dash 42.5-118.5, 5, 1230, 121, 5. Minus 1982, 1172. Guarding proposed. Statute no. Statute no. Well, dash 42.5-118.5 IB, 5, B, 1230, 121 IB, 5, B. Well, dash 42.5-118.5, 5, B, I, 1230, 121, 5, B, I. Well, dash 42.5-118.5, 5, B, I, 1230, 121, 5, B, I. Well, dash 42.5-118.5, 5, B, I, 1230, 121, 5, B, I. Well, dash 42.5-118.5 IB, 5, D, I, 1230, 121 IB, 5, C, I. Well, dash 42.5-118.5, 5, D, I, A, 1230, 121, 5, C, I, A. Well, dash 42.5-118.5, 5, D, I, B, 1230, 121, 5, C, I, B. Well, dash 42.5-118.5, 5, D, I, 1230, 121, 5, C, I. Well, dash 42.5-118.5, 6, 1230, 121, 6. Well, dash 42.5-119, 1230, 122. Well, dash 42.5-119, 1, 1230, 122, 1. Well, dash 42.5-119, 2, 1230, 122, 2. Well, dash 42.5-119, 3, 1230, 122, 3. Well, dash 42.5-120, 1230, 123. Well, dash 42.5-120, 1, 1230, 123, 1. 12-42.5-122, 1230, 123, 2. 12-42.5-123, 2, 3, E, 1230, 123, 3, similar. 12-42.5-120 IB, 3, DI, December 30th, 110 IB, 1B. 12-42.5-123, DIA, 1230, 110, 1BI. 12-42.5-123, DIB, 1230, 110, 1BII. 12-42.5-123, DIC, 1230, 110, 1BII. 12-42.5-123, DII, 1230, 110, 2B. 12-42.5-123, DII, 1230, 110, 4B. 12-42.5-121, 1230, 124. 12-42.5-121 ID, 1, 1230, 124 ID, 1. 12-42.5-121, 1, 1230, 124, 1. 12-42.5-121, 1, BI, 1230, 124, 1, BI. 12-42.5-121, 1, BII, 1230, 124, 1, BII. 12-42.5-121, 2, 1230, 124, 2. 12-42.5-122, 1230, 125. 12-42.5-122, 1, 1230, 125, 1. 12-42.5-122 ID, 1, BI, 1230, 125 ID, 1, BI. 12-42.5-122, 1, BIA, 1230, 125, 1, BIA. 12-42.5-122, 1, BIB, 1230, 125, 1, BIB. 12-42.5-122 ID, 1, BII, 1230, 125 ID, 1, BII. 12-42.5-122, 1, BIIA, 1230, 125, 1, BIIA. 12-42.5-122, 1, BIIB, 1230, 125, 1, BIIB. 12-42.5-122, 1, BII, 1230, 125, 1, BII. 12-42.5-122, 1, BI, 1230, 125, 1, BI. 12-42.5-122 ID, 2, 1230, 125 ID, 2. 12-42.5-122, 2, I, 1230, 125, 2, I. 12-42.5-122, 2, I, 1230, 125, 2, I. 12-42.5-122, 2, I, 1230, 125, 2, I. 12-42.5-122, 2, B, 1230, 125, 2, B. 12-42.5-122, 3, 1230, 125, 3. 12-42.5-122, 3, B, 1230, 125, 3, B. 12-42.5-122, 4, 1230, 125, 4. 12-42.5-122, 5, 1230, 125, 5. 12-42.5-122, 6, 1230, 125, 6. 12-42.5-123, 130, 126. 12-42.5-123 ID, 1, 1230, 126 ID, 1. 12-42.5-123, 1, 1230, 126, 1. 12-42.5-123, 1, B, 1230, 126, 1, B. 12-42.5-123 ID, 1, C, 1230, 126 ID, 1, C. 12-42.5-123, 1, C, I, 1230, 126, 1, C, I. Carried proposed. Statute no. Statute no. 12-42.5-123, 1, C, I, 1230, 126, 1, C, I. 12-42.5-123, 1, C, I, 1230, 126, 1, C, I. 12-42.5-123, 1, D, 1230, 126, 1, D. 12-42.5-123, 1, E, 1230, 126, 1, E. 12-42.5-123, 1, F, 1230, 126, 1, F. 12-42.5-123, 1, G, 1230, 126, 1, G. 12-42.5-123, 1, H, 1230, 126, 1, H. 12-42.5-123, 1, I, 1230, 126, 1, I. 12-42.5-123, 1, J, 1230, 126, 1, J. 12-42.5-123, 1, K, 1230, 126, 1, K. 12-42.5-123, 1, L, 1230, 126, 1, L. 12-42.5-123, 1, M, 1230, 126, 1, M. 12-42.5-123, 1, N, 1230, 126, 1, N. 12-42.5-123, 1, O, 1230, 126, 1, O. 12-42.5-123, 1, P, 1230, 126, 1, P. 12-42.5-123, 1, Q, 1230, 126, 1, Q. 12-42.5-123, 1, R, I, 1230, 126, 1, R, I. 12-42.5-123, 1, R, I, 1230, 126, 1, R, I. 12-42.5-123, 1, R, I, 1230, 126, 1, R, I. 12-42.5-123, 1, S, 1230, 126, 1, S. 12-42.5-123, 2, 1230, 126, 2. 12-42.5-124, 130, 127. 12-42.5-124, 1, 130, 127, 1. 12-42.5-124, 1, B, 130, 127, 1, B. 12-42.5-124, 2, 130, 127, 2. 12-42.5-124 ID, 2, B, 130, 127 ID, 2, B. 12-42.5-124, 2, B, I, 2, B, I, repealed. 12-42.5-124, 2, B, I, 130, 127, 2, B, I. 12-42.5-124, 2, B, I, repealed. 12-42.5-124, 2, B, B, 130, 127, 2, B, I. 12-42.5-124, 2, B, B, 130, 127, 2, B, I. 12-42.5-124, 2, C, 130, 127, 2, C. 12-42.5-124, 2, D, 130, 127, 2, D. 12-42.5-124 2 E 12380 2 E 12-42.5-124 IB 3 12380 IB 3 12-42.5-124 3 12380 3 12-42.5-124 3 B 12380 3 B 12-42.5-124 3 C 12380 3 C 12-42.5-124 3 D 12380 3 D 12-42.5-124 4 12380 4 12-42.5-124 5 I 12380 5 12-42.5-124 5 I 12380 5 B 12-42.5-124 5 I A 12380 5 C I 12-42.5-124 5 I B 12380 5 C I 12-42.5-124 5 B repealed 12-42.5-124 6 12380 6 12-42.5-124 6 B 6 C repealed 12-42.5-124 7 12380 7 12-42.5-124 7 B 12380 7 B 12-42.5-124 8 repealed 12-42.5-124 9 to 13 12380 8 12-42.5-125 December 20th 408 12-42.5-125 12380 12-42.5-125 December 20th 409 1 12-42.5-126 12380 129 minus 1983 1172 Current proposed Statute no 12-42.5-126 ID 1 12380 129 ID 1 12-42.5-126 1 12380 129 1 12-42.5-126 1 B 12380 129 1 B 12-42.5-126 1 C 12380 129 1 C 12-42.5-126 1 D 12380 129 1 D 12-42.5-126 1 E 12380 129 1 E 12-42.5-126 1 F 12380 129 1 F 12-42.5-126 1 G 12380 129 1 G 12-42.5-126 1 H 12380 129 1 H 12-42.5-126 1 I 12380 129 1 I 12-42.5-126 1 J 12380 129 1 J 12-42.5-126 1 K 12380 129 1 K 12
Active ingredient for drop.
Uh-oh. Active ingredient, sugar. Stopped, guys.
Uh-oh.
I don't think we were done.
Hey, Morgan. Morgan. Call Matt.
Oh, I don't know his password.
I like buttercup.
I think we were somewhere around 1984.
We actually should be pinpointed it right at 1983 when I started that page. So. Senator, you read about. We actually pinpointed it on that page. So. I'll just go to 1982 just to start it. And like despite that, like
Technical difficulties?
Yeah.
He doesn't like the numbers.
When? The artist that was bad. The artist that was just not the best.
do you think we were done?
We're not. Multiple read, or we're just trying to get one that's working? This is going really slow. This is easy too.
Proposed. Statute no. Statute no. 1261805 1CV 1210405 1CV 1261805 C guy 1210405 C guy 1261805 D 1210405 D. Statute no. 1261805 E 1210405 E 1261805 E 2 245 1261805 2 125 2 B 1261805 2 B 1261805 2 C 1261805 2 C 1261805 2 D 1261805 2 D 125 2 E 1261805 2 1 D 1261805 3 1261805 55.5 1061805 4 B 1261805 3 B 1261805 4 1261805 4 9 1261805 5 1261805 5 2 1261805 6 1261805 6 145 1261806 7 165 5 6 106 1 146 1 1261807 7 1 145 1 1 107 1 3 5 110 1 2 7 479 55.5 1 2 1 2 well, B 7 B 7 B 1 C. 709. C, 110, 1B, 516, 709, 1C, 58, 116, 104B, 1F, 709B, 188, 116, 104, 1F, I, 709, 1D, I, 1F, I, 709, 1D, I, 161, 1F, I, 709, 3, I, 131, 1G, 709, 1B, 709, 1F, 1 I, 709, 1G, 709, 1J, 709, 1H, C, 161, 1K, 709, 1I, C, 1 L, C, 709, 1J, 709, 2, C, 709, 2, 1C, 709, 1D, 161, 1D, 1 $160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160,160, B, 125, 105, 1 B, proposed 161, 105, 1 C, 115, 105, 1 C, 105, 1 D, 105, 1 C, 161, 105, 1 E, 105, 105, 1 E, 105, 2, 105, 2, 105, 2, 105, 3, 105, 105, 3, 105, 2, 106, 106, 106, 106, 106, 106, 1 106, 1 207, 106, 1 B, 106, 1 B, 106, 1 C, 106, 1 C, 107, 106, 1 D, 106, 1 D, 106, 1 E, 106, 1 E, 2, 106, 1 F, 106, 1 F, 106, 1 G, 106, 1 G, 106, 106, 107, 2, 106, 2, 106, 2, 106, 2, 9, 108, 7, no, 106, 2, 9, 106, 2, 9, 106, 2, 9, 106, 2, 9, 106, 2, D, 106, 2, B, 106, 8, 3, 106, 8, 106, 3, 106, 3, 2, B, 106, 8, 3, C, 106, 3, 3, 106, 3, D, I, 106, 3, B, I, 106, 3, B, I, 106, 3, B, I, 108, 106, 3, B, I, 106, 3, B, I, 106, 3, B, I, 106, 3, B, I, 106, 3, C, 106, 3, C, 106, 3, D, 106, 3, D, 106, 1 J Ashley 4, 110.5, 1 7 0 6 1 6 1 8 Ashley 4 J P. No. 2 4 3 4 0 3 2 1 2 2 0 2 1 0 2 1 0 3 2 Q. No. 1 2 4 3 4 0 3 2 1 R. 1 2 2 4 5 4 0 1 2 2 9 5 1 0 2 2 3 4 0 3 2 S. 1 2 2 4 5 1 0 3 2 S. 1 2 2 9 5 1 1 9. No. 1 2 2 5 0 1 0 2. No. 1 2 3 0 0 1 0 3. No. 1 2 2 5 5 1 0 3. No. 1 2 3 0 5 1 0 3. No. 1 2 2 6 0 1 0 2. No. 1 2 3 1 0 1 0 1. No. 1 2 2 6 5 1 0 2. No. 1 2 3 1 5 1 0 3. No. 1 2 2 7 0 1 0 3. Minus 2023 1172.
Can I move the bill?
Are we going to do these signed bills that we got at some point today?
Seriously, can I move the bill? That's what I would have thought.
Can I move the bill? Can you ask if there's any further discussion? And then we can just move the bill.
They have to be called a cow.
No.
All right. Call ourselves back to order. Any further discussion?
To the bill, Senator Fenberg.
Thank you, Mr. Chair. I move House Bill 1172 lay over until Wednesday, March 13th, 2019.
The motion is to lay over Bill HB 1172 to Wednesday, March 13th. All those in favor say aye. Aye. Opposed? No? No. The ayes have it. House Bill 1172 will lay over until Wednesday, March 13th. Senator Fenberg.
Thank you, Mr. Chair. I move to lay over the balance of the calendar on general order, second reading of bills.
Do we have to do the lay over the bill again?
Oh, sorry, until tomorrow, Tuesday, March 12th, 2019.
Roll call.
A roll call has been requested. Oh, no.
I don't think we can do that in the cow.
Can I? A division has been requested. All those in the chamber not entitled to vote, please be seated.
We just have to go super slow because we don't have.
Come here. Right there.
You know Andrew upstairs on the third floor? Well, come to us. He wants to say that. Yeah, he's gonna email. Okay. Thank you.
The motion is to lay over all those in favor, please stand. The motion is to lay over the balance on the calendar. Those in favor, please stand. Please be seated. All those opposed, please stand. The motion to lay over the balance on the calendar is adopted. Senator Fenberg.
Thank you, Mr. Chair. I move the committee rise and report.
The motion before the committee is to rise and report. All those in favor say aye. Those opposed, no. The ayes have it. The committee will rise and report. Where am I at here?
The Senate will come to order. Senator Rodriguez.
Thank you, Mr. President. The committee has met and had a number of bills under consideration. Will the clerk please read the report?
Mr. President, your committee of the whole basically reports that on consideration of the following test bills being seconded thereof makes the following recommendation. One, Senate Bill 182, House Bill 1113, later until 3/12/19, retain their place on the calendar. House Bill 1172, later until 3/13, retaining its place on the calendar.
Senator Rodriguez.
Thank you, Mr. Chair. Thank you, Mr. President. I move the report.
The motion is for the adoption of the committee whole report. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, the committee whole report is adopted. Senate Bill 182, House Bill 1113, laid over until 3/12/2019 and retaining their place on the calendar. House Bill 1172, laid over until 3/13/2019 and retaining its place on the calendar. Mr. Majority Leader.
Thank you, Mr. President. I move to lay over the balance of the calendar. until Wednesday, March 13th, 2019.
You've heard the motion. All those in favor say aye. All those opposed, no. The ayes have it, and the motion is adopted. The balance of the calendar will be laid over until Wednesday, March 13th. Introduction of bills.
Senate Bill 193 by Senators Janal Lee and concerning the continuation of the Colorado Medical Practice Act and in connection therewith, continuing the Colorado Medical Board examining the 60-day limit on the pro bono license, repealing requirement that a letter of admonition be sent to a licensee by certified mail and updating language and making technical amendments.
Judiciary.
Senate Bill 194 by Senators Garcia and Zinzinger and Representative Froelich and Van Winkle concerning the addition of Colorado State University Global Campus as a designated institution of higher education for tuition assistance for members of the National Guard.
State Veterans and Military Affairs.
House Bill 1178 by Representative McLaughlin and Senator Donovan concerning the name simplification of Western State Colorado University to Western Colorado University.
Education.
House Bill 1191 by Representative Arndt and Senator Donovan concerning the ability of a farm stand to be operated on a principal use site of any sized land area regardless of whether the site has been zoned by a local government for agricultural operations.
Agriculture and Natural Resources.
House Bill 1198 by Representative Valdez A. and Valdez D. and Senators Bridges and Priola concerning the powers and duties of the Electric Vehicle Grant Fund.
Transportation and Energy.
House Bill 1200 by Representative Arndt and Senators Bridges and Quorum concerning the point of compliance related to the treatment process involved in treating reclaimed domestic wastewater for indoor non-potable use within a building where the general public can access plumbing fixtures that are used to deliver the reclaimed domestic wastewater.
Local Government. Signing of bills.
The President has signed Senate Bill 1929. The President has signed Senate Resolution 4. The President has signed House Bills 1034, 1047, 1063, 1077, 1084, 1100, and 1175.
Delivery to the Governor.
To the Governor for signature on Friday, March 8, 2019 at 5:50 p.m. Senate Bill 4457 and 69.
Announcements. Mr. Minority Leader.
Thank you, Mr. President. Request a moment of personal privilege.
Granted.
Thank you, Mr. President. Members, today we visited the state constitution. Article 5, Section 22 makes it clear that every bill shall be read by title when introduced and at length on 2 different days in each house, provided, however, any reading at length may be dispensed with upon unanimous consent of the members present. Mr. President, if we go to the rules of the Senate, Senate Rule 11, reading of bills, unless a member shall request the reading of a bill in full when the bill is being considered by the Committee of the Whole on third and final reading, it shall be read by title only, and the unanimous consent of the members present to dispense with the reading of the bill in full shall be presumed. Mr. President, if we turn to Senate Rule 40, parliamentary authority, you, sir, are the presiding officer, and the parliamentarian of this chamber is the Secretary of the Senate. If we get to Rule 40, parentheses C, any matter not covered by the Senate rules or by Mason's Rule of Legislative Procedure shall be governed by the decision of the President, subject to the right of appeal by any member as provided for in these rules. If we turn to Mason's Rule, Section 720, bills must be read on 3 separate days. Ancient and parliamentary practice and most state constitutions require that bills be read 3 separate times on 3 separate days in each house of a legislature before final passage. 2, the requirement that each bill be read on 3 separate days prescribed by the Constitution, legislative rules, or statutes is one of the many restrictions imposed upon the passage of bills to prevent hasty and ill-considered legislation, surprise, or fraud, and to inform the legislators and the public of the contents of the bill. 3, a substantial compliance with the constitutional requirement as to the reading of bills is generally sufficient, although it has been held that the requirement of reading of the bill on different days is mandatory. Mandatory requirements must be complied with. Mr. President, thank you for this time. I appreciate the opportunity to present my letter of protest under Senate Rule. I appreciate our conversation earlier today that I understand in your opinion that having 5 computers reading House Bill 1172 at a pace that was beyond human comprehension for one computer, let alone 5 computers, in my opinion, Mr. President, does not satisfy the state constitution. Thank you, Mr. President.
Senator Gardner.
Thank you, Mr. President. I request personal privilege.
Granted.
Thank you, Mr. President. Members, much earlier today, during second reading, I came with my co-sponsor of House Bill 1172, the senator from Greeley, my friend the sheriff, and moved that bill on second reading. The senator from Greeley exercised his right, constitutional right as a legislator, to request that that bill be read at length. As the minority leader has read to you, the Colorado Constitution, not a rule of this body, not a custom of this body, not a matter of convenience of this body, the Colorado Constitution says at Article 5, Section 22, every bill shall be read by title when introduced and at length on 2 different days in each house. Provided, however, reading at length may be dispensed with upon unanimous consent of the members present. You know, the interesting thing about Article 5, Section 22 is that it presumes reading at length and only dispensing with it by unanimous consent. Now, as a matter of custom, we presume unanimous consent unless a member requests it. Now, it may seem a trivial matter, it may seem a burdensome matter, it may seem a matter that is easily dispensed with. But again, as the minority leader noted, our Senate Rule 40 refers us to Mason's Manual of Legislative Procedure, which notes that it is the rule unless it conflicts with our Constitution or our own rules. And it talks about this constitutional requirement for reading of a bill. It is not simply to be a burden. It is not simply to be a go through the motions kind of a thing. With a bill 2,000 pages long, which is not in our filing cabinet, in a session in which there has already been much haste, the purpose of reading bills at length is to prevent hasty and ill-considered legislation, surprise or fraud, and to inform the legislators and the public of the contents of the bill. To inform legislators and the public of the contents of the bill. Now, how do you do that? By a reading at length. And what is required of the leadership of this body? Substantial compliance with the Constitution. Substantial compliance is a legal standard that speaks of meeting the intent or purpose of the particular provision. The intent or purpose. And the intent or purpose is to prevent surprise or fraud, hasty or ill-considered legislation, inform the legislators and the public. Mr. President, 5 computer software programs and speakers at 625 or 50 words a minute is not substantial compliance. I protest in the strongest possible terms, Mr. President, Mr. Majority Leader, and to the majority, that is not compliance with the Constitution of the state of Colorado, and I call on you to comply with the Constitution of the state of Colorado. Thank you, Mr. President.
Having no other announcements. Senator Gonzalez.
Thank you, Mr. President. The House bill in question.
Senator Gonzalez, would you request a moment of personal privilege, please?
Thank you, Mr. President. I request a moment of personal privilege.
Granted.
The House bill in question was not hasty or ill-considered because it did pass our Judiciary Committee unanimously through consent. It also did pass our Appropriations Committee unanimously through consent. Thank you.
Having no other announcements, Mr. Majority Leader.
Thank you, Mr. President. I move the Senate adjourn until tomorrow at March 12th, 2019 at 9 a.m.
You have heard the motion. All those in favor say aye. All those opposed, no. The ayes have it, and the Senate will stand in adjournment until tomorrow.